Good morning, and thank you all for joining us for today's 2021 Annual Insurance Law Update. This, of course, is being presented by the Washington Defense Trial Lawyers. You are seeing me, Maggie Sweeney. I'm the Executive Director of WDTL, and Jason, who is our long-standing, is that a correct word, Jason? We figured 7 years, chair of this program. So, Jason, we thank you so much for chairing this and being with us. I want to thank everybody for your patience for waiting. As you know, this is our first time doing this seminar virtually, and we were working through a few kinks. We're still working through a few kinks. So we, one of our presenters is sort of lost in virtual land, and we're going to try to get her going, and we just did. So Galina is now a panelist, and we're ready to begin. I want to thank all of you who are joining us today and giving this virtual webinar a whirl. We are, for those of you who remember last year, this seminar was on February 28th, so a mere 2 weeks before we entered into quarantine for the pandemic. And you know, during this time, we have been offering, WDTL has been doing our best to offer you a lot of really quality programming online, and this seminar is just a continuation of that commitment to make sure that we are we're taking care of our members. I also want to say that we have some great core sponsors that we are also trying to take care of. And so I want to thank our core sponsors, and let me pull up our slide, screen sharing. There we go. Here you go. So our core sponsors, we thank them for bearing with us this year. We are pleased that we are continuing the tradition at our insurance law update of offering prize drawings, and that'll be it's quite a clever presentation that's been put together for our break and prize drawing. So now that we are all set, I'm going to turn it over to Jason to begin the program and kick things off with our introductions of our first presenters. Thank you.
Thanks, Maggie. Thank you all for attending today. I am Jason Vaca. My role will be to introduce our speakers as the day goes on. And we have a really, I think, a really good lineup. We've got a lot of very experienced, very competent coverage attorneys primarily, and also trial attorneys, and some interesting topics today. So although these speakers are all certainly worthy of much longer introductions, I will try to keep them relatively brief today. Our first topic this morning is the insurance case law update. We have a 3-person panel. Our first panelist is Pam DeVet. Pam is a shareholder at Lee Smart, whose practice includes all aspects of insurance law. She also represents attorneys and other professionals in malpractice and disciplinary actions, and defends individuals and businesses in a variety of other types of claims. This is her 6th year authoring the case update for WDTL. Our second panelist is Nicole Morrow. Nicole is an associate attorney with Lee Smart. Her practice, of course, is also focused on insurance matters, including coverage, bad faith, and claims. And she also represents attorneys as well in legal malpractice claims and defends individuals and businesses in all sorts of litigations and appeals. This is Nicole's 2nd year authoring the case summaries for the WDTL annual update. And last but not least, our third panelist is Galina Jakobson. I apologize. Galina is of counsel at Forsberg and Umlauf, where her practice focuses primarily on insurance coverage. She also represents insurers in complex coverage disputes and litigation, bad faith, and IFCA litigation. She has been a member of the WDTL group for several years, and this is her 1st year authoring and authorizing case summaries for the annual insurance law update. So with that, I'll turn it over to our panel.
Good morning and welcome to the first all virtual WDTL insurance law update. Jason, can you let me know if I'm audible?
Yes, everything looks fine.
Okay, great. And as Maggie said, the last time we did this was February 28th, 2020, back when everything most of us knew about pandemics was from theory or from history or from Hollywood. A lot's changed since then, but one thing that hasn't changed is that we have some exciting things to talk about, where exciting is a term of art in insurance law. I'm joined today by Nicole and Galina, and you should have our voluminous written materials by now. As in the past, the summarized case decisions are arranged chronologically under the court that issued the decision in the case. During our presentation this morning, we'll refer to the numbering in the written materials, and that may help you decide what to look at more closely later. We're going to speed through this in the rough chronology of an insurance action and give you some quick points that caught our attention as we were working through the cases. So first, we'll talk about notice. And what we're going to do is just kind of go from one to the next presenter on each of these topics. So we'll see how well this works. The notice requirement by insurance policies to give the insurer notice of the claim, as well as the notice required by the Insurance Fair Claims Act, Fair Conduct Act, IFCA, under RCW 48.30.015 sub 8. So in the U.S. District Court case number 38, Nickford versus State Farm, we had an insured who wanted to bring an IFCA claim. And this, you need to send a 20-day notice before you file to give the insurer an opportunity to cure the problem. Here, the policyholder sent the notice to the wrong State Farm entity, but the correct entity got the notice. It was at the same address and it responded to it. And so then the insured sent a second notice to the correct entity, but then filed the action fewer than 20 days after that notice, more than 20 days after the first notice. So what the insurance company did was assert an affirmative defense of lack of notice, and then the insured moved to strike that. And Judge Layton in this case said that the first notice provided actual notice, and that was sufficient. And so he struck the affirmative defense in that case. Nicole?
Hi, good morning, everyone. Happy Friday. For the notice section, I thought that 3 cases that I looked at were worth talking about. The first one is Coreen versus American Guarantee and Liability Insurance. That's a Western District of Washington case. The decision was by Judge Kuhnauer. And the facts in that case are that the plaintiff is a lawyer who brought claims against her malpractice insurer for alleged breaches under her lawyer's professional liability policy. The insurer had received some kind of notice from a complainant who said that the lawyer was submitting fraudulent bills for legal services not provided. The insurer reported that to the bar, and the Washington State Bar started a grievance against the attorney. Ultimately, that grievance was dismissed, and the attorney looked back to the insurer to recoup her attorney's fees and costs that that she had to expend to defend that matter. And the insurer gave some money, but was unwilling to give the entire demand. The policy obligated the insurer to defend plaintiff against any claim based on any act or omission in plaintiff's rendering or failing to render legal services for others seeking damages that are covered under the policy. Claim was defined as a demand for money or legal services. Ultimately, the insurer was ethically bound to report the suspected fraudulent activities by attorneys, and so it did so. And the plaintiff never actually tendered the defense of her grievance to the insurer. I think that the important part about this, plaintiff's claims were ultimately dismissed, but the knowledge that you need to affirmatively inform the insurer that participation is desired is the takeaway from that one. I also looked at Robbins versus Mason County Title Insurance Company, Washington Supreme Court case decision by Wiggins. This one dealt with a treaty from 1854 where 9 tribes relinquished their rights to land, but retained the right of taking fish at all the usual and accustomed grounds and stations. The Robbins purchased land in 1978, and they started working with a harvester of those clam beds. Of course, the tribes asserted their right, and how they did that was by a letter. There's a lot of other important aspects of this case, but for the notice portion, the court found that that letter was a demand within the insurance policy, and it triggered the duty to defend. So that's important. And then finally, I looked at National Union Fire versus Zillow, a Ninth Circuit case. And the issue was that Zillow had a policy that provided coverage solely with respects to claims first made against an insurer during the policy period and reported to the insurer. And Zillow received a demand letter issued before the policy period related to a copyright infringement matter. The insurer brought a declaratory judgment action that no coverage applied because the demand was made outside the policy period. The district court agreed, granted SJ for the insurer, dismissed the insured's claims, but the Ninth Circuit said that a claim is defined as a written demand for money, 1, and 2, a suit. And the suit was actually filed during the policy period, squarely falls under the claim definition. And so the appellate court reversed that one. And so those are the 3 that I looked at for notice.
Good morning, everyone. My name is Galina Jakobson, and I am doing the last couple of cases in the notice of claims and IFCA section of our presentation. The first case is Washington City's versus Iron Shore Indemnity. In this case, the Judge Jones examined whether the IFCA notice provided by the insured satisfied the 20-day statutory requirement, and whether the insured was entitled to amend its complaint to add bad faith and breach of IFCA causes of action. The facts of the case relate to a demand for payment from the, in this case, it's a reinsurer, for settlement of a case that related to police misconduct. The reinsurer denied the claim, and so the insured filed a breach of contract litigation, and also requested that the court strike several provisions in the policy, specifically the mandated arbitration provision, as well as the choice of law and venue provisions in the policy. Prior to filing the motion to amend, the court did agree with the insured and struck the requirement that arbitration be held, and then also found that Washington law applied and that this matter should be before the Washington courts. Subsequently, the court then moved to, the insured moved to amend its complaint to add the IFCA and bad faith claim handling causes of action. The insured of note informed the reinsurer that it planned to add IFCA violations sometime in May of 2020. The court, in looking at the request, did grant the motion to amend. The court discussed the various methods under the federal rules to amend a complaint, specifically the requirements that under FRCP Rule 15, the request to amend should be liberally granted. However, if that request is made after the deadline in the scheduling order, then the party seeking to amend is required to show good cause. The court noted that the insured filed the motion to amend prior to the deadline and therefore did not have to show good cause to amend. The insurer attempted to argue that there was undue delay on the part of the insured, and therefore good cause did need to be shown. The court dismissed this argument, saying that the discovery deadline was many months away and this did not in any way prejudice the insurer. They were able to conduct discovery and develop a defense. The court also granted the motion to file an IFCA claim, finding that even though the motion would be heard at such time that the 20 days had not expired to file the IFCA litigation, because the insured was actually just seeking permission to file the IFCA complaint, and when that motion would be heard, 20 days would have passed, and therefore the requirements are satisfied, which supports the ruling in the case that Nicole had previously mentioned. It appears that judges aren't requiring very strict compliance with the 20-day requirement. As long as the insurer somehow had 20 days notice, it appears that the courts will allow those to move forward. The second case regarding notice deals with claims made and reported policy. It's called Faith Life Corporation versus Philadelphia Indemnity. It's also under section E in the materials as number 56. In this case, Judge Lasnik examined the application of the notice requirements for claims made and reported policy. The insurer had issued two policies, one from 2015 to 2016, another from 2016 through 2017. In November of 2015, two employees filed claims with the Washington Human Rights Commission and the Equal Employment Opportunity Commission regarding age and disability discrimination. The insured was informed in April of 2016, but did not inform the insurer of those claims. The employees filed suit in March of 2017, alleging the same causes of actions as reported in the administrative proceedings. They filed rather, the insured tendered the claim to its insurer, but the insurer denied, saying that the notice requirements were not satisfied. The insured in turn filed suit for a breach of contract, bad faith, IFCA, CPA, and declaratory relief. The court granted the insurer's motion for summary judgment, saying that Washington law strictly enforces the notice requirements in a claims made and reported policy, and that the April 2016 notice of the claims before the administrative committees did constitute a claim as defined by the policy. The interesting aspect is we'll see how the Ninth Circuit decision in Zillow will affect future cases relating to claims made and reported policies, and whether at this juncture an appeal hasn't been filed with respect to this, but it'll be interesting to see if the insured uses that case, the Zillow case, to challenge the dismissal of its case in this action. And we're off on claims handling, and Pam, off to you.
Thanks. So an insurer's claim handling can be a real source for trouble. A lot is at stake, and courts have even treated claim handling errors as intentional acts, and in some cases, unreasonable denial of a claim. But alleging claim handling errors isn't always the silver bullet that the policyholder wants it to be. In Gamble versus State Farm, which is case number 47, the policyholder moved for partial summary judgment for a ruling that the insurer had violated 3 WACC provisions. I think they wanted to form baseline of, you've already been determined to be wrong about this, so please pay up. What the adjuster had to do was determine whether a medical condition was caused by this car accident. And his investigation involved reviewing medical records, looking at the photos of the minor damage to both vehicles, and consulting with the in-house nurse reviewer, who said there was no causal connection. And so the adjuster denied the claim. On pushback, they did an IME, and the doctor said no cause, so the denial stood. In the lawsuit, the court said that under these facts, the policyholder had not proven as a matter of law that the insurer violated the WACC's governing reasonable investigation and timeliness. And note here that one of the policyholders' theories was that the insurer had not sufficiently trained the adjuster in Washington claims handling in violation of the WACC provision that says you have to adopt reasonable standards for prompt investigation of the claim. Additionally, in the White versus Liberty Mutual case number 59, the insurer accepted the duty to defend about 5 months after receiving the tender. The policyholder's response was, checkmate, you're too late. And so they rejected the defense and filed a lawsuit. They sought summary judgment that the insurance company breached the duty to defend and acted unreasonably. And the court actually looked at the circumstances and said, well, here are the circumstances leading to the delay. And the court also looked at whether the delay actually caused any harm, and determined that no breach of the duty to defend had occurred, and that the policyholder had not shown that the insurer was unreasonable in its conduct. So Nicole and Galina are going to touch on claims handling in a later part of the presentation. So we'll move on to the next topic, which is policy interpretation. And I'll quickly touch on 3 cases that I saw that involved defined terms. First, what is a, quote, insured auto, unquote? In case number 45, American Alternative Insurance versus Goodwill, the judge said a customer's car was a store's insured auto because it was being, quote, used in conjunction with your business, unquote, where the store employees had said, move your car over to the loading area where we can put your purchases. And in the course of moving it, the driver injured somebody. The court said, well, hey, the definition doesn't say it has to be an employee driving the auto. It just says the auto has to be used in conjunction with your business. And these of the 3 I'm talking about, this was the outlier. The other 2 are not quite so disheartening as that one. In the case number 46, Homesite Insurance Company versus Zajac, the court asked, what is property damage? The court said that a home seller's misrepresentation of the condition of the home, the failure to obtain permits and the failure to make repairs was not property damage as defined under the policy. That seemed like a straight over tackle kind of analysis. And in the 3rd case, which is number 55, Transamerica Life Insurance versus Slee, the question was, what is a nursing home? The policyholder argued that an assisted living facility should count. But the long-term policies at issue in the case defined nursing home as a facility that requires a state license. And the court upheld the denial of the claim based on the fact that the assisted living facilities did not have state licenses. Nicole?
Thanks. I looked at 3 different cases in the policy interpretation section of our presentation. The first one is Scottsdale Insurance Company versus Computer Sciences Corp. It's number 10 in our materials, 9th Circuit case. It deals with California law, but it could shed light on how the court could rule in Washington law related to tech startups. So the case dealt with a computer startup business that made a claim under its D&O insurance policy. The insurer filed an action seeking a declaration that it did not owe a duty to defend or indemnify. The insured brought forth expert testimony that in the context of underwriting D&O policies for a technology startup, the language contemplating being acquired is a term used to mean actively considering to offer to buy the company. And he further opined that the technology startup cannot be contemplating being acquired without a term sheet or a concrete offer to purchase the company. The district court found that the words in a contract are ordinarily to be construed according to their plain, ordinary, and popular legal meaning, rejected the expert testimony. But on appeal, the court looked at the California Civil Code section 1644 and said that while that's true, unless there is a special meaning given to them by usage within the industry. And in this case, there was, so it was reversed and remanded. A huge case in Washington this year, McLaughlin versus Travelers Commercial Insurance Company, where the Washington Supreme Court took a look at what the term pedestrian means within an insurance policy. This is number 2 under our written materials. This case will likely be dealt with later in the day today, so I won't go too in depth, but the basics are the plaintiff was a bicyclist riding on a Seattle street when the door of a parked car swung open and knocked him over, causing injury. He made claims to his insurer for his medical payments. And the question for the court came down to whether he was a pedestrian, because his policy would only provide coverage if he qualified as a pedestrian. Remember, he was riding a bicycle. The trial court agreed with the insurer, not a pedestrian. The appellate court agreed. But then when it came down to the Washington Supreme Court, they looked at the definition in the legislature, and it says pedestrian means a natural person not occupying a motor vehicle as defined in RCW 46.04.320. And plaintiff's bicycle did not contain a motor. And so the court also looked at that the section that the other courts were looking into were dealing with motor vehicles, and they needed to be looking at the section dealing with casualty insurance in Washington. So the court ultimately decided that the bicyclist was a pedestrian and remanded the case back down. The last case that I looked at in this section was Webcorp Construction versus Motorist Mutual Insurance Company, number 8 in our materials. Midwest Curtain Walls was insured under a policy. It received insulated glass units, IGUs, from a manufacturer and then installed them into curtain walls. It was later sued, tendered defense, and the insurer said that that was excluded under the policy. Exclusion K precluded coverage for property damage to your product arising out of it or any part of it. And your product included any goods or products other than real property, manufactured, sold, handled, distributed, or disposed of by the named insured. The Ninth Circuit found that the IGUs fell squarely within the your product exclusion because they were handled by Midwest. Galina.
Thanks, Nicole. I have 2 cases that are somewhat similar where the court, both United States District Court, Western District, took a look at the cooperation clause as well as the fraud clause in a policy and applied both. The first case is Progressive Direct versus Ruger. It's under Section E, case 25. In that case, the insured was involved in an accident where he drove his car into a guardrail and pled guilty for driving under the influence. The insurer informed the insured that as a result of this accident, his premiums would be increased. And at this time, the insured said, well, actually, there was another car that caused me to hit the guardrail. As a result of these allegations, the insurer opened up an uninsured motorist bodily injury claim, UMBI, to determine whether the accident is then covered under that provision and the insured is entitled to damages for any injuries he sustained. However, during the investigation of the claim, the insurer attempted to get evidence to support the claims that another car was involved in order to determine if coverage was in fact triggered. The court noted that while the insurer tried to serve the suit in which it was seeking declaratory relief that it did not have an obligation to defend, the insured drove off the process server with his rideable lawnmower, literally chased them off his property. And then subsequently, every time they tried to serve him, he had several dogs running around and being aggressive. So the court allowed service via mailing and used that to show that the insured was not cooperating. The insured sent photos of his car, but they did not indicate how another car had hit his car. And subsequently, when the insurer tried to have its expert examine the car, the insured refused and then provided notice that he no longer had the car. The court granted the insurer's motion for summary judgment, stating that the insured failed to cooperate, that he failed to provide any evidence that supported another car was involved, which was required for coverage under the policy. The second case that was a little more egregious in terms of the insured trying to get coverage through creative use of facts. The second case is Walker versus Twin City Fire Insurance Company. It's also under Section E as case 54. And in that case, the Judge Martinez again examined what constitutes fraud and under the insurance policy pursuant to its terms, and whether the insurer has an obligation to pay a claim. In the Walker case, the insured struck a parked car while he was driving, and in the police report, as well as several statements, recorded statements given to the insurer, the insured indicated he was going northbound when a car going southbound veered into his lane, causing him to hit the car. The insured sought PIP coverage and subsequently attempted to obtain UIM coverage. When the insured was informed that there was no UIM coverage based on the statements he provided, the insured stated that, well, actually what had happened was that a car hit him from behind, and that's what forced him to hit the parked vehicle. The insurer still denied, and then the insured filed suit. And immediately after filing suit, the insured provided a letter purportedly written in 2016 by a witness who corroborated his story that his vehicle was hit from behind. During the investigation, the insurer was able to determine that through metadata of this letter that it was actually written in 2019, not 2016, and that there was no evidence to corroborate these purported statements that the insured was hit by a car from behind. The court upheld the policy terms and indicated that fraud eliminated coverage under the policy, and therefore there was no obligation to provide coverage for the UIM under the claim. And now we're going to move on to removal and remand, and Pam will discuss a couple of cases for us.
So whether to remove an insurance case from state to federal court should probably be an attorney's first question after clearing conflicts. The deadline to remove is usually very close by the time we're retained, although there are sometimes later opportunities. And when there is a non-diverse party, sometimes there's a basis to remove anyway based on fraudulent joinder. And we'll hear more about Keodalah's fallout later, but it has brought some fraudulent joinder questions right to the fore in Washington law. Then, of course, if removal is the right thing to do, it's often followed by a motion for remand. And the remand statute provides for attorney's fees recovered if there's no objectively reasonable basis to remove the case. So if you want a primer or a refresher on the nuances of removal, I'm afraid we're about at the halfway point of our presentation this morning. We're not going to be able to get to that today, but we'll give you a few points that we have seen this year. So in case number 43, Christian versus Regents Blue Cross, the policyholder settled with the non-diverse party and gave a notice of removal to the non-diverse party, but refused to file the notice of removal. So the insurer alleged fraudulent joinder and removed the case, but the court said no. The settlement alone is not enough to give the court jurisdiction, and the fact that there's no order of dismissal in the state court case means that that party is still part of that case and removal can't happen. But the judge did say no attorney's fees in this case because discovering that the that the policyholder had settled with the non-diverse party and apparently dismissed them was a reasonable basis for removal. In the second case that I looked at, it's number 58, Hesselgesser versus Geico. The second amended complaint in that case was removable, but the court found on the motion for remand that the initial complaint and the first amended complaint were also removable. So remanded the case on an untimeliness argument, but again, denied the insured's motion for fees because the fact of the matter was that the complaint was removable and it seemed to trigger a new deadline. And so that wasn't sufficient to find that there was no reasonable basis for removal. Nicole?
Thanks. I took a look at three different cases. The number 27 in our materials is Elijah versus Garrison Property and Casualty Insurance Company. The claim was made under homeowners insurance policy for damage contributed to by a leak from a bathroom pipe. Plaintiff filed a complaint in this one indicating that the adjuster had evaluated the estimated cost of the claimed repairs at $38,392.17. And then the prayer for relief stated economic, non-economic damages, diminution in value, and treble damages in the amount to be proven at trial. Defendant went ahead and removed on that basis, and the court took a look and said that because there was an amount given in the complaint and treble damages were requested, that number trebled would be over the amount needed to remove the case. The court declined to award attorney's fees in this case. They said that the complaint did not explicitly state a total amount in controversy, allowing for an objectively reasonable basis for removal. And then I took a look at case number 1, third and battery versus Hartford Casualty Insurance Company. Here, the insured submitted a claim for property damage caused by a fire. The insurer accepted coverage and adjusted the claims. The insured subsequently assigned the claims for future payments to a plaintiff, and this plaintiff in this case, and plaintiff claims to have incurred fees and expenses post-assignment, which asserts are covered under the insurance policy with insurer. And plaintiff claims that the insurer denied the validity of the assignment from the insured to the plaintiff and refused to issue any payments, and plaintiff filed a lawsuit against the insured and the insurer. The insurer sought to remove the case, and plaintiff moved to remand for lack of complete diversity because plaintiff and the original insured were both Washington residents. The insurer's argument was that complete diversity did exist because plaintiff fraudulently joined the original insured as a defendant, or that the original insured's interests are aligned with plaintiffs, and so they should be considered a plaintiff for jurisdictional purposes, and requested that the two be realigned. The court utilized the standard that if there was any possibility that a state court would find that the complaint states a cause of action against any of the non-diverse defendants, federal court must find that a defendant was properly joined and remand the case to state court. The court found that that did happen here, and that the insurer's conclusory arguments failed to establish that the plaintiff had not stated a cause of action against the original insured. The court on attorney's fees said that although removal was not appropriate in this case, it was also not objectively unreasonable, and so no attorney's fees were awarded. And then finally, number 6, Rosa versus American Family Insurance Company, a home that sustained significant first floor water damage. Plaintiffs provided notice of damage to the defendant. Water led to mold, and Washington Water performed water mitigation, but failed to adequately address the water damage or the mold. And so plaintiff initiated an action against Washington Water and the insurer. Washington Water sought to compel arbitration between themselves and plaintiff, which was granted. And then the insurer decided to remove the case. Insurer's position was that because Washington Water could be severed from the case because they were going to go to arbitration with plaintiff. The court reasoned that plaintiff has always been the master of the complaint and is afforded the first opportunity to select a state or federal forum. Just because Washington Water and plaintiff were compelled to arbitration, Washington Water still remained in the suit. As a result, the court found that the case was not removable. And in this case, the court did award attorney's fees and found there was no tangible support for defendant's position because at the time that they removed, Washington Water was still a part of the case and the case was not removable. And that's it for me, Galina.
Thanks, Nicole. I also had a case regarding attorney's fees for removal of a case that the insured felt was improperly removed. The case is Berry versus Safeco Insurance Company. It's number 63. In that case, the insured sustained water damage to their home, and there was a dispute as to the cost of repair. Because the parties couldn't reach an agreement as to what the cost would be, the insurer stating $18,000, insured's contractor stating $30,000, the insurer invoked the appraisal provision in the policy, and the appraisers came in with an estimate of $25,000. Subsequently, the insured filed suit for breach of contract, IFCA violation, insurance bad faith, negligent claim handling, and violation of the CPA. The insurer removed on the basis of diversity and that the controversy exceeded $75,000. The insured then moved to remand, saying that the controversy actually did not meet the $75,000 threshold level because the insurer had made some payments for the $25,000 in repair costs. When the insured filed the remand, the insurer actually stipulated to remand, and this struck the Judge Konauer as a little odd, as he noted that the insured's stipulation, quote, wasn't good enough for the insured, and they sought their attorney's fees and costs as a result of allegedly wrongfully removing the case. The court reviewed the damages to determine whether the insurer had reasonably removed, and in looking at the fact that there was still some of the outstanding amount owed for repair costs plus trebling of those, the court deemed that that would be about $36,000 plus attorney's fees and other costs, that the insurer was reasonable. There was a reasonably objective basis to remove and did not grant the attorney's fees. What was interesting in this case is that the judge noted that because the insurer didn't offer an estimate of damages that the plaintiff was claiming for repairs or an estimate of attorney's fees, that the insurer failed to meet its burden of showing the controversy amount with a preponderance of the evidence. However, the court did state that that's a completely separate issue from whether objectively it was reasonable for the insurer to remove on the basis that the amount in controversy was $75,000, and therefore again denied the attorney's fees request. And now we're going to move on to stays, bifurcations, and consolidations, and Pam is going to talk to us about a few cases.
Thanks. I'll talk quickly about two cases that I reviewed. In number 52, Dentist Insurance Company versus Eusebian, the property damage policy contained an appraisal provision, and the insured asked that appraisal be started and a stay be, the judge order a stay while the appraisal was going on. The court granted that motion and said the litigation is going to be stayed during the appraisal. And his reasoning for that was that, first of all, the parties had contracted for the appraisal in the policy, and so he was going to uphold the contract rights. And the second was that it was practical for the parties in the court in the litigation, that this was a big question in the litigation, how much money is at stake? And if that could be answered, it could lead the parties to settle, and it would narrow the issues for trial. I'm not going to really talk about this one because of our timing, but number 37, Phoenix Insurance Company versus Diamond Plastics, has a determination that the discovery and motions practice relating to the insurer's duty to indemnify would be stayed, even though discovery and anything else related to the duty to defend could go forward. Nicole?
Case number 8 is Hopkins versus Intigen General Insurance Company, a Western District of Washington case. dealt with a motion to bifurcate UIM claims from extra contractual claims. And the plaintiff suffered a TBI from an accident, later aggravated by another accident, and treating providers noted that he would have residual vertigo long-term. He ended up accepting limits from the tortfeasor's carrier and then made a claim to his insurance carrier under his UIM coverage. The adjuster set a reserve for $100,000, made an offer of $17,340, and then conducted a records review and increased the offer to $40,000. Plaintiff filed suit for bad faith, IFCA, CPA violations by insurer, and defendant insurer moved to bifurcate the trial, again, the UIM claims separately from the extra contractual claims. The court took a look at this one and said bifurcation is inappropriate when the issues are so intertwined that separating them would create confusion to the trier of fact. And Peckman said in this case that even if a jury finds that the value of defendant's UIM claim was $17,340, the extra contractual issues relating to the investigation and handling of the insured's claim for indemnity still exist. It would not expedite and economize here, where at least 4 witnesses will provide testimony relevant to both the UIM insurance claim and the extra contractual claims, and they would necessarily have to testify twice. So the motion to bifurcate in that matter was denied. Galina?
Thanks, Nicole. The case I'm going to talk about is West American Insurance Company versus Construction Loan. It's number 48. And in that case, Judge Rothstein examined if a stay of the coverage action was appropriate while the underlying action was pending. Judge Rothstein basically did grant the stay, finding that it would be undue burden for the insureds to have to fight 2 battles, and that the insureds may be prejudiced because the evidence or uncovered or other factors in the coverage action may constitute collateral, res judicata for the underlying action. The judge also dismissed the insurers' arguments that they would be prejudiced because they have to defend the insured while the entire underlying action with the coverage action being stayed. What I found interesting was that the judge referenced the fact that the policies of the insurer included a provision that allowed them to reimbursement of defense fees and costs where it's found that they had no obligation to defend a case. So the court dismissed the insurer's arguments that they would be prejudiced by this. The insurers came back to that argument saying that there's no indication that the insured could reimburse their attorney's fees and costs, which were significant in this case. And the judge responded that there was no case law that supported the fact that the insured had to be able to actually reimburse defense fees and costs in order to enforce the provision with respect to reimbursement. And so the court did grant the stay. And now I'm going to very, very quickly touch upon all of the COVID cases. There is a section later on today that will discuss them more thoroughly, but very briefly, there have been 1,500 insurance coverage cases filed in 2020 nationwide, and the multi-judicial district court recognized that Washington was a favored jurisdiction for being pro-insured. However, to date, only 2 cases were accepted by the multi-jurisdiction district court, wherein all of the suits against two insurers were consolidated, and those were only for Society Insurance Company and the Erie Insurance Company, and that those did not include any Washington cases. The cases in Washington have attempted to be consolidated by the insurers, and right now, based on the information available, the cases against Valley Forge entities have been consolidated, and there's an attempt to get a class action certification with respect to National Fire Insurance and Transportation Insurance Company. What's interesting is that there is a pending legislation, SB 5351, that is attempting to address the defenses that insurers are presenting to the COVID business interruption coverage. And basically the effect would be to change the time limitation from 1 year to 2 years in allowing a cause of action against the insurer, and to amend the definition of what property damage is covered. And now we're on to class actions, and Nicole has a case she'll discuss.
Yes, thanks, Galina. I took a look at a few cases, some interesting points to make on class actions this year. Number 28, Stevens versus United Services Automobile Association, which is an Eastern District case dealing with whether a court can order an appraisal take place under the policy in a class action. Plaintiff alleged that defendant systematically undervalues its customers' total vehicle losses claims by relying on valuation reports by a co-defendant in the case. Defendants filed a motion to compel plaintiff to submit to an appraisal. The court found that the appraisal clause in plaintiff's insurance contract was enforceable under her breach of contract claim, because the breach of contract claim, as pled in plaintiff's complaint, was fundamentally a dispute over the dollar amount of the actual cash value of plaintiff's vehicle, and so appraisal was ordered. Number 4, Williams versus Geico General Insurance Company, a Western District case. That one dealt with whether the court could stay in action pending an appraisal. The insurer filed the motion to stay the action pending a planned appraisal of plaintiff's vehicle, or in the alternative, moving to dismiss and strike. And the court found that the insurer had failed to establish that a stay was warranted, and the need for any stay or that there was any prejudice in litigating the matter while the parties participated in the appraisal process. And so that motion to stay was denied while the appraisal continued on. And then number 10 in our materials, Zielinski versus First National Insurance Company, dealt with removal of a class action and damages calculations. The important part about this one is that the insurer and then the class came together with competing damages calculations. The plaintiff supported their damages calculation with a declaration by an expert who had provided similar testimony in other cases where they were asserting that the proper method of calculating class size and amount in controversy involved utilizing raw data obtained from the insurer and then whittling down the number. And they had created, and the court found that both theories had shortcomings. The insurer's amount of looking at all of their claims within the class in their system, and then the plaintiff amount in using their expert testimony to take that raw data and then whittle down those claims. But the burden of proof is on the insurer, and the burden had not been met because of unsupported assumptions that were made in determining their number. And so that's an interesting look at how the courts will view damages calculations for class actions in federal court if the parties bring competing theories. That's it for me.
In the interest of time, I'm going to incredibly briefly talk about case number 51, Reppart versus State Farm. In that case, class action, the named plaintiffs brought suit saying that State Farm violated the WAC provisions for evaluating the actual cash value of cars that were totaled. The insurer tried to get the causes of action dismissed, alleging that the required elements of each cause of action, which were common law bad faith, a breach of the covenant of good faith and fair dealing, had not been properly pled. The court did not agree with the insurer's arguments and denied the motions to dismiss. Of note, the court stated that the insurer attempted, or rather requested, that appraisal be ordered in order to obtain the proper values of the vehicles in question, but the court indicated that the insurers were essentially attempting a red herring, that the issue wasn't the actual value put on the car, but the methodology was illegal pursuant to the WAC. And therefore, the court allowed the case to continue. And now we're going to go back to Pam and causes of action.
And if you're watching the time, you'll note that we're a little past what it says on the schedule, and that's because we started a little late. So this will be our last section. And I'm going to suggest that we each talk about one case and bring it to a close. I saw an interesting breach of contract theory in case number 29, Minnesota Life Insurance versus Perkins. This one had a comedy of errors, set of life insurance beneficiaries showing up, 2 people that claimed to be the surviving spouse, multiple children and stepchildren, and 1 policy and 2 beneficiary designations. It was very confusing. And so the insurance company invoked the interpleader option, said we want to deposit this into we want to deposit the benefit into the court, and you guys fight it out, we're out. And so in that case, one of the claimants said the insurer was breaching the duty to pay her benefits when it sought interpleader instead of just simply paying her. And the court did not accept that argument. The court said that by reasonably pursuing interpleader instead of choosing to pay the beneficiary, that the insurer had actually discharged its contractual obligations in this case. Nicole?
I took a look, thanks Pam. I took a look at Webb versus USAA Casualty Insurance Company. It's a Washington Court of Appeals Division 2, number 1 in our materials. The brief facts are that neighbors alleged that appellants shot guns at targets on their own property, which then carelessly and recklessly caused bullets, bullet fragments, and ricocheted projectiles to enter their neighbor's property, and they brought claims for trespass and nuisance. The insurance company decided that those claims were not covered under the policy, and the appellants made claims of bad faith, violation of IFCA, and violation of the CPA. The important part here is that the court came down hard on the insurer, stating that the respondent's failure to evaluate the complaint, the policy, and the applicable law for whether the policy conceivably could cover the allegations made was unreasonable and frivolous. It looked to the court that in this case, the insurer was reviewing for how the claims could not provide coverage. And that is absolutely contrary to the law in Washington, that when an insurer evaluates whether or not to defend a lawsuit against its insured, the insurer must ask if there is any conceivable way that one or more of the claims asserted in the lawsuit is covered under the applicable policy. Galina?
Thanks, Nicole. I'm going to very briefly discuss the case of Kenko versus Hartford. And in that case, the court examined whether a third-party claimant under a surety bond can, rather has standing to assert bad faith, IFCA, and CPA claims against the surety for its claims handling practices. The court found that the third-party claimant to a surety does not have standing and cannot seek IFCA, CPA, or bad faith damages against the surety, referring back to the tank case, wherein the Washington Supreme Court stated that claims for bad faith were based upon the special relationship between an insurer and an insured. And while a third-party claimant under a bond is entitled to payment under the bond, that relationship is not the same as an insured and an insurer, and therefore the third-party claimant cannot seek those bad faith damages against the surety bond company.
Well, thanks everybody. And I noticed that there's a question for Nicole and Galina in the Q&A. So at the break, maybe one of them will answer that. You could see that we were quickly stepping through this and didn't have much time for questions, but we appreciate your attention and we'll see you next year.
Thank you.
Thanks so much, everyone.
All right. Thank you, Pam, Galina, and Nicole. Our next presentation is titled Emerging Pretrial Practices Across Washington State. And we have two presenters today for that topic. Our first is Lori O'Toole. She is a partner with Preg, O'Donnell, and Gillett. She is a past president of WDTL and former chair of the WDTL Construction Law Seminar. And she also currently serves on the board for DRI as the Northwest Regional Representative. In addition, we have Brad Smith today from Feltman Ewing. Brad's practice encompasses all areas of civil lawsuits and dispute with an emphasis on insurance coverage and defense, bad faith litigation, and construction defect disputes and trials. Brad is co-chair of WTL's legislative committee, and today he brings a much needed Eastern Washington perspective to the seminar today. So I'll turn it over to Lori and Brad.
Very good. Oops. Okay, and I will trust that you can hear me. Jason, raise your hand if I can't, but this is rather new for all of us. We're going to start off talking about CR 35 examinations, and Lori and I will be bouncing back and forth on various topics and sometimes joining each other on these discussions. This area of 35 examinations has become increasingly problematic in my own personal practice, and I know from talking with many attorneys it's the same on the west side of the state as well. It's always good to start, for your own practice when you're dealing with these, is to review CR 35 again. There's nothing in CR 35 that talks about stipulations. Pursuant to the rule, if you want to have a 35 exam, you're supposed to file a motion and the court has to order it if there's been good cause shown. But, and in the past, for my own practice, it used to be no problem. You would contact plaintiff's counsel, request a 35 exam, and they'd say, fine, who do you want to use? And let's set it up. And of course, over the last 10, 15 years, we're starting to see more of these stipulations being entered into or demanded by plaintiff's counsel beforehand. And if you're like me, you've learned that, like my own waistline, these stipulations are getting longer and longer all the time. And they often result in weeks, hours of discussions, which can create a lot of problems. We have a couple poll questions we want to include at this point, and Lori is going to be the one at least putting those up on the screen for people.
Well, and of course, with these wonderful new tools that we have on Zoom, I'm not seeing that I'm able to access our polling questions right now.
Hi, Lori, it's Maggie. Can you hear me?
Yes, I can.
Apparently, I have the controls over the polling, so I'm going to go ahead and launch your polling questions.
Awesome. Thank you.
Here they come.
So hopefully everyone can see our polling question number one. In the majority of your personal injury cases, are plaintiffs' attorneys requesting CR 35 exam stipulations? And if Maggie, if you can enable the voting on that.
We'll need the second polling question as well after that one.
Okay.
We thought we were being so clever with these polling questions and making people participate, or requesting, I should say.
And for the record, Maggie, I see that a little note at the bottom says host and panelists cannot vote. And I think there's far too many attempts to disenfranchise people from the vote these days, and I'm therefore objecting to this.
Okay, so you two, I can see the polling questions. Can no one else see the polling questions?
I think I can see the polling question, but do you have to enable for people to vote?
No, they're voting now.
Okay, awesome.
You have 51 votes for yes and 10 for no. So you just need to let me know when you want to end polling. This
Okay,
will be a reminder to you all to get your votes in now. How many seconds should we give them?
I think we should give them 5 more seconds. 4,
Okay.
3, 2, 1. Okay, end polling. What are the results on that, Maggie?
Okay. Pretty much as I would have expected. Stipulations are very common. And can we have the second question, please?
Okay, let's figure this out. I'm going to.
And I'll read it as it comes up. How many times in the past year have you had to engage the court to rule on a stipulation, or, bring a motion to compel? And that's in the past year. None, 1 time, 2 to 5 times, or more than 5 times.
Okay, let me find our next polling question. Sorry, guys, I'm failing you. Okay, I'm gonna try this. Is this the same question?
Yes.
It is. We need question number 2.
Well, for all the fancy attempts at polling, I am, wait, hold on. Here we go.
Yay.
You are question number 2.
And Brad, why don't you answer the question, since we are not allowed to vote, but we can at least maybe influence a little bit. How many times have you had to engage the court in the past year?
I think twice for my personal practice.
Yeah, I have had to do so also. Mainly, actually, it was interesting, both cases involving minors and getting psychological evaluations. And we agreed to do them via Zoom, and the plaintiff's attorneys just said no. And thankfully, winner won both times on that issue. And, in the one case, the court just, as far as, we also had these various, especially with psychological evaluations, that, the parent couldn't be in the room and things like that. And the court went 100% with our proposed order. So that was awesome. So what were the results of that?
Okay.
So none, 60%. Wow. 1 time, 2 to 5 times was 18%, 18%, and then more than 5, 3%. So 2 people.
All right.
So,
Wow.
just so you two know, Garrett Ayers did ask a question. He said, for
saw
the
that.
first poll, okay, do arbitrators count? And he said, I have to speak with arbitrators for CR 35 evaluations all the time. So
And
I would think yes. I would say yes.
And one thing that I can maybe add with respect to the Eastern Washington side of things, I've heard of this being a frequent dispute on the west side. Our arbitrators over here, I've not found, are denying CR 35 examinations and MAR proceedings. But I obviously think that you need to make that request very early in order to make sure that that happens. Anyway, getting back, thanks for the answers to the questions. In my practice, and I think Lori agrees, these stipulations are often very veiled attempts to impose what are effectively motion in limine type restrictions on the examiners at the very early level. And go way beyond, of course, what the CR35 requires, which is virtually nothing in terms of stipulations on 35 exams. Thought I would jump through some of the recent types of requests or demands and stipulations that I've received recently from plaintiffs' counsel. They often want the stipulation to indicate that this is going to be the one and only examination that's going to be done. And although CR35 does provide that it's more in the singular form, don't sign anything that would prohibit your right to at least to go back to the court and request perhaps a second exam if that turns out to be necessary. Very common.
Brad, I'm going to interrupt. Are you talking about an exam in a different field? For example, you decide to have an orthopedic exam and then all of a sudden all these neurological issues come up, and so you want a neurologist to do their own exam. Is that what you're talking about?
Yes, or perhaps at the start of the claim they're only making something that's more of a pure orthopedic issue, and then there's something comes up later on. For example, maybe a CRPS nerve damage type of claim, which would require a new examiner for a new expert. But if you sign a stipulation agreeing that this is going to be your one and only, you might foreclose that situation. Same type of topic. They often try to limit the expertise or the areas that a particular examiner can go into. If you have an orthopedist that is going to be doing the CR35 exam, they can still ask questions that might relate to neurologic issues or depression or some other issues just as part of their practice. But if you sign a stipulation that limits that, you're effectively tying their hands both in the examination and potentially later on at trial. I'm seeing a lot of questions that try to limit any questions dealing with liability, which would include even questions about the accident itself or the mechanics of the injury, of producing the injury. And so again, be very hesitant to sign anything or agree to anything that ties the hands of your examiner. Similar situation. They want to have the stipulation agree that nothing the plaintiff says in the examination can be later used as an admission at trial. And I'm always looking at what they disclose or reveal to the examiner with respect to maybe the mechanics of the injury or their symptoms. Look out for trying to an attempt to get you to foreclose that opportunity in the stipulation itself. Had an interesting stipulation came up recently where they tried to have the examiner agree, or the plaintiff, myself, agree with the plaintiff early on, that the examiner could not consult with others to either write the report or to provide the medical opinions or findings. Obviously, our experts are entitled to rely upon perhaps the consultation with others, so look out for that sort of thing. What's really getting annoying is the attempt in the stipulation to effectively influence a subsequent deposition of that expert, either by demanding an immediate identification of with the report, whether they're going to be a testifying expert or not, or even agreeing, serving with the stipulation, the subpoena to those experts, demanding production of the documents, background information that would be required only once they are deposed. And they're trying to get that with the CR35 stipulation, which is obviously beyond what they are entitled to get in these types of cases. Other types of, they'll also often in the stipulation try to get you to agree that they will have an absolute right to submit rebuttal experts to the defense witness, even well before or well after the case schedule provides for the same. So again, just looking at what they're trying to do here in order to get you to agree. And the final thing that comes up frequently is a final paragraph that basically says not only that the defense attorney is responsible to see the adverse examiner is appraised of and follows the order, but also includes a catch-all that if there's any violation of the stipulation by the examiner, his findings and testimony are going to be excluded. And obviously you cannot agree to anything like that in a stipulation. So the one that I was referring to most often is about a 27-point stipulation, so they grow exponentially over the year. The last thing I want to point out on this is there was a roundtable discussion several months ago through the WDTL, and if you've never attended one of those, they're excellent, that discussed CR 35 exams, and Levi Bedell with the Holt Woods law firm in Seattle had a really proactive way, I think, of dealing with CR 35 stipulations. With his first submission of written discovery, he sends out a proposed stipulation, and we've got a copy of that as part of the materials. And it's obviously a much shorter stipulation, which attempts to try to limit the number of issues that the plaintiff is going to be able to go into. Provides them some of the things they usually want to see, such as a potential limitation on the time, but gives some flexibility to it. There it is. And if you can go to the second and third pages of that, Lori.
Yeah, and I just want to mention Joanne Blackburn asked, hey, can you guys provide us with a example stipulation? So good timing, Joanne. Thank you for that inquiry.
Correct. And as I mentioned, he serves us with the discovery under a letter to proactively begin the discussions with the plaintiff's counsel. And then if the plaintiff comes back and tries to be too onerous with their demands, only then he files a motion under CR 35 with the court, and therefore has already indicated that he tried to be proactive, proposed a reasonable one that followed the rule, and only pushes the court if the plaintiff is unreasonable in this. And the last point I'd make is, at least on general stipulations, is the fact that I found that for those of you who have not filed motions on CR 35, I found that plaintiff's counsel get a lot more reasonable once you file that motion. They'll often end up agreeing to a more reasonable stipulation because they know that the steps that they're usually proposing go way beyond what the rule is going to require and what the court is likely to order.
And Brad, for a while on at least the west side, we were seeing many stipulations demanding to see financial information about the experts, requesting 1099s and such. And it seems like that the plaintiffs, at least in my cases, have kind of backed off that request. I don't know if they've now gained all the information that they need on these experts, but it seems like it's not as prevalent of a provision anymore. And in fact, I even had one that went as far as asking for all the reports from the past 5 years of the IME provider and or the doc, and I ended up actually having to argue that, and thankfully won out in Grays Harbor County that they did not get to have access to the prior reports.
Right. And there's a question from Garrett again, how can we stipulate to what private information our experts will share? You know, what kind of follows along with what Lori just said is there are, judges are going to allow for bias purposes the plaintiffs to be able to examine the money that an expert makes for their forensic work compared to others. And so, I'm actually at the beginning when I'm looking for my examiner, I'm asking those questions originally, even before I make the final choice. I have to know, because there are those examiners who will refuse to give out any financial information whatsoever. Most I've found are willing to at least give their 1099s, showing at least the income that they've made for forensic examinations. But that's just something that needs to be discussed with your expert even before you disclose them to the plaintiffs for a CR 35 examination request.
Yeah, and I always send the proposed stipulation to the examiner, because I don't want to have to go back and say, oh, guess, we can't agree on this. So that's a good practice pointer, is to get their buy-in.
The last topic that we were going to discuss, there's a kind of a survey This deals with neuropsych exams because CR 35 does include mental examinations, but it provides that an observer is always entitled to attend the examination, and that the plaintiff can audio tape and with stipulation videotape. But most neuropsychs will not agree the testing portion of their exam to either be observed or recorded. And so I had a recent motion down in Whitman County where this really was specifically argued, and my expert, Dr. Ziegler, was only willing to provide an audio tape of the testing to the plaintiff's expert, which she has been forced to do in certain other situations. In this case, the judge actually ordered that the plaintiff could audio tape the entire testing, after which Dr. Ziegler took out about 80% of the tests that she was otherwise going to provide because she just could not allow them to be audio taped for licensing purposes or there. So in the process of this motion, I had obtained about 15 orders from around the state that are identified here in terms of the rulings, and some judges are essentially allowing representatives to attend the entire testing process. Some allow an audio tape just to the plaintiff's expert, and some are basically supporting the defense side of things, not allowing any representation or audio taping to the plaintiff at all. So this kind of gives you a feel for things. Obviously, it's a little more loaded towards the west side of the state. One thing that I've started considering doing is at the early stage, since the plaintiffs often will have a neuropsych expert that they've already sent their client to, is I'm going to start sending interrogatories or trying to find out well before I propose my own CR 35 exam, whether the plaintiff's neuropsych allows audio taping or observing of their own examination process, because I think that's the best way to support your own defense examiner's position, is if the plaintiffs themselves don't allow it. That's going to make the judge a lot more likely to say, okay, I understand what the defense examiner is talking about here, I'm not going to order it. But unfortunately, too many times, like this last time, I got to the hearing and I didn't have that information to provide to the judge because I hadn't looked at it earlier or hadn't deposed the plaintiff's examiner beforehand.
And Brad, do you what I've pointed out is, you get a good declaration from Dr. Ziegler or the other neuropsychs that says, this ethically is not allowed as part of our exams. And then I point out to the court, where's the declaration from their expert saying they allow it?
Yeah, and I did that, and unfortunately, Judge Libby disagreed with me. So,
oh, wow.
Yeah. Okay, well, that's everything on, you were going to go into some COVID protocols, Lori. I'm not sure if we want to go too deep in that.
I don't want to go too deep. Just as all of you probably know, many of the plaintiffs, I received these two attached documents actually from the plaintiff to be exhibits to CR 35 stipulation that was, very limited. And so it was kind of new to get it from them that these two exhibits be part of the stipulation. And a lot of times now, I know the CR 35 examiners that I'm working with, they send out these types of documents whenever you make the appointment and send the scheduling information to the plaintiffs. So, I have these documents. So if folks want them, they can contact me, but it's pretty common. And then lastly, Brad, I think you wanted to share what's been happening with you and doctors flying over to Spokane and the issues with that.
Yeah, a couple times here in the COVID era, I've had plaintiffs' counsel refusing or wanting to delay examinations if the doctors were planning on flying over as opposed to driving, because in flying they would be exposed to so many people. Now, I haven't had that since the doctors have all been hopefully vaccinated by this point, but some may not be. And even then, it's possible that the council over here, because so many of our doctors come from the Seattle area, they're not wanting them to fly because they'll be exposed to 100 people just on the plane right before they come in. And it's a legitimate concern they've had. And I think I had a doctor that agreed to drive over as opposed to fly in order to rectify this situation. Okay, I think we're going to talk a bit about depositions here, and in particular, one area that has come up a lot in my own practice is an increased number of CR30B6 depositions, even in cases involving your normal tort defense, your slip and falls, your automobile accident where the defendant driver is an employee of the defendant company. And it's pretty clear that this is probably due to the evolving reptile theory arguments being made by plaintiffs. And Lori's going to jump into that a little bit more. In the past, I would get some CR30B6 deposition requests that were very unsophisticated. You might get a request in an interrogatory asking to identify who your CR30B6 witness is going to be, which is obviously inappropriate because they have to identify the topics that they have to discuss. And then you get the request saying that, okay, have them discuss everything that relates to the complaint, which is obviously too broad. What now I'm seeing is some very, very detailed 30B6 topic requests. One in particular had approximately 82 topics being raised, which included 15 questions specifically on the fact issues involving the case that, of course, the corporate representatives themselves would have no personal knowledge of. And what was my original reaction was to object, either file a motion for a protective order, or basically tell plaintiffs I was take a long walk off a short pier. But unfortunately, I started looking a little bit more about the law. I knew there was very little cases in Washington regarding 30B6, but even nationwide, the cases tend to be get broad rulings that saying, yes, you can basically ask corporate representatives factual questions. Now, those might be your cases where the reps know where the facts are, but they were so broad that I thought that I was probably not going to be able to be successful in getting this knocked out. So I kind of turned it around and used the factual questions and the very numerous questions, made it a lot easier for me to prepare my witnesses for the deposition, since I knew basically every question that was going to be asked and by topic. And I kind of took a chance because there's no real rules about it. But since I was being asked to educate my corporate witnesses about the facts of the case, the only real way to do those, since one of those witnesses was already gone, was to use their recorded statements taken by the insurance company before the lawsuit to provide them that facts. And of course, once the plaintiff's counsel learned that they had reviewed those, they were demanding production of those during the deposition, which I refused, and they brought a motion to compel those statements, claiming that we had waived that or that they were entitled to get anything that the deponents had reviewed for purposes of preparing for their case. But the judge agreed with me, since the plaintiff was taking the kind of the extreme route to ask corporate representatives to provide facts that they had no personal knowledge of. It was perfectly natural for them to educate themselves by going through these statements, and we didn't waive that by asking them to do so. But it was pretty obviously that the factual questions were probably trying to get whatever work product or attorney-client privilege documentation, which normally would not be discoverable, and trying to use this as a way to get a waiver. But the judge over here, at least in Spokane, Judge Shamblin, supported us on that. So that was a good finding. Laura, you going to go into the reptile theory aspect of this a little bit more?
I am. And, you know, first of all, whenever you get a case in, I recommend that you try to recognize, is this a case where the plaintiffs are going to use this reptile theory to drive their case? And basically what they're attempting to do is to change the standard of care as far as if, for example, if you have a client that has a lot of internal safety rules as far as how their employees should do their job, that they try to use those safety rules as the standard of care versus, you know, what's the standard of care in the industry. So you need to be very careful and identify these types of cases. Another case is a trucking case, or if you've got an employee driver, what they'll try to do is bring in, for example, the federal standards for truck drivers, and which are much more stringent than just your regular standard of care for negligence. So what you could, there's a couple things that you should do if, for example, if you do get a 30B6 notice, is, you know, make sure that you make your objections in writing before the deposition. You may need to conduct a CR26 conference before the deposition, but be sure to do that. Or you may want to consider actually moving for a protective order. There's been some success on the federal level, especially if you're dealing with a known quantity of a plaintiff's attorney that uses these reptile type practices, where you can argue, you know, they're simply doing this to create confusion in the jury about the standard of care and to replace it with the company's internal safety rules. And then also argue, like Brad said, you know, these are fact witnesses, they're not expert witnesses. So any questions about hypotheticals are beyond the scope of the deposition, because, you know, they're not expert witnesses to testify about, is this situation dangerous? Or is this a hazard? So just be very diligent in both preparing your witnesses and also doing maybe some preemptive strikes with both objections and bringing a motion. And I know I have a case right now where I'm going to team up with my co-defendants and suggest that we bring this type of motion in a case where they're trying to make the standard, the federal standards with regard to trucking, and which are much more higher standards than just your legal standards involving a car accident. I also wanted to mention a practice pointer. There was a roundtable last month on the reptile theory, and I believe it was Carl Forsberg had this practice pointer with, you know, if the complaint mentions safety or mentions a safety standard that's not the legal standard, in your answer, cite to, you know, the reasonable care standard for negligence, cite to it in your answer, or in your discovery responses if it's asked. So that was a good practice pointer I got from that discussion, which are, I am going to do a shout out to the roundtables. They're always a great way to talk through things. So wanted to talk a little bit now about in the Zoom era, there seems to be a lot more videotaping of remote depositions. So wanted to first, Maggie, we've got some polling questions. There are questions 3 and 4. So let's wake up everyone in our audience and see if they can participate in our polling with regard to videographers. So if first question is videotaping a deposition not using a legal/professional videographer allowed under the civil rules in Washington? So is your answer yes or no? And I am not seeing the responses, Maggie, so let's give everyone like 5 more seconds to get in your answer. And what does our polling say? Our polling says, yes, it is allowed. For 67 people said, oh, that's 2/3 said yes, and 1/3 says no. Well, I can advise that it's really not addressed in the rules. And you need to, first of all, there needs to be a notice. As everyone knows, there needs to be a notice under 30B6, and it must be 20 days. So if someone comes into the deposition with a GoPro or an iPhone wanting to videotape, or if it's the plaintiff's paralegal, if they didn't provide notice, you can object on that stance, and I would say you not agree for the deposition going forward. That would be a basis. But if they did provide that adequate notice, they probably are allowed, because it's just not addressed under the civil rules. So let's go to our next question with regard to admissibility. And the question is the videotape deposition not using a legal/professional videographer admissible under the civil rules? So a little bit different in that if it is someone that's not a videographer, will it be admissible at trial? So let's see what people think on this one. And oh, I'm kind of surprised. We have 60 people that say yes, it will be admissible, and 40 people that say no. Well, I'm going to point you to a couple of civil rules. One is CR 28, which is disqualification of interest, which means that if you go to that civil rule, it states that under 28C, disqualification for interest, no deposition shall be taken before a person who is a relative or employee or attorney or counsel of any parties, or a relative or employee of such attorney or counsel, or is financially interested in the action. Again, you could probably, if it was noticed correctly, you could probably, I'm sorry, what I would do is, and a good practice pointer would be to do, is make an objection on the record that if they are going to videotape and it's going to be a paralegal or the attorney themselves, that you object, you note your objections on the record as far as CR 28. The other rule to cite is CR 30B8, which lays out what a videographer needs to do. And if many of you I know have been in video depositions and you have a videographer, you know how they say, wait, can't go off the record. We've got to do all these things and give the time. And even before they start that, I'm pretty sure the paralegal is not doing that. So again, you would make your objections for the record. And although there's no case law on this, I think you'd have a good method of keeping that out. One of the, it's interesting, one of the orders that have come out, we have all these emergency orders that have come out from the various courts. And this one came out out of Snohomish County on February 2nd, 2021. And it's interesting, they do address video depositions or remote depositions. And I've got the highlighted part, but it says, absent an agreement of parties, the only person permitted in the same, oops, sorry, I'm going to talk about that in a little bit when I go down to the second sentence. If a deposition is being video recorded, the recording shall be only of the witness and not of other participants in the deposition proceeding, and the same rules for mask wearing pertain. So, you know, it talks a little bit about following that CR 30B6, or I should say B8 rule. The other fact I wanted to also advise you of is, court reporters, they can't simply ask the court reporter to hit the record button either, because there is a rule or a prohibited practice by the National Court Reporters Association that they cannot act as both stenographer and as a videographer. So that would be another basis to object if they're having the court reporter just hit that record button in Zoom. And one other thing that you could do is, if they do record it and, it's again on the iPhone or the GoPro, send a request for production and, get your own copy of that video. So Brad, do you have anything that you want to add on with regard to videotaping of remote depositions?
No, I don't think so.
Okay. So we're going to talk now about, I wanted to talk a little bit, go back to, although Coreen Wilson this afternoon is going to be talking about presentation and technical tips. For example, I'm sure, I'm not a CAT judge, so be sure to check those filters before you go on. But I just wanted to give a couple of practice pointers for remote depositions. And I think we've got another polling question. I'm interested in fully remote depositions. And if Meg, if you can bring up the polling question number 5 with regard to being fully away from your client. So in the past year, who has taken a fully remote deposition where the deponent and the attorneys are each in separate locations? So not even, in the same office, but are in separate locations. How many people have done that in the past year?
And Laura, I think this question was supposed to ask not only for the defense attorney themselves, but if the plaintiff counsel was in a separate room from their client, if it was a
fully, everyone's in a different location. All right, what are our results? I'm curious. Our results are 4% said never, interesting. 1 to 5 times, got 43%, and more than 5 times, 53%. So a lot of people are taking fully remote depositions. It's my position, if you have a choice, if you're able to act within COVID protocols, try to be at least in the same office or the same location of your client when you're defending a deposition. And if you can be in the same room, be sure to have separate monitors. That was what I was going to, the sentence in that Snohomish County order, it talked about, if you are going to be doing a remote deposition, that each party and each person have their own monitor, which obviously is important because you don't want to have a view on the plaintiff and not be able to see his attorney who may be sitting across the table from them. And then also it states that, just the witness needs to be, whenever it is recorded, they need to be on camera. We had an attorney in our office who was aghast that they recorded it and caught her eating potato chips in the recording. So keep that in mind. Another practice pointer is that, you need to update your deposition outline. For example, be sure to ask, who is present in the room with the deponent. I had a deposition yesterday where of the plaintiff's wife and her husband was in the room. So there were some issues with that. For the record, you need to make sure that they advise you if anyone enters the room during the deposition. And ask if there are any applications that are open on the plaintiff's device. For example, you don't want them Googling or having the ability to Google answers. And then also ask about their surroundings. Do they have any records that are within reach, or they need, or that they may be referring to? Because again, you want to find out if they're, what sources of information they're obtaining during the deposition. And then my last little practice pointer before we go into discovery is, think about maintaining confidentiality when you're in a video deposition. For example, if you're in your office, be sure that you're looking to see, okay, if you've got a credenza behind you, like I do in my office, what documents are there and are they in view? Do you have calendars that are in view? Do you have case lists that are in view? Do you have things on a whiteboard that you that would provide information on your cases? Just be very careful that you're not, the view of your camera is not waiving any confidentiality. The other practice pointer is to be using that mute button. I know you may have to come in late with objections, but you just want to make sure, especially if your client is in a different area and you take a break, make sure, I always go into a different room and talk to my client just to make sure that no one is hearing us. And then with screen sharing, I've been on a couple of Zoom calls, not a deposition, where I've seen someone's Outlook and all the emails that they've received when they were trying to do a screen share. So again, close out all those programs and also be mindful as far as what you're naming documents before you click on them, because you want to make sure that that's not being seen also. For example, documents of plaintiff lying might not be a good category to name those documents. So just be mindful of that, can also be seen possibly by others that you don't want them to see.
Lori, Joanne Blockburn asked a question, I think kind of relating to your last discussion about, in terms of having, if the lawyer and the deponent are in the same room, if they have two monitors, then you cannot see if there's any sort of note sharing or coaching going on kind of off camera, which is a legitimate concern. It's sometimes nice to have the plaintiff and their lawyer, more of an expanded view where you can see both of them to see if there's any sharing going on. But this is just one of those situations. I don't think there's any rule about it, and it's maybe something that should be discussed beforehand as far as a deposition logistic stipulation, I guess.
Yes, and if you have concerns about opposing counsel, that is something absolutely you should talk about, the logistics as far as cameras. Obviously has been coming up in Snohomish County because they put it in an order as far as having each person on a camera. So, be mindful if you prefer that they be in the same view. The problem is if you're video recording, you probably need to make sure that, it's just the deponent and they may need a separate camera for that. And Jason, are we out of time?
We are getting pretty close. Yeah, we are a little bit over actually, but we can, we are going into a break, so you can take a couple minutes here and wrap it up.
All right.
So Brad, why don't you talk a little bit about objections versus motions for a protective order, and then we can run through our other two topics very quickly.
I don't think we can get through our topics very quickly.
I mean, under discovery, under discovery.
Yeah. I wanted to give a kind of another little insight on Eastern Washington as far as motions for a protective order being required before you can object, for example, to a discovery request for documentation. When I'm dealing with Seattle attorneys, I'm getting a lot of situations where, well, you've waived your right to object because you didn't file a motion for a protective order instead of just doing a standard objection saying we're not going to produce these documents because they're either irrelevant or for whatever purpose. Or for example, the 30B6, where you have questions that you think are objectionable and you don't file a motion ahead of time, but you just raise your objection during the course of the deposition. One good thing that is at least a little different here, I think, in Eastern Washington is I've never had a judge in a subsequent motion to compel, or maybe I filed a response requesting a protective order to that motion. I've never had a judge over here in Eastern Washington say you've waived that because you should have filed a motion for a protective order first to support your objection. I just don't see our judges doing that. I don't think they want to be bothered by it. But one thing we are starting to see a little bit more, at least in my personal practice, are the judges, since they're getting so overwhelmed, and will certainly be more so with the recent, I think, the State versus Blake case. They're looking at the option for discovery masters on more frequently. And I don't know if we want to get to that polling question on that point. Maybe that'd be a good way to wrap it up. But you know, judges, I think, are looking to remove the discovery disputes from their calendars, appointing discovery masters and giving those discovery masters very, very broad powers, including the right to sanction or award attorney's fees on discovery disputes. And quite frankly, I think some of those discovery masters would be more willing to do so than the judges are, who never want to seem to sanction plaintiffs' counsel for bringing these frivolous motions. Do we have that polling question up, Lori? Okay.
Sure.
So this one I'm really interested in seeing, especially the second one in terms of what types of cases. So please, who has used a discovery master in the last 5 years? Obviously, your options are there. And hopefully they've already voted. Can we get the results? Okay, 58%, so a lot that are still not have been used, but they are, you'll get some. They're beginning to come up more often. And let's do the next question that asks them what type of situations they're coming up. There we go. What are the circumstances? A complex case, multi-party case, maybe that's more often. How many times they're being judge ordered? All of the above issues or none of these issues? I realize there's probably some options that could be done otherwise, but I'd just be interested to see what the results are to this question. And Maggie, can we have the responses? I'm pretty much all over the board. Okay. None of those issues. The most recent one I've had is a very simple tort case, but the judge, after the third plaintiff motion for various either discovery compels or a motion for partial summary judgment, the judge had enough, and the judge was not going to deal with this anymore. So she gave us a choice of 6 discovery masters and told us we could pick one of those, and if we didn't get back to her in a week, she would pick herself. So.
And Brad, I just want to quickly mention another option. If you've got some thorny discovery issues, you can ask to have a CR16 conference with the judge and obtain a discovery order. So just, that's another tool in your toolkit as far as maybe if you want to avoid a discovery master, get a discovery order that a judge will issue if you see concerns with experts, the amounts of discovery, depositions, and so forth. And that's been a great help in some cases where I've had multiple defendants and or complex cases. So I'd like to say thank you and skip through to my last slide. Whoops, there we that says thank you.
Well, that's an important one. Let's get that up. There we go.
But thanks so much.
All right. Thank you, Lori, and thank you, Brad. I really appreciate it. We are going to take a shortened break, just 5 minutes at this point. So we'll, it's about 10:30, so we'll get back on at about 10:35. I did have a couple of points for the attendees. Unwritten materials. Lori and Brad referenced some materials that were not included with the set that you got earlier. We will be supplementing those materials to include the ones that Lori and Brad referenced. So those will be coming to you. With regard to materials sent out before we started today, if you're having any trouble accessing those, please just go ahead and email Maggie and she can send those to you. She did send out a link though, so hopefully everyone can access them that way. And Also, just an FYI, we have adjusted our settings so you all can log in from multiple devices, which means if you need to walk your dog or whatever, you can take the seminar with you on your phone and attend that way. So we'll be back in about 5 minutes with our next panel. Thank you.
Hi, Jason.
Hi, Maggie.
Hi, we're just waiting for our next speakers to come on, and as soon as they come on, we'll get going. There's
Okay.
Tom now. Hi, Tom.
Hello. Now, am I supposed to, while Ryan's talking, am I supposed to keep my camera on or turn it on when I talk, or what do you want? I'll do what you say. Just tell me what to do.
So I can tell you right now, Tom, that you are speaking to the audience. So there's 100+ people listening to your question, and that's great. So I would recommend that you stay on, similar to how Brad and Lori did it. Oh, Lori,
Okay.
you're back on. You can cut off now. Just similar to how Brad and Lori did it, that you both stay on, unless you are not planning on going back and forth. Is there going to be any back and forth?
There will be some.
Okay.
Basically, if I say something stupid, Ryan's going to correct me, and then I'll just like chime in every time Ryan's brilliant.
Okay, great. Well, because you're screen sharing, let's have you both on. But Tom, if you just get tired of your face on screen, feel free to cut your video, okay?
Okay. All right.
But I enjoy looking at both of you, so that'll be and I am going to stop sharing our agenda and core sponsor screen now and turn it over to you.
All right, thanks, Maggie. Our next presentation today is titled Business Interruption Coverage, Cybercrime, and Other Trends. And we have two speakers today. Our first is Tom Ahearne, who you just heard from. He's a principal at Forsberg Garvey. Tom has over 30 years of trial court and appellate experience, a little different than some of our other speakers today. His practice focuses on two distinct areas, and one of those is representing policyholders and claimants against insurance companies. The other is representing litigants in high-profile constitutional, statutory, and election-related lawsuits. Our second speaker is the counterpoint, I suppose, to Tom's policyholder point of view. Ryan Hesselgesser is a practice at Forsberg and Umlauf, and Ryan's practice focuses on insurance coverage, alleged bad faith litigation, and providing general advice to insurers concerning coverage disputes in both Oregon and Washington. So with that, I will turn it over to Tom and Ryan.
Thanks, Jason. So we're gonna split it up a little bit here. Tom, I think, is gonna focus a little bit more on the cyber coverage. We got two different presentations for you, and I'm gonna start with the business interruption, but hopefully we can have some insight on each other's kind of presentations. And hopefully everybody can see the presentation. So business interruption coverage, I'm excited to be presenting on an area of law that literally didn't exist a year ago. And so trying to develop expertise in this area and be coherent and presenting on it has been a challenge, because it's obviously in its infancy and we didn't expect to be here this time. So I think we were trying to come up with a link between cyber coverage and kind of business interruption for COVID. And really the common link is COVID. I mean, it's we may have seen, I think, as Tom will allude to, we've seen some increases in cyber crimes, maybe a lot of people on their computer more, sitting at home. So I think that, that would be the kind of the common theme. These are both emerging. We don't have a lot of case law yet in the areas. And so it's kind of up for grabs a little bit. So, so let's get into it. So here's an example of actually just a straight up form, typical form, ISO form business interruption. This is kind of what we're talking about today. It could be called business income, business interruption, kind of used interchangeably, but I've highlighted the elements there that you'd really have to kind of show on this type of form. It requires actual loss of business income due to the necessary suspension of your operations during a period of restoration. And then this is the big one. This is the one that most of the litigation has been about. Suspension is caused by direct physical loss of or damage to property at the described premises or the covered premises. So those are kind of the elements that you'd have to show in our business interruption coverage form. And that's kind of the nexus or the starting point of business interruption. And then we try to put a square peg in a round hole with how do we deal with COVID losses under this type of coverage. So just a brief primer, what is Washington law on business interruption prior to COVID? So 13 months ago, what was the law prior to any COVID losses? And I just want to highlight a few cases that I think are important, particularly given the later discussions on the later cases that we'll talk about. But there must be an actual suspension of business. The Keech v. Mutual Venum Claw case talks about that, and I think this is a really good case factually because it had to do with the shutdown or the alleged shutdown of a motel, and in fact, the motel didn't shut down, but it was in response to the Mount St. Helens eruption and specifically being covered in 6 inches of ash. And the distinction there was that the hotel remained open, but really their business loss was associated with decreased occupancy or decreased foot traffic. And the court said, no, you got to have actual shutdown, actual business income lost from the shutdown, or the suspension of the business. The form there was a little bit different than the one I just showed you. So, but I think it's instructive of how courts maybe had originally interpreted business interruption coverage. Period of restoration, obviously you need a period of restoration. And I think we'll highlight that later of how do you fit that into COVID losses from governor's orders that are changing on a daily basis. Kind of, and I'm sorry, I apologize for all the words, but I wanted to get it out there, but the direct physical loss of or damage to covered property, a lot of the cases dealing with that are actually in the context of homeowners policies, not necessarily business interruption policies, but some of the important ones, the Wolstein v. Yorkshire case, which was actually a builder's risk policy on a ship, the increased cost of completion due to builders' bankruptcy and faulty workmanship were not physical loss or damage. Basically, they cite, and this is important because you'll see this definition cited a lot in these cases, which is there was an initial satisfactory state that is changed to some external event into an unsatisfactory state. So I don't know if that's as clear as mud on what that means, but some people cite that for saying, well, there has to be some physical alteration to the covered property in order to be a covered loss. And the other important one is actually an unpublished decision, which is the Washington Mutual Bank of Commonwealth, the Commonwealth Insurance, and that one I think is important because it kind of mirrors the COVID losses, which is the building had to shut down, and there they actually made the exact argument that a lot of the insureds are making now, which is loss of use of the building, because there they had to evacuate the building, was the covered loss or was direct physical loss. And the court rejected that argument there and said there had to be actually some physical or alteration or some actually something physical. I think they relied on the physical aspect rather than loss in the general sense to just include loss of use of the building. So that unfortunately is an unpublished, from my perspective, is an unpublished decision. So, I don't know how much you can cite it. And I think people have tried to cite it in briefing on the cases so far. So I don't know how much weight the court would give that. But the other one that I think the courts, at least the two Washington decisions we'll talk about in a bit, have kind of keyed in on is the Nautilus v. Alliance case, which is a Western District of Washington case where they say deprivation of property without physical alteration may constitute direct physical loss of. One distinction there is that case involved a terminated employee actually absconding with a business license and a seal that prohibited the company from actually conducting business in China. And so the business loss related to the theft of company property was the issue. And as we'll see in a minute, I think that comes down to, was it permanently lost or was it a temporary loss? At least that's what I would argue on the insurer side was, a theft is still a loss because it was permanently lost. And so the court really said theft is physical loss of. I don't know if that's the same here, but at least the state court decisions that we'll see have kind of keyed in on that case, probably through the briefing and relied on that a little bit. So what are we talking about? Business interruption lawsuits. Here's kind of a chart. And I pulled this from, a lot of you may know.
Ryan, if I can interrupt just for a second.
Sure, go ahead.
What you're talking about with the physical loss, what's really important is to focus on the exact language in your policy, because a lot of these direct physical loss, is it physical loss of, or is it physical damage to or loss of? And as you know, and we're going to get into later, this, how it's worded, little words like or to, or of, make all the difference in the world.
Yeah, absolutely. So, and as we'll see in some of the cases, there is some different language there where the courts have found in policyholder favor because of that language. So this is kind of brief overview. These charts I pulled from the University of Penn COVID litigation tracker. It's a great resource. A lot of you may have looked at it. I'm not going to duplicate the wheel here, so I kind of utilize that. A but this kind of gives an idea of what we're seeing over the course of the last year and the lawsuits that have been filed. And as you can see, there was a big push early on. It's kind of tapered off now. And now we're getting a lot of those decisions on those cases that were filed earlier around the country. And this is around the country, by the way. And I think, as Galina mentioned earlier, there's over 1,500 lawsuits on addressing some form of coverage related to business interruption. Rulings on the merits, I think this is important, and you'll see in the cases that we pulled, the federal court overwhelmingly have dismissed the cases in favor of the insurer. And this chart kind of separates that out. Could be dismissal with prejudice, without prejudice. And only in a few cases you've seen where the federal courts have come down on a motion denying a motion to dismiss. That doesn't necessarily mean they've been granting summary judgment in favor of the policyholder, but they've been denying and allowing the suit to continue. So this is federal court, and as we can see, state court is kind of a little bit more of a crapshoot. It's a little bit more actually 50-50 on the decisions. So I think this is just a commentary on what you would get potentially in state court versus federal court. And I think for those of us who practice coverage, I think we kind of knew this already a little bit. And I think, from the defense side, from the insurer side, we obviously prefer to be in federal court. And it seems like statistically it's playing out in the decisions that we've seen. Sometimes you can't be in federal court, obviously, but you'll see that most of the decisions, a lot of the decisions that people are citing are state court decisions. And we have 4 of them, actually, I think, in this presentation that we'll talk about a little bit more detail. Types of coverage and dispute kind of gives an overview. Business income, the big one. Extra expense, civil authority. Those are kind of all wrapped up together. So a lot of those suits would include all 3 of those, at least the arguments on those a lot of the time. And then obviously there's a smattering of some other coverage issues. We're not going to get into a lot of detail on that. Liability, we haven't seen a lot of those come through. I think we've seen a few, but I'm not aware of anything significant on that issue yet. Liability, though, I think would probably be after these initial suits. Again, we're only about a year out, so we'll see. Industries filing suit, obviously restaurants, big one. Hospitality services, healthcare, storefronts. So this kind of gives a good overview. And if you guys, obviously the link down below will give you, you can go, you can't click on it, but we can provide the link. At least you can copy it. But if you want to look, there's more charts. There's a lot of more detail on this. That's a really good resource and that they've been tracking. I tried to start tracking the cases, and I think I stopped reading them in November, maybe. November this past year. It was just too much to keep track of for me. So I'm glad somebody else is doing it. So what are we talking about? What are the primary issues on the COVID losses? We're talking about, does the temporary loss of premises due to government orders constitute a covered loss? is it direct physical loss of or damage to? And again, going back to Tom's point, of and to can make a difference. What is the period of restoration for this? Is it just when the governor decides to open it up? Can you do something to mitigate the loss in the meantime? And that'll affect the damages if there's ultimately finding a coverage. Does the virus exclusion, pollution exclusion, or bacteria, fungi exclusion apply? Those are argued in a lot of cases. Most of the cases that we've seen, the court kind of just addresses them secondarily. The primary focus has been on this physical loss of or damage to element. And then the government authority coverage. I don't know that everybody has a good grasp on how to apply government authority yet on this. It's kind of just, again, we'll throw it in because the government told us to shut down. But, government authority traditionally has been where there's a loss to a neighboring property that forces you to shut down and you can't access your building. How do you fit that into the COVID world where they're telling everybody to shut down, right? So, Tom, I think you had something maybe.
Yeah, no, I was just going to say, this is another instance where you got to pay attention to the particular language of your policy, because a lot of these government authority coverages, they apply if the government shuts down your neighbor's property or shuts down of somebody else's property so they can't get to your property. So again, you just have to read the policy and see what, how the facts fit or phrase the facts to fit the language.
Yeah, and I think that there's probably some poorly drafted ones out there too that you can, government authority that you can argue are ambiguous enough to maybe get some coverage on that from a policy holder standpoint. So I think, again, like Tom said, yeah, absolutely. Make sure you're paying attention to the language. So we're going to go through some of the cases here. I'm going to start by two decisions where there's a finding and no coverage. There's a lot of decisions out there. They're all trial court. Most of them are trial court decisions. I'm not aware of an appellate decision yet, and it could change though. This literally, like, there could be one that came down as I'm talking right now. So, so we don't know. But this one, I pulled this one because I thought the reasoning, made sense, and it actually kind of dealt with some of the issues in the Washington decisions that we're going to talk about. Play and check downtown. And it's also been cited 14 times since it was issued, but the direct physical loss or damage to was the primary argument there. And the insurer argued that the term physical modified loss and damage requiring some tangible alteration, and the court held that that the insured's argument was actually unreasonable, where loss was intended to cover just generally loss of use or loss of the premises as that was intended to be used. And the court had some strong language that said that interpretation insured would result in a major expansion of insurance coverage and would be without any manageable bounds. And it cited actually three kind of examples of if you took it to its extreme, then that would mean any type of change in occupancy code, which would limit the amount of people in your business, would potentially fall within the loss of use of physical loss of use of language under that interpretation. Or maybe the city amends the ordinance requiring restaurants in residential zones to cease operations at a certain time. Maybe they got to shut down at 10 p.m. Does that mean they can make a claim then for the 2 hours because they're not able to use their premises as intended during that period? And then obviously a mass evacuation order for like wildfires or something like that. It was another example they gave. And so the court really, I think, took a practical approach rather than the literal interpretation of, oh, this language can be ambiguous. And so therefore we're going to side with. And they took a practical approach and said that doesn't make sense in this context. And so that was kind of the gist of that decision. And they really, they understood what the insured was arguing, but again, they said that would take it beyond the reasonable, manageable bounds. So.
And one thing that the insurance companies' attorneys did well in that is they did the parade of horribles, which is, okay, fine, maybe even if it is ambiguous, here's the parade of horribles that's going to happen, Judge, if you construe it the way that idiot policyholder wants it, construed. And that's an effective tactic that I hate it when you guys do it against me. So.
Yeah, I mean, there's a lot of practical aspects that you can argue on these motions. For example, the example I always give to people is, well, why doesn't an insurer just pay it? Somebody should pay it. I lost business. I lost my income, and I say, well, imagine, insurance is a risk-based product. And so imagine you insured everybody, that was driving a vehicle out there and they all got into an accident at the same time. That would be an unmanageable business model. And so that's what we're dealing with. Everybody got into an accident at the same time, assuming that it was an accident in the first instance. But that's kind of how we're trying to figure it out from a practical standpoint. But then here we're talking about the legal aspects and trying to fit it into to the existing case law and the policy language. So I think, like Tom said, that practical approach may be effective one way or the other. I think on the policyholder side as well, you can make a practical argument that maybe can get some traction. Sorry, what was the one? The next one was the Mud Pie v. Travelers case, and I put this one out there because the court actually agreed with the insured and said the loss of functionality could be a covered loss or loss of, but then took it a step further and said, yeah, but it's intended to only be permanent dispossession of the property or permanent loss of the property. And so there you'll see kind of the idea that a temporary one doesn't really fit, at least from my perspective, when I'm looking at this, doesn't really fit within the rest of the policy. For example, the period of restoration. One of the arguments there that was made was, well, the period of restoration is a time period in which the lost property or the damaged property could be reasonably restored, repaired, or replaced. And how do you fit those rebuild, restore, replace into an open-ended governor's order or local order that we have no time frame on, right? So a lot of the business interruption is the period of restoration, how long it took you to get back up operating, right? And here we don't have that because we don't know how long that's going to be, and it doesn't. Those rebuild, you got to use those terms: rebuild, replace, or repair in that context, and you can't really do it if you accept the argument that a temporary dispossession of the premises would be sufficient. So that's, I think, would be another effective argument. But again, courts can obviously disregard that, as we can see. So now we're going to move to kind of the decisions that kind of a couple of the big ones that came down in favor of coverage. The first one was the North Carolina decision, a North State Deli v. Cincinnati. And there the court, the term loss was actually defined to mean accidental physical loss or accidental physical damage. Again, I don't think they had that word "of" in there. That was kind of one of the distinctions, although the court didn't really key in on that. The language, I think if you were going to distinguish that case, you could potentially argue that. So one of the key points, though, and then we'll see this in the Washington decisions, the court concludes that physical loss and physical damage had to mean two different things. And so if you're arguing this on one side or the other, if you can come up with, okay, well, here's our reasonable interpretation of the two different meanings, one way or the other. If you're on the insurer side, I would argue, well, physical loss would have to be permanent physical loss rather than temporary because of the other elements in the policy, versus damage, which is something that could be damaged that isn't completely lost, but it would be repairable. I'm sure on the policyholder side, it means, well, it doesn't say permanent. So it could mean physical loss could be temporary, permanent. It's just lost. You lost the use of that covered property. So, that's where you kind of get into the weeds a little bit on this. But the court at least found that was ambiguous enough and granted actually summary judgment in favor of the policyholder. The court really didn't analyze the exclusions. There wasn't a virus exclusion in there. There was an ordinance and law exclusion, action or decisions exclusion, and delay or loss of use. And the court kind of just disregarded those. They just said, we don't think they apply. And that was the gist of the analysis. So if the virus exclusion had been there, or the actual virus exclusion, not necessarily a pollution one, or a bacteria or fungi exclusion, maybe that would be a little bit different. But at least that's one that policyholders score one for the policyholders on that. And there were 16 restaurants. So it was a pretty significant decision. Again, state court, North Carolina. So this one actually. They went so far in this one to actually call the insurer's interpretation of the policy as unreasonable, and that the only reasonable interpretation was the policyholder's interpretation. This is a casino losses of the tribe, the Choctaw Nation of Oklahoma. And one of the key things there too, and one thing that I think policyholders will probably argue, is that the pandemic itself was the event, or the fortuitous event to show coverage, and not necessarily the virus. They actually made a distinction when they were talking about the virus exclusion between of the virus and the pandemic. So you may see that argument again and again, that's saying, well, the pandemic itself could be somehow a separate event than the virus. And they disregard the virus exclusion because they said the virus had to be actually present there in order for the exclusion to apply. One of the things to keep in mind, though, that the insurer actually put in a communicable disease exclusion the day after the lawsuit was filed. So I don't think the court looked highly on that. And so that, you got to be careful at. Now, going forward from an underwriting standpoint, I'm expecting to see a lot of those now, to clarify this, or maybe a change in the language. But that's something to keep in mind, that why the insurer kind of got smacked down a little bit on that. The policy itself, one thing also to point out, the court distinguished the other cases from other jurisdictions on the COVID loss issue, because those policies used ISO forms, and the court actually referenced the of as a modifier to loss, and this policy with the tribe did not. So again, that distinguishing point, that may be a point of contention. What we'll see now, though, in Washington, is that there's only been 2 cases so far that have issued substantive rulings, state court decisions. And in those cases, they actually did have the ISO language with the of modifier, but they still issued decisions in favor of the policyholder. So maybe the Choctaw one hadn't come down yet. So maybe, I think these cases were first. The first one was the Hill and Stout, the mutual beam claw case in King County, and the court considered the term losses. The decisions, both these decisions, are actually they're a very basic, I would call basic interpretation of the policy. So they just looked at the term loss, looked at the Merriam-Webster's dictionary definition of loss, which included deprivation, and concluded that deprivation of the property was loss of the property. So that was essentially the reasoning in the decision. A couple things to point out: it wasn't a substantive grant of summary judgment in its entirety. It was a denial of the insurer's motion to dismiss in this Hill and Stout case. So whether there was a virus exclusion or other exclusions, that wasn't addressed. Other issues of, what is the period of restoration? Was there actual suspension? Those types of things obviously haven't been addressed. This was literally limited to an interpretation of the word loss or loss of as used in that direct physical loss of or damage. The second one was Perry Street Brewing, and I believe this was the Eastern District, or not Eastern District, but the Eastern Washington case. And the court actually granted summary judgment in favor of the insured. And there's a list of the decision is actually just drafted by the insured's attorney, signed off on by the court, and it lists a lot of findings of law in there. One of the ones, and I want to point this out just as an argument for argument purposes, but one thing the court said was one reasonable interpretation of direct physical loss of property at premises is the interruption of the business operations as a result of the proclamations. So there you have an issue of, the way the policy's structured, the business interruption has to result from the direct physical loss or damage. And here the court's kind of conflating them and saying, well, the loss of the business interruption itself is the loss of. So you don't have that causal connection there. You're just saying it is business interruption is loss of, not business interruption from the loss of or direct physical loss of. So that's kind of where I was trying to make sense of it. And I was like, well, that was an interesting finding to me, and it's actually signed off on by the court. So it's in, it's actually part of the order. So, but again, the court looked at the Nautilus v. Allianz case, but didn't really analyze this temporary versus permanent aspect. I think it may have been mentioned or brief, but the court just didn't address it, in the findings. Maybe because the policyholder attorneys drafted the findings, but nevertheless, the reasoning is very basic, and again, just kind of goes to, what is loss of? Dictionary definitions. Can it be deprivation? Yeah, so it's ambiguous. So one other thing one mentioned earlier, I think Galina mentioned, was a proposed legislative action. That Senate Bill 5351 was actually introduced because of these two decisions. And the bill proposed adding a provision that declared every property insurance policy containing a grant of coverage for direct physical loss of or damage to property shall be construed to include the deprivation of such property. So they want to change the language, or at least provide a guidance of how to interpret the language, I suppose is what you would say. There was a public hearing, and in fact, the University of Pennsylvania law professor testified there that put together the coverage tracker, testified in favor of the bill. But at this point, it appears to have died in committee. And I don't know if there's been further action on it since then. So I don't know. We'll see if somebody tries to resurrect it. But right now, it doesn't look like it's gonna move forward anywhere. So where are we at in Washington? I'll wrap it up here pretty quick. But two state court decisions finding direct physical loss of to be ambiguous and deprivation of property, a reasonable interpretation. No legislative action, no really clear determination on the virus exclusions or any of the other exclusions or government authority. No application of that key to the mutual union clause on the what is the period of restoration, or is there actual suspension there? I haven't really seen that issue come on any of these. No court of appeals, no Supreme Court decision. Majority of the other jurisdictions obviously are ruling in favor of the insurer, at least in federal court. And then there's consolidated federal lawsuits in front of Judge Rothstein in federal court, and there's a motion to certify the question for the Supreme Court in there. And I listed the two questions, and one to point out is the second one, which is one argument that policyholder attorneys have been making, which is, does the efficient proximate cause rule require a factual determination of the predominant cause before a virus exclusion can be applied? And I think it's to try to avoid rulings on summary judgment and saying, look, there has to be a factual trial on this before we can actually apply the exclusion. And so I think that that's probably the purpose of that. The briefing is still coming in on that, so we'll see if Judge Rothstein issues something on those probably fairly soon. I don't know, within the next couple months. Just final food for thought. Big takeaway from all this: permanent versus temporary loss. I think that is a key distinction on this loss of argument to be made one way or the other. Cause of, what is the cause? Is it decreased in foot traffic, or just less people attending your restaurant, or is it because you don't have the use of indoor dining? And then also mitigation, I think, would go along with that. Did you just shut down completely, or did you try to stay open for takeout, and delivery type of thing? Inability to use for the rented purpose or the intended purpose, but not for any purpose. Does that make a difference? Period of restoration, again, rebuild, repair, replacement necessary. How does that fit? virus exclusion, does it apply? Is it the pandemic is the cause, or is it the virus, or is it the governor's order? Presence of virus or employee with COVID. I can say that in reading the decisions, it seems like most of the courts would say if you actually had the presence of virus there or employee there and you had to shut down for that purpose, that may be a little bit more palatable as far as a physical loss. It seems that there's some commentary about that in some of the cases, although most of the cases aren't that. They're not addressing that coverage issue. So, and then liability coverage. What, is there something, that's obviously a whole nother can of worms, but something to think about. If, like, for example, you can't open your food truck or something because there's no more street fairs or something like that. Can you sue the city for a loss, and is that covered? So that that type of thing, you can probably see people reaching out to liability pockets as well. So I think that's all I got on this. I think Tom was going to kind of go over to the cyber stuff. So.
Okay, and now we're going to see if I can actually switch to share my screen. And since the way I've got this set up, I cannot see what's actually on everybody else's screen. So what do people see right now? Or Ryan, can you just tell me what you see?
Yeah, it's just the front page, the first slide. So
okay, good. So it's not like, all right. And here. And for some reason, I can't move the little thing at the top. Okay, on my screen, is it showing the thing that says you're screen sharing?
No, you're good. So.
I'm good? Okay, so
yeah.
I'm just gonna go ahead. On the cybercrime, the trends, and then the insurance coverage relief, what I wanna do is go through 5 points that Ryan and I have put together here. One, just talk about the general types of cybercrime losses. People say cybercrime, but what are those kinds of losses? I want to talk about, just to get it off the table, some non-insurance relief. Next, the general insurance coverage principles that are going to apply. Then go through about 6 cases with specific policy provisions that are implicated. And finally, the basic insurance related steps that you could take. So charging ahead, number 1, the general types of cybercrime losses, as Ryan mentioned, COVID has really been pushed this to the forefront, and this is something being emphasized by the FBI and other federal agencies as well. And cyber actors are doing a variety of things with this COVID pandemic. One is they're using the fact that we're all using these virtual environments now, which are just opening up our systems a lot more. 2, hackers, my personal view is a bunch of people are bored and they figured out they can make a lot of money hacking, et cetera. So they're now exploiting vulnerabilities in these virtual environments. People are, as I'm sure a lot of you are familiar with, engaging a lot more of these phishing expeditions, which are, the emails that get sent out trying to trick someone to click on something or respond to infect a system with a virus. These distributed denial of services, which is basically just overloading a company's insurance or computer system. Others are these variety of certain types of schemes, like these business email compromise schemes or BEC schemes. And what are those? Those are basically tricking people into allowing wires to go through, or wiring to the fraudster, the cyber crook, or whatever you want to call them. And there's been a dramatic uptick in these. Now, usually they're small, less than $130,000. But back in 2015, there were about 240 million nationwide. Last year, up to over 2 billion. And this chart also shows the state of Washington numbers as well. And prosecutors across the state are talking about and explaining how phishing scams are getting worse and worse. These ransom scams where people lock down or encrypt someone's computer or their computer system and then demand a ransom payment. The cyber charity scams with scammers saying, hey, I'm doing this wonderful thing with respect to COVID or that, et cetera, et cetera. And then supply scams, when people, especially earlier on, were desperate for supplies, those kinds of scammers. So basically what you have is a really big problem. Now, one thing I tried to do is come up with sort of a picture to, demonstrate, or just illustrate a really big problem. And at first I thought of, well, okay, how about that tanker or the cargo ship that got stuck in the Suez Canal? And I decided not to use that because I don't know how many people have seen this picture, but every time I see it, I think of this poor guy in the excavator that was sent out to try to fix the problem, and how he probably spent the whole day muttering how stupid his boss was for thinking that he could fix this whole thing. And so since I didn't want you all muttering about me, I'm not going to use that picture. Instead, I'm just going to go through the types of losses these cyber crimes are causing. One is you lose, and there are three distinct types to focus on when you then get into the insurance coverage part. Loss of the computer system itself, malware or ransomware, or these distributed denial of service attacks, which put in a virus or encryption, or they just overload the system. So you'll lose your computer system, and businesses lose the use of their system. Another is loss of information, where someone hacks in either by theft or trickery, or they disguise themselves as someone to steal your own information, which causes you damage because you have information on your computer that you need for your business, but also other people's information. And that's a big trigger, because if it's personal information of somebody else, like credit card information, or social security numbers of your employees, or things like that, passport information for travel agencies, things like that, that's going to trigger a whole host of federal and state laws with respect to disclosure, protections you have to pay for the victims, et cetera, et cetera. A third kind is loss of money. Cyber crooks take your money. They force you to pay them money. They force you to pay the victims money because, for example, cyber getting into credit card information, you're going to have to pay for the credit protection, credit monitoring, et cetera, for the people whose information was stolen. It also forces you to pay all sorts of remediation costs. So now, going into just this first level of what the computer, you lose your system by virus, encryptions, or overload, just a few quick examples of ransomware examples. And what a ransomware oversimplified is someone infects your computer and says, I've encrypted everything in it, and I will unencrypt it so you can actually use your computer if you pay me ransom. And so sometimes the ransom paid is small. Here's some examples from 10,000 to 600,000 paid by various people, and they cross their fingers, and actually the ransomer then released the system. Other times people do not pay the ransom, and that's what the FBI's advice is. And also a word of caution: if you're paying someone, make sure you know who you're paying, because there are also federal laws dealing with you. If you're paying to a terrorist organization or a suspected terrorist organization or someone that's on the naughty list, you get in big federal trouble. But here are two examples. Baltimore turned down a $75,000 ransom demand. They had to pay $18 million to get their computer system back up. Atlanta turned down a $51,000 demand, and they had to pay $17 million to get their system back up. So that's the types of virus, encryption, overload. Since I didn't have a good nautical picture with the Suez Canal thing, I figured I would go and make my high school English teacher proud that I actually read some of the stuff she made me read. Go back to the Odyssey, and the whole story from Homer, etc. And the loss of the computer system, these virus, encryption, overload, these are like the Lastrygonians, who are, remember, they're the folks that were throwing all the rocks, et cetera, on Odysseus's fleet, sinking most of it, killing most of his crew, et cetera, et cetera, et cetera. That would be the loss of your computer system. Now let's go to loss of information, a loss of money, either by theft or force. And that, again, my lame Odyssey example, that'd be like the Cyclops who breaks into your system, steals your information, steals your money, or forces you to do a variety of things. And the remediation costs, which I mentioned, those end up being a really big deal. And when you're talking about loss with the cyber fraud, people originally think of, at first they think of, okay, they've stolen money out of my account, or they've stolen this money or taken some of my sensitive proprietary information. Remediation costs can be the big thing. Some example of remediation costs, you're going to have to comply with state breach notification laws, federal data breach notification laws, international data breach. Some of the more complicated cases I'm working on right now, you're dealing with the EU rules, you're dealing with Asian rules. It's a mess. Various states have different identity theft and credit monitoring services that you have to provide if any personal information of anybody has been compromised. And there's a whole variety, like Delaware, California require you to give this to people for free, the credit monitoring, identity theft protection for 12 months. Massachusetts is 8 months. Connecticut is 24 months. It's all over the board. You have to pay for your forensic investigation costs, your security improvements. You have to upgrade your computer system. You're obviously going to be having to be paying defense settlement when you get sued. And then another litigation cost is often I'm representing several folks who are getting sued. They fell victim to paying, fraudulently the cyber crook, wiring the money payment to the wrong place. And then the person who actually deserved the money sues to get their money. You could file counterclaims against the other person, and that's a big expense too, based on how their computer system was not complying to industry standards, and Consumer Protection Act violations for not protecting consumer data, especially if you're one of the consumers, going on and on and on. And just for state data breach notification law compliance and state identity theft credit monitoring requirements, I've got a few cases in the materials, which, by the way, my materials will be posted on the website once this is done. I didn't get them finalized in time. But one is you do a state-by-state analysis of, and I have two cases quickly here. This is the Capital One case where over 106 million Capital One customers had their data stolen. There was a nationwide class action, but then also statewide subclasses of California, Florida, New York, Texas, Virginia, Washington, which brought a whole host of rounds of legal briefing on, for example, the economic loss rule, since they're negligence claims. It barred it in some states, but not in others. The data breach notification and consumer protection statutes in various states, all different. This is just a mess, an expensive mess. Another state-by-state analysis, this Martinez-Holden case is another example. And there are rounds and rounds of discovery on choice of law and what are you going to enforce the insurance policy's choice of law clause for, and what state law claims are you not going to enforce that. Also rounds of discovery over the variety of application of attorney-client privilege to adjuster materials, attorney materials, et cetera, et cetera, et cetera. So that just becomes a large mess. It's like a sinkhole that's going to drag you under. My last lame example, going back to the Iliad. This is like the whirlpool and that multi-headed beast, Cilia. This is just going to drag you down with the theft and the remediation costs, et cetera. So those are with respect to theft. The trickery, disguise, et cetera. There are a whole host of, and I cut this out of the presentation, but there are a whole host of things that folks can do, industry standard requires them to do to protect your system from being, or people that work for you, from being tricked into falling for one of these phishing scams, or just, it's as simple as clicking on the link that introduces the virus or the backdoor or something like that. And that is sort of like, some examples of these tricks are, using a similar email address. Oh, I'm really used to getting, emails from, ahearne@foster.com, but what if it's ahearne@fosd.com or something like that? Similar email address that the fraudster uses. Attaching a link that infects the system with a virus, or attaching a link that makes a backdoor so the hacker can get in and start doing things. And okay, I do have one more lame Iliad response. Remember when the sirens are very tempting, sirens when he's trying to get through the two rocks there, and he has himself tied to the pole. Well, that's exactly what a lot of these security measures are. And when you get sued often, it's, well, did you train your people well enough? Did you have the adequate security measures in place? And that's then going to also get into when you're talking about the insurance coverage. Are you is your loss because of something you neglected to do, some failure you did, or is it because of all this criminal act, which sometimes the criminal acts are going to be then excluded? So here we've got the various types of the computer system loss, the information loss, the money loss. Quickly, I want to go through some non-insurance relief. One is immediately contact the financial institution to see if they can block payments. Immediately contact the FBI to see if they can freeze payments. Immediately contact local police, which is sometimes important, especially for insurance, because some insurance provisions that would cover these cyber crimes require you to have a police report. So contact your local police, even though they probably can't do much to get that police report. And finally, immediately check your logs, lock down your system to make sure you don't have a repeat breach, which one of the cases we're going to be talking about has. I want to focus just on this FBI bit briefly, because what they can do is they can file criminal charges, they can hack into the hackers to figure out how to get the money back, and they can do bank holds really quickly. I had one case where the hacker knew that, or the cyber crook knew that we owed $6.5 million to a certain construction company. And long story short, our payment person emailed the 6.5 million to the wire transferred it to that cyber criminal, and getting the FBI involved immediately, reporting to your banks immediately, getting that local police report ended up working out well, because the FBI was able to freeze 5.5 of that million in various banks across the country before it went out of the country, notifying the financial institution froze. They were able to, that was our account, was able to freeze $500,000 of that, and then notifying the police, check the box for the insurance coverage to get the other $500,000. So you've really got to follow through with all of those aspects. Now, general and insurance coverage principles, we all know those. I don't have to repeat those. Here's just in the materials a list of the general rules we all know. Ambiguities, construe in favor of coverage. Exclusions, strictly construe against the insurance company. Duty to defend, the allegations, if they could conceivably be covered, it triggers the duty to defend. These are all just from a cyber liability and data breach case here in the Western District of Washington that summarizes those for everybody. Now to talk about some of the cases where some of these provisions have been implicated. This authentic title case, really briefly, the situation is they deliver loan proceeds from the mortgage lender, which is Quicken, and Brittany Clark at Quickens is their contact person. What's the method the cyber crook used? Well, he issued wiring instructions to the authentic titles president from a similar email address. Notice the right one is clark@quickensloans.com. What the cyber crook used was clerk@quickenloans.com. And that little bit, that's the trickery stuff I was talking about earlier. What happened? The loss? Well, the authentic title wired $500,000 to the cyber crook's account. Now, they then tendered under an errors and omissions policy. And what was the policy language at issue? Well, here it is. And the key element, that, at least for the policyholder, was, well, if it's a loss from a negligent act or omission, and golly gee, I was really negligent in wiring, not reading the email address correctly and wiring the information over. But the policy also had an exclusion that said, well, it doesn't apply to theft, stealing, or misappropriation of funds. And the policyholder said, well, theft, stealing, that's criminal theft, criminal stealing. Tried to narrowly construe what those words meant. So the exclusion didn't apply, and just the broad grant of coverage for negligent acts or omissions applied. And the court had none of it. They said, theft, stealing, misappropriation, that's not ambiguous. There's just no coverage. Second example, this Ernst & Haas case. Similarly, the situation, they're a property management company, they pay invoices, the managing broker has a certain address. What did the cyber crook do? Well, he sent an invoice to the accounts payable clerk from a similar address. Here's what the right address was. Here's what the cyber crook used. So what ended up happening, that clerk wired $200,000 to the cyber crook's account, and then they tendered under a commercial crime policy. And it had two provisions. One was a computer fraud provision that paid if it resulted directly from the use of any computer. Another was a funds transfer provision, which covered losses resulting directly from a fraudulent instruction. What did the court do? The court said, well, you know, there's sparse binding legal authority, so we're sort of going to wing it as we go along. And you'll notice that in all of these cases that, you know, in our materials here, they're all from the last 6 months. I mean, this is like the COVID with the business interruption, something that's just exponentially growing now. So what did the court say? The court said, well, there's no computer fraud coverage because going on this resulting directly from the use of any computer. Well, it didn't flow directly from the use of the computer. It flowed from, well, the clerk doing the wrong thing. And there's no funds transfer fraud because it didn't result from a fraudulent instruction. The instruction from the clerk wasn't fraudulent. The instruction from the clerk saying transfer the funds, that wasn't fraudulent. That was the employee did it. And so that wasn't a fraudulent instruction, so there's no coverage. Third example, this Landry's case, they're a management company and they stored electronic credit card information for all the payments on his properties. And they're processed by JP Morgan Chase and a bunch of other banks. What did the cyber crook do? They hacked into the account and got all that process, millions of customers' credit card information. And that credit card information is personal information under various state laws. I mean, that's private personal information. What was the loss? Well, the credit card companies and the banks, they sued Landry's for over $20 million. You know, their losses from this situation. And so Landry's tendered it under their CGL policy. What was the policy language? Well, the policy language is language we're all familiar with. It covers personal injury and advertising injury, with it being, you know, publication in any matter of material that violates a person's right of privacy. So the policyholder said, well, it was publication in any manner. Well, the data was let out and it did violate the personal information. So that's personal right of privacy. And so there should be coverage. And the court said, no way. First, there's no publication because in this, they construed publication to mean something you knowingly do. And they said, well, you know, the hacker stole this information, so it wasn't a knowing publication. But the stronger argument was there was no privacy damages because what the court said is, this isn't an invasion of privacy in your typical common law sense. This is what happened here. What the policy at Landry's did wrong is they didn't follow industry standards on what you do to lock down and secure your system. If they're finally, or next example, this Mississippi Holdings case, MSH is a metal silicone medical manufacturer. What did the cyber crook do? They broke into and accessed the email system. So they were sending fake emails back and forth between MSH and its supplier. And one of those emails said to the CFO, hey, here's our newest wiring instructions and here's an invoice, you know, send it to us. The CFO wired the $1 million to the cyber crook's account and they tendered it under their commercial crime policy. Running really short on time here, so I'll just go through quickly. There were two kinds of coverages. One had a $1 million limit, another had a $100,000 limit. One is for transfer fraud and the other is for social engineering fraud. And so what did the insurance company do? They paid the lower limit, social engineering fraud, and they denied under the transfer fraud. What the court said is, well, there's no computer transfer fraud because just merely receiving an email isn't computer fraud. And so you're going to get into these policy distinctions or arguments about, well, what is consumer or computer fraud under the language? And the court also said there's no computer transfer fraud for another reason, in that it required the fraud scheme to transfer funds without the insured's knowledge or consent. And here, the employee got duped and he did wire the number or the money with their consent. So it didn't technically fit the language of the policy. This underwater kinetics case, it's a scuba diving gear company. There were three, I mentioned earlier, sometimes you have multiple attacks. There were three malware attacks. separate types, encryption, infection, and then getting in and actually running the system with the local administrator. It costs over $350,000 to fix the problem of each of those 3 malware attacks, and it was a building and personal property coverage. There was endorsements, and their endorsements are important. There was an e-commerce endorsement that covered these kind of malware attacks for any act, event, or cause of series of similar acts. There was an extra expense endorsement that said, hey, any money you have to pay to restore your operations, we pay for that. There was also an anti-stacking clause, which basically said, hey, Mr. Policyholder, you got to choose. If there's more than one thing that might cover you, you got to choose one and only one. What did the court say? The court said, well, that anti-stacking provision requires you to choose between the e-commerce coverage and the extra expense coverage. Since the e-commerce coverage had the higher deductible, obviously they chose that. And then what was going to trial then was going to be whether these 3 attacks were similar related acts, so only one limit applies, or there were 3 acts, so you got 3 limits. Last one is this Target case, which a lot of people have heard of, but just last month, the final, or the decision, at least from the trial court, came out. Target stores personal credit card payment data. The cyber crook hacked in and took that data. The losses were the banks that issued those credit cards said, hey, we're out a lot of money. And for example, we had to cancel cards, reissue them, we had to pay a lot of things. So Target paid a confidential settlement amount on those banks, and they tendered it under their CGL policy. And it was focused on those credit cards because the policy covered, bodily injury and property damage, with property damage defined being loss of use of tangible property that's not physically injured. So people lost the use of their credit cards, that's physical property, but it wasn't physically injured. And so they said it was covered. And the court said not so quick. And what the court said is loss of use damages must be based on the alleged loss of use of the credit card. But Target, they failed to show that its settlement payments were for the loss of use of the credit card. They were payments for consequential damage, resulting damage to the banks for having to reissue things, having to make payments, et cetera. That was a lack of proof to track the insurance coverage language. So getting to the end here, what are some basic insurance-related steps to take? And there are basically 2, and they're things that we all know. 1, get a complete copy of all the potentially applicable insurance policies. I say complete because as we went through some of these cases, endorsements are important, as well as the main body that a broker will sometimes think has nothing to do with this, so they won't even give it to you. Get a complete copy, and then of all the potentially applicable policies. As we went through those prior cases, there are E&O policies, CGL policies, there are criminal crime policies, all kinds of special policies, get them all. And second, read and understand the fine print. Because 1, you have to know how to phrase your claim. I have one quick example here. Another case where I had where the insured was going to, they had been snookered by one of these, phishing scams, and they were wiring money to the wrong place. And they were out several $1 million, a little over $1 million actually. But they originally were going to tender as theft of money because they had theft of money coverage. And I convinced them, no, you tender under the employee failing to faithfully perform duties coverage because of the limits. If it was theft of money, they'd be limited to 500 or limited to 50,000. If it was this failure to faithfully perform your duties, like faithfully follow the protocols on wiring funds, you had $1 million. So you got to phrase your claim correctly. You have to know how fast you give the insurance company notice, because that's one of those things where they can say, hey, we were prejudiced, you didn't tell us quickly enough, you didn't tell us so we can go to the FBI, go to the banks, go to these other things to block the money from getting out of the country. What kind of information do you have to give the insurance company? We're giving, just also with the business interruption, we're getting now laundry lists of information you have to give. And if we don't give everything, we're being dinged for, well, you didn't cooperate. So you want to make sure you're cooperating, giving the information that's required. And then this last thing I've mentioned now too many times, sometimes you have to report to police just to trigger your cyber coverage. Even if the local police aren't going to actually be able to do anything, that's where you're at. And I think I'm done.
So, yeah, just Tom, real quick, one thing.
Yeah.
The thing about getting all of your policies, I would say that applies to the insurers as well. So many times I'll get a claim and under one policy, and then I'll ask about other policies and 4 or 5 will come out. So it's important for the insurers to look at all available coverages as well, to the extent it was tendered under broadly. And sometimes there'll be E&O policies or something that you didn't even know about. So.
Yeah, and that's why, you folks who've actually received my requests and my tenders before, I will generally say something like any and all policies issued by
Right.
XYZ company, as opposed to a lot of other folks simply say under policy number, 1, 2, 3, 4. I don't want to limit myself just to that, because Ryan, you're right. I want, if there are other policies which I frankly don't know about, I want that carrier to be, looking at them all.
Right.
Okay, Jason, I think we're done, and we went over just a little bit.
Just a little bit. That's all right. Thank you very much, Tom and Ryan. Really appreciate it. Our next panel is entitled Keodalah Ethics and Trends and UAM Discovery and Bad Faith Cases. We have 2 presenters for that topic. First is Pam Reppart. She's a shareholder at Forsberg and Umlauf. She's a Northwest native and a double University of Washington graduate, and her practice focuses on civil litigation defense, insurance coverage, and bad faith. Those are among the areas that she handles. Our other presenter for this topic is Geoff Bedell. Geoff is a shareholder with Soha and Lang, and his practice focuses in the area of insurance law, of course. Geoff was I want to give him a shout out. He was a chapter co-author of the Washington Insurance Litigation Practice Guide in 2014, and also the co-author of the Washington Supreme Court Gives Insurers the Bird art piece in Defense News in 2013. And Geoff was nice enough to come back and speak again about Keodalah and kind of update us on what's happened in the last year. So we are running a little bit behind, so we will go ahead and go into the lunch break a little bit as well, potentially, depending on how much time Kim and Geoff need, but by about 10 minutes or so. And with that, I'll turn it over to Kim and Geoff.
Okay, my first question is, can everybody see my presentation? Can somebody please answer back?
Yes.
Yay. Okay, I've done screen. That's my first screen share my whole life. Basically, Kim and I this is sort of a panel where it's not really a panel. We're doing 2 completely different things. So sort of mini presentations. I'm dealing with Keodalah, and Kim is dealing with a discovery in UIM. So we agreed I would go ahead first, and at some point, Kim would rudely interrupt and tell me to stop talking, and she'd take over. So we're waiting for that interruption. Start out, and as Jason mentioned, I actually talked about this last year, and it was right in the aftermath of when the Keodalah decision had come out, and it was right in the aftermath of a lot of consternation and concern about the impacts of that decision. And we all breathed a sigh of relief. So what I'm going to do today is do like I said, a quick recap of Keodalah for anyone who either forgot or was never heard about in the first place. And then the idea is I'm looking at sort of how that is playing out effectively in trial court decisions, and mostly in the context of federal jurisdiction, actually, in federal courts going forward since that decision. Basically, Keodalah, again, in case anybody forgot or didn't hear, had to do with the fact of whether or not an insured could bring direct bad faith claims and direct CPA claims against the adjuster personally. It was undisputed that they could, of course, sue the insurance company under these very theories. That was never at play. And the concern was, well, you're suing these poor people who are earning on average, something like $70,000 a year, according to some of the MECAS briefing, and have, multiple files. And now they're personally liable for each and every file they're working on potentially. So that was the backdrop. The backdrop of the Supreme Court's decision was the Court of Appeals. And basically all these claims against the adjuster were dismissed at the trial court and went up on a discretionary review on a 12B6 motion. And this is kind of sort of what the Court of Appeals did. It looked at RCW 4801030. I should note that that's a general kind of policy statement with respect to the insurance code, saying that business of insurance is one affected by the public interest, requiring that all persons be actuated by good faith. So it looked at that broad language and said, yep, you get to sue an individual adjuster because it applies to all people. Adjusters are people, therefore you've got a cause of action. It also ruled that a per se cause of action could be brought under the CPA. And just briefly, per se CPA action means that you can base the CPA action on violations of the insurance regulations. A non-per se action means you can't do that. The non-per se is more difficult to prove. And so I'm going to be mentioning those here, and that's the difference. Went up to the Supreme Court, and as it says here, Justice Madison wrote the majority opinion. It was a 5-4 decision, so it was close. The court held that there was no implied cause of action under that statute I mentioned. Now, importantly, what it did was a Bennett v. Hardy analysis, and that simply means that there's a factor test to determine whether or not there is an implied cause of action in a statute when the statute doesn't say there's a cause of action. It went through that analysis and determined there was no statutory cause of action. It also held there was no per se CPA claim, the reason being that the regulations on which that would be based are focused on insurance companies, and the adjuster wasn't an insurance company. Now, what it didn't do, the majority that is, was deal head on with the common law theory of bad faith. I mean, one not based on the statute or based on a theory that, you know, there's an implied cause of action in that statute. And this has become the significant point here. There was a lot of dicta suggesting strongly that the 5 folks in the majority didn't think there was a common law cause of action, but again, they didn't flat out say it. And I have here this quote. This is from the majority opinion. I bring this up because whatever the court said about anything having to do with a relationship, the one thing they said importantly is that the someone here being the adjuster was outside of the quasi-fiduciary relationship. So this is actually in the text of the majority. I think this could be important going forward if anybody's facing this common law question, because it says here flat out that the adjuster does not have a quasi-fiduciary relationship. And if you look at some of the jurisprudence, including some of the cases like Tank cited in the footnotes, courts have looked to the quasi-fiduciary relationship in defining bad faith under a common law theory. So that might be something useful, who knows. The other thing is it's pretty clear from the majority opinion that one can bring a non-per se CPA claim. In other words, proving all 5 factors under Hangman Ridge against an adjuster. I say that because the court cited Merriman favorably, and Merriman had held, that's a Court of Appeals decision from Division 3, Merriman held you could bring one of those. Importantly, there was a real long dissent by Justice Yu, joined by 3 other justices, and it made a strong case for a common law bad faith claim against the adjuster. And that was really, if you read the opinion, that's where all the talk about common law bad faith was. It was all in that dissent. The Keodalah opinion was issued in, I think it was October, November of 2019. Since that time, there have been 2 retirements from the Supreme Court. Justice Wiggins, who was in the majority, is now gone. And then Justice Fairhurst, who's in the dissent, is now gone. So whatever was meant by the majority, frankly, doesn't matter anymore because the majority is no longer there. So this issue will, of course, be decided by different people sitting on the court, assuming it gets up there again. Just out of curiosity, I wondered what happened to Keodalah on remand when it went back down, because it was remanded to the King County Superior Court. And I pulled the docket, and strangely enough, there was actually an amended complaint that was filed when it was back down on remand. So they'd already lost up at the Supreme Court, and they're going back down. They amended the complaint to add the proper Allstate company. They had initially sued the wrong company. But in amending the complaint, they did not drop their claims against Smith, and Smith was the adjuster's name. They also kept Smith in the caption, which I found to be very odd. I actually called up one of the attorneys of record defending Allstate, and he basically explained that push had never really gotten to shove on the inclusion of Smith, but they were they had as much consternation as I did seeing claims were still live against Smith, and that was something that would have been taken care of. It never was, however, because I recently settled in February of 2021. So in the aftermath of Keodalah, there were a series of questions, and they would include things like this. Is there a common law duty of bad faith theory against an individual adjuster? I mean, could you sue adjusters? What about adjusting companies that are retained by an insurance company? Are there other people that you can bring in under this common law bad faith theory? This is actually a slide from the presentation of last year. It's slightly old news, but it's important news. These cases were pending. They had already been filed. These are obviously trial court dockets cases. That had been filed while the appeal was pending in front of the Supreme Court after it had been issued by the Court of Appeals. And in these cases, which basically I don't think went too much farther than complaints, except for one that I'll talk about here, they asserted Keodalah style bad faith claims in the Blackwell case against a broker, and in these other two, Scudder and Sharp, against coverage counsel. So the counsel representing the insurance company. And as you can see here, the Blackwell case, the broker case, that was dismissed, settled and dismissed. Same thing with the Sharp case. Interestingly enough, is the Scudder case. And what happened is the claims were dismissed, and I can't recall if they were dismissed on a motion or on a CR 41 voluntary dismissal, but the attorney in that case, coverage counsels, in that case, moved for sanctions against the plaintiff's attorneys and was awarded CR 11 sanctions in that case. And so that was a pretty resounding emphasis, at least by this court, as to the veracity of such claims. That gets to the sort of circling back to the ethical question, and this came up when the appeal was pending, and it had to do with making claims directly against insurance companies' coverage counsel. And the concern was, and again, when you had those cases like Scudder and Sharp pending while the Supreme Court's decision, was pending as well, what on earth could a coverage counsel do if coverage counsel was potentially faced by a quasi-fiduciary duty or some kind of common law bad faith or statutory obligation to someone who was not his or her client? And this is, this is sort of pretty clear black letter law from this case, saying that, attorneys cannot have divided loyalties. They got one client, they've got to serve that client within the realms of the rules of ethics. And so that was poised in front of the state Supreme Court. In fact, WDTL did some briefing on that out of the very concern of these cases being filed and the very concern of any kind of ethical problems that could arise. Now, of course, the Supreme Court didn't have that issue in front of them. The ruling was certainly favorable. The Scudder decision is favorable, but so it appears at this moment that these ethical concerns are probably a dead letter if they ever were truly there, because of the recognition that the Supreme Court had, at least to date, of no claim against the insurance company's adjuster. Now I want to move to some other decisions that have come in the aftermath. And I sort of a disclaimer here. Basically, this is me looking for stuff on Westlaw. So I'm not going to guarantee that every case dealing with this issue is in here. Particularly, it's particularly difficult for me in any case to find state court decisions. And so the pattern you're going to see, at least in the things I'm presenting, are cases in federal court that get kicked out and remanded back down to state court. And that tends to be the procedural posture in these cases. This Leonard case had actually come out last year by the time I was doing the presentation. This was a fire loss case. And you can see here, it says the target was the adjustment company, Crawford & Crawford, and its local adjuster, an individual named Johnson. And what happened was it was filed in state court. It was removed to federal court. That's my mom calling. I just had to hang up with my mom. Anyway, it was a motion to remand, right? And the reason is because Johnson was a local adjuster. And it was granted, as you can see. And what the fight over was fraudulent joinder. And basically fraudulent joinder says you can't join a party to destroy diversity jurisdiction. But the claim for that is quite high. One court has said it's, a quote unquote high bar. Another way of looking at it is the showing's pretty light to show that there isn't fraudulent joinder. And basically, and it goes through it pretty well in the Leonard case. So if anyone's curious, go read the Leonard case. But really, is it possible for a claim to be asserted? Is more or less what they're not ruling that a claim in fact exists, but could it possibly exist under state law? And so this was Judge Layton, and this is what Judge Layton said looking at the Keodalah decision. He said, well, they dealt with the statutory cause of action, but they didn't say anything about the common law duty of good faith. And they also noted that it only addressed the per se CPA violation in its opinion and not a non per se. And so the court held there was no fraudulent joinder and remanded it back down to the state court. And it was in Pierce County. Now, in Pierce County, there was actually a ruling. And if you can see here, and this is a quote from the trial transcripts, these were subsequently filed in the federal court, which is how I got them. It says, I am finding as a matter of law that Johnson, the individual who works for the adjustment company, had a common law duty of good faith. And the court declined to make a ruling on the non per se CPA claim. So we have a trial court decision now saying that you can sue an individual under a common law theory of bad faith in the post-Keodalah world. Interestingly enough, that case appears is going to stand. I mean, it's never going to go up on appeal because, strangely enough, this case actually went back to federal court, and it went back first to Judge Layton, and when he retired, it went over to Kuhnauer. And what happened was they amended the complaint to add a class action, and that tripped the Class Action Fairness Act. The insurer ruled a second time on that basis, and then the plaintiff again moved to remand it, and this time it was denied. And then this is recently settled in, according to the docket, in January 2021. So that case is sitting out there, that oral decision, and it's not going to be a subject of appeal. This is another case. It has to do with water damage. This was interesting because who the target was. It was Madsen, Kneppers and Associates, MKA is what I always call them, and also an employee there, a guy named Northall, who was local. He lived around in Washington. And again, as you'll see time and time again, these cases tend to have to do with jurisdiction, the fact that the plaintiff wants to add somebody who's local to defeat diversity jurisdiction and send it back down to the state courts. This one, however, was slightly different because when it was removed, the insureds did not move to remand or oppose removal. Instead, a summary judgment order was filed, and the court then issued a order to show cause of why is there diversity jurisdiction if you've got a local guy, Northall. In response, the carrier argued fraudulent joinder. The court rejected it. Again, this is we're in the world of possibility, looking at fraudulent joinder, and you can see here that again acknowledged, this was Kuhnauer, that basically the Keodalah majority didn't say anything about it, and notably, Kuhnauer looked at the dissenting justices and noted that they sure were talking about common law bad faith. So it went back down on remand. And so it goes back down to King County. And interestingly enough, earlier this year, the court granted summary judgment in favor of MKA and also Northell and dismissed the claims against them with prejudice. And so it junked all those claims that you can see in the next bullet point. So we now have a ruling, thankfully, that holds that, oh, by the way, MKA is essentially, it's a consulting firm, an expert consulting firm. They got architects, engineers. They do, this is probably a cost estimator who is looking at the claim costs under a first party claim. So these people are retained by the adjusters to help them with technical issues like costing out, repairs. And then they are not adjusters. So thankfully, this decision got rid of those claims. Another case, this is a property theft case. Interestingly enough, that the claim is against an insurance agent, a local insurance agent. And this was in federal court, and it was a motion to amend the complaint to join said local agent. And the court held that the joinder was not futile, among other things. And so here's what the court said. Importantly, again, the posture here is a motion to amend a complaint under Rule 15, right? So they're looking at various things like prejudice to the other party, things like that. Was there any kind of delay? The one interesting here, though, is futility, right? And the court is effectively saying, well, I can't say it's futile. So they're not saying it's a real life claim. They're just saying they can't stop it on a futility basis. So it was granted, the case got remanded to Clark County. Last I checked, there were no rulings or any developments. Here's a case which was fire loss. And the target on this was an adjustment company. So it was like Crawford and Crawford. It was one of these companies that is retained by the insurance company to do kind of the boots on the ground adjustment. And again, this was a motion to amend a complaint under Rule 15. And again, the court was looking at futility, among other things, in assessing whether or not to grant the motion. And again, this is Leighton, who's ruled, he did Leonard. And so he said, look, I've already said it several times in the context of, removal that Keodalah didn't rule these out, and he ruled the same here. Interesting enough, this was not brought to defeat diversity. And so it's still in federal court. You'll note Lasnik is now on the matter because of Lane's retirement. And the adjustment company moved for summary judgment in recently on March 15th. The court, Judge Lasnik, granted summary judgment, and it did so under the borrowed servant doctrine. And frankly, I would have never thought of this. I thought this was very interesting. The argument was basically, and you can see in the blurb there, that State Farm effectively controlled the employee, that employee being the employee of the adjustment company, Greer. And so the de facto employer was State Farm, the insurer, and therefore the claims were dismissed against the adjustment company. So the adjustment company got out of that under a theory that hasn't been addressed to my knowledge in the prior cases dealing with adjustment companies. We have just a few more here. This is, again, another local adjuster. It's another motion to remand. And again, there was a holding of no fraudulent joinder. This case is settled and has now been dismissed after it was remanded to state court. A similar case, again, with a local adjuster. This was, again, another motion, Rule 15 motion to amend the complaint to join the adjuster. And this surprised me. This was a magistrate judge, Crystal. Judge Crystal denied the motion. And basically it said here, and this is a blurb from the opinion, that the record shows that the insured's true purpose was to defeat the court's diversity jurisdiction. And that's noteworthy, at least to my mind, because frankly, as far as I can figure, every time a policyholder council is bringing in a local adjuster. The whole point is to defeat diversity, because you don't need the local adjuster to get the remedies you need to recover against an insurance company. Adding a local adjuster doesn't do anything in terms of your remedies. It doesn't do anything in terms of deep pockets. What it does is it destroys diversity. So that's the first time I've seen something like this where a court actually cared about the actual intent in destroying diversity. So we're getting to the end, and that leaves us as to where we are now in terms of a recap. That Pierce County case indicates that common law bad faith theories are still live against adjusters, potentially. The MKA case, where the claims were dismissed, shows that it might be kind of sort of difficult to extend that to somebody like a cost estimator who's an expert consultant. You've got the case against Merriman was a case against a third-party adjustment company. And you're going to have live claims against third-party adjustment companies, potentially, though there was that case where, as mentioned, they dismissed the claims based on the borrowed servant doctrine. There's also the case with that insurance, it's Hale, H-A-L-E, the insurance agent. And that case kind of bugs me because it's an insurance agent. That seems to me like, why would you have a bad faith claim against an insurance agent? Also, you don't really need one because a policyholder would already have a standard, negligence claim against an insurance agent anyway. In the Hale case, the agent was an employee of the insurance company. So this was somebody who, at least according to the court's text, was in fact an employee. The company was Country Mutual. To my understanding, Country Mutual's sign was on the door. So this is not somebody who was some kind of independent broker or agent out there. That being said,
right. Hey, Geoff, I have a question for you.
Oh, okay. My whole screen's blocked, so I can't. You're gonna have to read it to me.
All right. So this is from Garrett. He says, "Do arbitrators count?" Oh, here we go. Good to see you, Geoff. Based on recent decisions involving Whitener and Montoya, do you believe it's probable direct causes of action against adjusters will be reinstated?
Yes.
We might be talking about that. Yeah.
Yeah, I think it's probable. That would be my gut on that. But the other thing that's important to note, though, is by the time one of these gets up to the state Supreme Court, I mean, chances are there are going to be other changes on the court. So we'll just have to see who's up there at the time. But I certainly think it's possible with the additions we have in the court to have that be changed.
All right, you ready to talk about UAM? Thanks, Geoff. So I guess I'm the second half of here's how we're going to terrorize you now. And I know all of you are probably hungry for lunch, so this is probably not the best time to hear about UIM and UIM discovery. My name again is Kim Reppart. I'm at Forsberg and Umlauf. I do half my practice is third-party general liability defense, and the other half is insurance coverage and insurance coverage litigation. And I have an emphasis in UIM and UIM bad faith. And one of my colleagues here likes to call UIM a minefield. So I'm going to talk about a minefield within a minefield, which is the application of attorney-client privilege and the work product doctrine to the claim file. All right, so can everybody see that? Can you see that, Geoff? Yes, all right, great. All right, so I'm gonna go a little bit fast because I know you all wanna get to eating. But I want to end up talking about some of the more recent decisions we've seen out of the Court of Appeals, which perhaps have put trial courts in a bit of a confused position about what should or should not be produced from a UIM claim file. I will spend a brief amount of time talking about the purpose of UIM and just how it is different from other first-party claims. And then I'll talk about the pre-litigation UIM claim file, but most importantly, I'll talk about the post-litigation UIM claim file. And when it comes to UIM, this is going to be old hat for some of you, a good reminder for others. But most importantly, I find that insured's attorneys often misunderstand what the duties are that the UIM carrier owes to its insured. So it's a good recap. The main case is Ewing. I'm sure you're all familiar with this case. I wish I had time to do a deep dive on the facts and why it was later overturned on other grounds, but the most important part is what the Supreme Court had to say about the UIM insurer-insured relationship. The most important thing is that it's adversarial by nature. UIM is a floating layer of insurance coverage over the tortfeasor's coverage or lack of coverage. And the whole idea is that the UIM carrier steps into the shoes of the tortfeasor and their liability should be identical. And so what does that mean? It means the UIM carrier gets to defend. And what the Supreme Court said was that the UIM insurers are allowed to assert liability defenses available to the tortfeasor. I know that there are some judges, or at least one judge, who thinks this might mean that UIM carriers are not allowed to assert damages defenses, but that's a whole different presentation for another day. The big picture is the injured party is not supposed to be placed in a better position just because they were struck by an uninsured motorist than an insured motorist. For you conversing with opposing counsel about the duties a UIM carrier owes, the big picture is that tank does not apply in the UIM scenario. There's no enhanced obligation to be insured. There's no quasi-fiduciary duty to put your insureds, to give equal consideration to your insured's interests. And that is because UIM is adversarial. And that means that the insurer is free to dispute the case and defend the case within the confines of the normal rules of procedure and ethics. So remember that, it will come up later. There is, of course, still a duty of good faith. It's not the Wild West. The duty of good faith and fair dealing survives. So the whole idea is to have a fair playing field, a good faith battle, and a fair fight. So that's the background. That's what UIM is supposed to be. And traditionally, you know, the carrier looks at the information, does an investigation, evaluates the case, extends an offer. But what happens when things go south and the insured says, nope, I disagree with you. I don't think you're being fair with me. I think your investigation was in bad faith. I'm suing you. And now I want a copy of your claim file, including all those emails back and forth between you and that attorney you hired in the middle of this process. Well, what gets produced once you're in litigation? Typically, of course, the UIM claim file is what's at issue, and you can only hold things back if you can apply the attorney-client privilege or the work product doctrine. And where do we start? So, as you know, insurance bad faith first-party cases start usually with Bedell, but even Bedell recognized that it doesn't apply in a UIM scenario. Bedell says, you know, for first-party cases, we're going to presume that there's no attorney-client privilege and that you've waived that. Not so for UIM. There's no presumption of a waiver of the attorney-client privilege. In Bedell, if you're a first-party carrier, you can go back to the court and say, wait a second here. I think, you know, I should get to hold back these communications as privileged because this attorney was not helping me adjust the case. They were not doing any investigation. They were giving me pure legal advice. Those communications should be privileged. And then the court still decides, well, is there some kind of basis to pierce the attorney-client privilege? Well, this isn't really how it works in the UIM context because it is different than the average first-party case. Even Bedell said that in the UIM context, the insurance company is entitled to counsel's advice in strategizing the same defenses that the tortfeasor could have asserted. So, gosh, you'd think a UIM carrier would then be able to consult with an attorney while it's working on the UIM claim and strategizing liability defenses and strategizing damages defenses, just like in a third-party case, but that's not necessarily so. And we'll talk about that later. Bottom line, for an insured's attorney to get the attorney-client privileged materials, they have to be able to pierce that privilege. And the basis to do that is fraud. And way back in Berry in 1999, what the court says, there has to be a prima facie showing of bad faith tantamount to civil fraud to strip that privilege. And the court even goes on and defines really what that means. The Berry court said, you have to show that the insurance company was planning in or engaged in some kind of fraud. and that their communication with the attorney was in furtherance of that particular fraud, then after that, the court goes through a two-step process. One is, all right, you've given me this information. Is this enough for a reasonable person to conclude that there might be fraud here? And if so, the court will say, okay, give me your documents. I'm going to do an in-camera review and see if there's a basis for fraud. And if so, you might have to produce them. And the big question, and I think the area where there's some confusion is bad faith the same as fraud? Because what the court said is bad faith tantamount to civil fraud. And here's where everyone starts Googling that word tantamount. I know I did. And what Google said was tantamount means virtually the same as, but not the same. It doesn't really shed a lot of light on what that's supposed to mean. But, Berry considered that. The Berry court looked at it and said, you might have these bad faith claims, a violation of the CPA. Maybe you can show that there's been some violation of the insurance regulations. You probably, even if you can pass summary judgment on those causes of action, that doesn't necessarily form a good faith belief that the insurance company committed fraud. There has to be something more. In cases citing Berry say that. They say there must be something more without really defining what that something more might be. If you're in federal court, you'll see Lexington versus Swanson cited on this issue. The court said then that an insured suggestion that a mere allegation of bad faith was sufficient to invoke the civil fraud exception is inconsistent with Washington law. That's back in 2007. Well, then we circle back to Bedell, and here's where things get a little bit confusing. After all that effort the court made to separate out UIM from other types of first party claims, the court's a little less clear on bad faith versus fraud. First, in a footnote, Bedell seems to acknowledge that those are different things, that bad faith may be tantamount to civil fraud, that those are two separate concepts. But then when it comes to the test that should be applied, the court said on a showing that a reasonable person would have a reasonable belief that an act of bad faith has occurred, we'll do our in-camera review. And after that review, if there's a foundation to permit a claim of bad faith to proceed, the attorney-client privilege shall be waived. Well, as you might imagine, that can be pretty confusing to trial courts that don't do a lot of work in insurance litigation. It seemingly says that all you need is a decent claim of bad faith and the attorney-client privilege evaporates. But most federal courts who are citing Bedell for these reasons reinsert that phrase tantamount to civil fraud in brackets. Some more recent state courts who are going through this process will revert back to the original language from Berry to try to keep that fraud element in there. But bottom line, you might have to be very careful in explaining this to a trial court in the state of Washington if you're facing a discovery motion on these issues. Work product, as you know, applies to things that are prepared in anticipation of litigation. I think the big news for UIM carriers is that there is no work product immunity for documents prepared in the regular course of business. Well, what is the regular course of business for a UIM carrier? It's investigating and evaluating an injury claim. And in doing so, it is very likely that the adjuster will be creating documents that include conclusions and opinions and an analysis of the applicable law, an analysis of what a jury might do with respect to an award of damages. And those evaluation reports are not necessarily in anticipation so much as in the regular course of what an UIM adjuster does. And the bottom line is that likely that will be producible. And what actually ends up happening in discovery motions on this topic is there's some effort to determine when the date is that the UIM carrier can fairly anticipate that it's going to be sued. You might think of Leahy versus State Farm, where the court said that, when the insurance carrier gets that demand that says pay me policy limits or I'm suing you for bad faith, it's fair for the carrier to think, all right, at that point, I think we can anticipate litigation. The insured is saying we might get sued for bad faith, and you'll have more protection under the work product doctrine there. Brief mention of federal court. They have a different take on work product. As you know, in federal court, the state substantive law will apply to privilege, attorney-client privilege, but federal court applies their own work product rules. And they have the dual purpose doctrine, the because of test. They will look at each case on its own merits and insurance bad faith and try to determine if a particular document was really created because of that litigation or some other reason or multiple reasons. So that is how it's different from state. So that's all the pre-litigation UIM claim file, right? You're going to have a production, there's going to be a privilege log. Where things have been getting complicated more recently is the post-litigation UIM claim file. As you might know, if you do this kind of law, very often the filing of the UIM complaint might be the first notice of the UIM claim, or the UIM suit is filed very early in the UIM process. And in that case, the evaluation and the investigation is necessarily happening in the context of litigation because that's what happened. So what are courts doing there? First, we have Richardson versus Geico, which seemingly creates somewhat of a bright line rule. In that case, the insured accumulated $38,000 in medical bills. USAA, the tortfeasor, had $25,000 limits. They tendered them. The insured came to Geico and said, well, I would like my $35,000 in PIP limits. And Geico said, well, we don't think all that treatment is reasonable, necessary, and related. They go to PIP arbitration. Geico hires an attorney, but the arbitrator decides, nope, all $35,000 is going to the insured. And then Geico says, well, okay, we think that you are fully compensated and you have no UIM claim. And of course, the insured sues Geico for bad faith, both on its PIP and UIM claim handling. And the trial court says, okay, Geico, you have to turn over your post-litigation file materials, including all those file materials from that from that PIP arbitration, but Division 2 reversed. Division 2 said a couple of important things. One is that the decision on the UIM claim was made before the lawsuit was filed. You already have that insured for the production of the pre-litigation claim file. You don't get all the post-litigation stuff. It's not relevant for you. But more importantly, the Richardson court said, this is a public policy issue. Insurance companies get to defend themselves as a matter of public policy, and specifically permitting allegations of litigation misconduct would have a chilling effect on insurers, which could unfairly penalize them by inhibiting their attorneys from zealously and effectively representing their clients within the bounds permitted by law. Insurance companies get to defend themselves when they've been sued. So seemingly there is a bright line rule before the lawsuit and after the lawsuit, but that's not quite so. Last year in Locke versus American Family Insurance, Division 1 carved out an exception to Richardson. And in that case, the insured had sued American Family on a UIM claim. There were bad faith and claims involved too. There were a couple of attempts to remove the case to federal court. There was a remand. And during this process, an attorney for Geico, not the defense attorneys in the litigation, but an in-house counsel, sent the insured a check. They sent the insured a check directly for about $4,000 or so. What that check really represented was payment of a cost or a fee that had been imposed by the court. But what it said was in full and final settlement of all claims. As you might imagine, the insured got very upset, called up their attorney. When did we settle? This didn't happen. And the attorney wanted to introduce evidence of that check being sent to the insured and how upset she was at trial. The trial court said, no, that's post-litigation conduct. That can't form the basis of a bad faith claim. It's going to be excluded, but Division 1 reversed. And Division 1 said, you know what, we recognize that litigation tactics, litigation strategy, what you're doing in litigation, that's not going to form the basis of a bad faith claim. For that, you have litigation tools in front of you, motions to compel, motions to strike. But we still have good faith, that applies to UIM carriers, and the insurance company still must act fairly, even in the process of litigation. And that insurance company knew that they were not supposed to communicate directly with a represented insured, and that's what they did, and that is bad faith. And Division 1 sent it back and said that evidence on how the check was sent directly to the insured and how upset she was, that should be admissible. So the bright line is actually a little bit blurry. Like, how do you determine what is insurance conduct? I mean, what is litigation conduct and what is not? Also, we have Hoff versus Safeco. It applied Richardson. That was an effort, a failed effort to remove a case. And the insured's attorney said, well, I want all of your post-litigation claim file materials about this terrible decision you made to try to remove the case. And Division 1, looking at Richardson, said, nope, that's a litigation tactic. That's not bad faith. You don't get that. But I think more importantly, what the court said was an insured's discussion and documents about strategy created during litigation, in contrast with discussions and documents related to claims processing, are not discoverable. So in that statement, and I've seen trial courts interpret it this way, the Hoff court seemingly created two hats, right, for the insurance company. The litigation hat that they're wearing, defending the case in litigation, and a claims processing hat that they might still be wearing if the claim hadn't finished being processed before litigation was filed. And here's where it gets very confusing. What counts as claims processing materials as opposed to litigation materials? Discovery, the other side already has, but what about an evaluation created by an adjuster with the input of their attorney during the course of litigation in preparation for, say, a mediation? That's the same kind of evaluation that the adjuster might prepare if the case wasn't in litigation at all. Is that protected? Is that discoverable? And that's exactly what I've been fighting about on discovery motions at the trial court level. There's a couple cases on federal court where there's a bit of a split on how far the litigation protection might extend. This is an example of a trial court ruling from King County last year. This was made an exhibit on a discovery motion that I had. The insured's attorney pointed to this ruling for the case that I was in and said, hey, this is what King County is doing. You should do this too. And what the King County judge said was, Richardson doesn't create a bright line rule. And Locke demonstrates that Richardson doesn't create an absolute bar to the discovery of information and documents developed post-litigation, even when the insurer has ceased all claims handling or adjustment. Wow, that doesn't seem to be what the Richardson court was saying originally, which is you don't need this information. This potentially opens up discovery to a lot of information that could be considered protected or privileged as part of the defense in the litigation of the case. So we might see a ruling on this in the future. I've certainly been keeping a close eye on it. I think the big picture, though, is how important it is to clearly document the nature of what you are doing or created. What is the nature of this communication with the attorney? What is the nature of this document that's being prepared in the case? Because that is what will be discussed later. All right, I did it. You're probably all hungry.
Thanks. Thanks, Cam, and thanks, Geoff. Appreciate that. We're going to take our lunch. We are going to start on time at 1:15 after lunch. And our first panel is the panel with Coreen Wilson, Scott Wakefield, Judge Williams, and Judge Keenan. So be sure you're back for that at 1:15. Thank you all.
Testing.
Good afternoon, Judge Keenan. Good to see you. Hey, Betsy.
Yeah.
You want to cut your video feed just because we'll get going with the presenters who are this
Oh,
afternoon.
yeah, absolutely. I was just checking. I'm going to try and change my background, but I'll check later.
Okay. It looks great if you want to
Okay.
keep it that way.
All right. Thanks. Bye.
Thanks. Okay. Hi, Scott. And let's see. Oh, Judge Williams. Hi, Judge Williams.
Good,
that was
good
clever.
afternoon.
So we are waiting on Coreen, and then we can get going. Oh, there she is.
I'm here.
Great. Okay, so we will begin at 1:15. We told our attendees that we will be starting right on time. And so at this point, I'm going to go ahead and drop off just because everybody's set. And thank you so much for being here. And then what I will also do is I will stop screen sharing, Jason, when you're ready to do introductions. Okay?
Okay.
Can I just very quickly test? Is my audio working okay?
Yes.
I can hear you just fine, Judge.
Great, thanks.
Is mine working?
Yep, Scott, you're good.
Who is going to be sharing screen? Are you guys going to have a screen share? PowerPoint? No. Okay, yep. Perfect. Jason, with this being a panel, I would recommend that you recommend to attendees to put their setting in gallery view because that allows them to see everybody on the screen and not just the person who's making the most noise.
Understood.
Thanks.
All right. Looks like we're right at 1:15, so I will go ahead and introduce our next panel. This topic is emerging best practices, some discussion of discovery and trial issues during 2020 and 2021 and going forward, specifically looking at discovery, arbitrations, mediations, and trials. Coreen Wilson is a partner at Wieck Wilson, she's one of our panelists today. Our practice focuses on insurance defense. She's, of course, experienced and well-decorated trial lawyer. And next we have Scott Wakefield, also a partner at Wakefield and Kirkpatrick. I shouldn't say also, but a partner at Wakefield and Kirkpatrick. Scott's got 40 years of experience as a trial lawyer in Washington State, and civil litigation practice focuses on insurance coverage and extra-contractual matters, as well as other areas in more of the traditional defense sense. Both Coreen and Scott have Zoom trial experience. And then, of course, we have our judges today. Judge David Keenan is with us. He joined the King County Superior Court bench in 2017 and serves at the Ewing Center down in Kent. Prior to being elected judge, Judge Keenan worked in complex civil litigation for the global firm of Orrick, Harrington, and Sutcliffe. And we have Judge Matt Williams as well of King County Superior Court. Prior to serving on the bench, Judge Williams served 6 years as a district court attorney in King County, Washington, and began his legal career with the Attorney General's office in Nebraska, Iowa, and Washington State. He also served as supervising assistant attorney for the City of Seattle's major litigation unit and as the managing attorney of a large law office based in Tacoma, and a general manager with a national insurance carrier where he implemented best practices. So he's got a lot of experience not only on the bench, but also prior to that with our insurance issues. But today, we've gathered the four of them here today largely to discuss emerging best practices and some of the unique challenges of trying cases. in 2020 and beyond. I wanted to start off with a question really primarily for the two judges, only because we did have two attorneys who spoke to discovery issues a little bit earlier today. But with regard to discovery, my first question, what is the biggest change you've seen in discovery practice in 2020? For either Judge Williams or Judge Keenan.
Okay, well, I'll leap into this one. You know, I think from the practitioner standpoint, one of the hardest issues in terms of when you're doing remote discovery, depositions, and other forms of remote conferencing, it's the worry that the witness is being coached. From the bench, what I'm seeing is a different type of discovery motion practice, more and frankly, less communication than I would have liked, that I generally would like to see. This CR26 conferences that are kind of pro forma, but more, both more aggressive discovery motions and frankly, discovery motions that are frequently easier to resolve, because a lot of times the answer is, you need to talk about this before you come to us.
Yeah, and I would just add to that, what I heard a lot early during the pandemic was, Your Honor, we would have attorneys emailing our bailiff saying, we're having a deposition tomorrow, it's all remote. Will you be available if we have a problem that comes up during the deposition about coaching or something like that? And my response was, sure, but why would that be any different? You know, and each time I've heard these ethical concerns about any remote conduct, my response is always the rules still apply and cheaters are going to cheat. If somebody was going to cheat before the pandemic, they would find a way, and they'll find a way during the pandemic. But if you are concerned about anybody in a remote space, whether it's a deposition or during testimony, you can ask for a 360. You know, you can tell the witness as you are explaining the rules of the road for the deposition. You can ask them if there's somebody else in their space. And what I have seen, and this, of course, is during testimony, but I imagine it happens during depositions as well, which is that nobody's intentionally, or very few people are intentionally referring to their notes, but it is just tempting. And I'm in a trial right now, and the witness the other day started looking down, and I said, wait, what are you looking at? He's like, oh, I'm just, I have some notes here. And I said, well, I understand you're at home and you have these notes in front of you. And it just felt natural to do that, and they didn't know. But I haven't seen so far in this last year any intentional discovery violations that I think would relate to the remote technology.
Great, thank you. And I should add, just for our listeners and our attendees, I was so excited to get into the substance and talk to the panel today. I neglected to suggest that everyone switch their view to gallery view for this discussion, since we do have 4 speakers today, speaking on a panel. Following up on the discovery issues, Judge Williams, is there one tip you would give the listeners with regard to discovery?
I think Judge Keenan really articulated the best one, which is, if you've got a doubt, just ask the witness to do a 360 with their camera. And may I also suggest that, and you're going to hear this, I think, a pretty consistent theme from both Judge Keenan and I and the practitioners. The first time that you have a Zoom call with your witness should not be the day of the deposition or the moment of the deposition. Practice and being able to make sure that the technology works, you can hear them, they can hear you. If it's a client, making sure you know how you're going to communicate. But at the end of the day, try it before the day of the deposition. Do a practice technology run first, so you don't stumble.
Thank you. And then for Scott and Coreen, any reaction or thoughts on those topics?
Well, there are a couple things that I do that I have found are helpful. One is that the state bar has guidelines for remote depositions. And so my practice is to attach those to my notice of deposition, so that those go out with the notice, and they aren't comprehensive, but they do give some guidelines on how to conduct remote depositions. The second is that I found that when people cheat and you call them out on the record, that ends up being good for you. I took a deposition a couple of weeks ago, and one of the two plaintiffs was being deposed. The other plaintiff was in the room off screen. The plaintiff being deposed was wearing a mask, and I asked him, "Where are you?" And he said, "At home." And I asked him why he was wearing a mask, and he said he always wore a mask. Well, then he shows up to arbitration without a mask on in the same location from home, which, makes it look like, he's trying to hide something. The other thing he did was he's starting to answer a question. I can hear his wife's voice in the background giving him the answer. It's caught on the transcript. And then he tried to tell me that it was just the TV, which conveniently provided the answer to the question. Imagine that. So, when people do cheat, it often does not work out in their favor as they might hope. Now, I know that that's not always the case, but if you're prepared for the idea of, okay, here are the things that can happen during a deposition, here's what I should be concerned with, you can catch it out, and it ends up being beneficial to your case.
I guess I'm naive, but I've never really been in a deposition yet where I suspected anybody of cheating or being coached by some sub rosa method like a cell phone or text or anything like that. But I guess the one thing I would suggest, it kind of correlates to, I think, Judge Williams, his suggestion about, have a meeting with your deponent or your witness if you're defending the deposition. Before, I would practice exhibits and learning screen share before. I think the first time that maybe it wasn't the first time that I took a Zoom deposition, one of the first times, it was a kind of a critical issue about where people were at a certain time, and we had photographs, and I thought, how am I going to do this? And I was pretty bad at screen share. So I practiced with Dan Kirkpatrick, and the other, he's like 10 feet away from me in his office. And I said, "Okay, what do you see?" And he could yell and I could hear him. And then we practiced, using there are tools on Zoom that you can actually mark exhibits with and then freeze them. And, I found it to be almost as good, in some ways better, than having somebody draw on something with the pen. But it is not an intuitive experience for me, and especially if you're going to mark up a diagram or an exhibit or a Google Map image, you need to practice. So that would be my suggestion.
If I could jump in and just add on the issue of exhibits, we'll probably talk about this later. There's so many ways of skinning the cat of exhibits. And of course, you can use the technology, you can use email, you can transmit. One method that Judge Peckman and Judge Lasnik and Judge Zilli suggest is, in a deposition or in a trial, you can ship to the witness, say you're taking a deposition, ship them in a sealed envelope, ship them the hard copies of the exhibits that you intend to use, and then have them open that in front of you on the record.
And I think Scott's point just can't be emphasized strongly enough. I don't think this is intuitive for any of us. It certainly wasn't for me, but I'll tell you what, this is not a screen share. That's not how you use an exhibit. And I've seen that more times than I can count. And if you cannot, if you aren't willing to take, a half an hour or so to practice basic screen share techniques, you're doing yourself a great disservice, because the ability to display and interact with exhibits during a deposition or during any kind of a proceeding is absolutely an essential skill.
Although I will add that the best screen sharing or exhibit sharing is what works in the moment often. And so I agree with Coreen. It's ideal to have these things uploaded. You should practice with the technology. And I know we may talk about this later, but you should consider and figure out in advance how it is going to look to someone else seeing it on the screen. But I think Judge Williams and I can both attest that sometimes just things come up during trial, and the next thing you know, somebody is pulled out a flipboard or a piece of paper and is drawing something and holding it up to the screen, which is not ideal. But we do often have to improvise, and I think the best advice I can give you in that instance is, talk with your judge, talk with the clerk of the court, who is often on the Zoom about what they'll accept. And I think you'll find that most of us are pretty flexible. We just want to try and make it work and keep trial moving along. So if it's the choice between that and stopping for several minutes while somebody scans something and uploads it, I might say, well, let's see if we can improvise a quicker solution.
Transitioning a little bit from discovery to mediation, and I'll start with Scott and Coreen. What's the biggest challenge you've seen with mediation 2020 and beyond? I don't know if it's a challenge. In my experience, they're shorter. You're not at somebody's office, the mediators, not shuffling between two conference rooms. And so it's a quick cut from one, breakout room to the other breakout room. And I guess I would also add, I think there's less drama. There's not people, okay, we're going to standing up and we're going to leave. You just say, well, just go to your breakout room. Don't leave. And I'm not sure I like it better, to be quite honest. I kind of tend to still like in-person mediations. But I think in some ways they're more efficient. Again, the same thing, I've found I'm writing a little bit longer pre-mediation letters than I did because, it's different when you can sort of do a fairly brief introductory type letter and then sort of fill in the details on if it's a critical medical record, you can bring it along with you. And now, because you don't really have maybe as effective a way to do that over Zoom as you could, and if the mediator was in the same room, I'm finding I'm writing a little bit longer letters and trying to include, excerpts of critical documents or medical records, in the pre-mediation letter that maybe I wouldn't have done if it had been in a face-to-face environment.
I think, conversations are just different when they happen over a video conference. And so for me, that's been the challenge, is it's just different to talk to people in person than it is to talk to them over a camera. But the other thing that I found is fundamentally different about the video mediations versus in-person mediations is, well, I mean, they're a lot less fun because you don't have the, social aspect, but I find it helpful at certain times in certain mediations to just walk down the hall and have a face-to-face with somebody, whether it's another defense attorney or whether it's plaintiff's attorney, or go find the mediator while they're, regrouping between rooms. Sometimes that's what makes all the difference. And that's really hard to do in an online mediation. I had one recently where I absolutely had to have a face-to-face with plaintiff's counsel. And so I had to ask the mediator to set that up, which was a little bit uncomfortable because the reason I needed that was because I didn't feel like my message or their message was being conveyed correctly between the two rooms. I was worried that there was a miscommunication there. But he was very gracious and set that up for me. It just was more cumbersome than having to do it in person.
I'll just say from my perspective, doing settlement conferences at least, so this is still on the ADR topic, Zoom works really well for me. I don't know how well it works for the parties based on what I'm hearing from the attorneys, but the policy we have here in King County is that judges cannot schedule settlement conferences during what we call duty hours, which is basically 8:30 to 4:30 Monday through Thursday. We do have the opportunity to set them during the day on Fridays with some exceptions. So for the most part, we do them after hours. And Zoom, I find, is really efficient. I had one a couple of weeks ago, and the breakout rooms I felt went really well. You could go back and forth, especially towards the end of this particular settlement conference where the parties were close on the numbers, and I could just flip back and forth between rooms very quickly and get it done. So I'll say that at least going forward, I plan to do all of my settlement conferences on Zoom if I can. If council conveyed to me the importance, I think, as Coreen did, of being in person for whatever reason, I'm open to that. But I'm more willing to do settlement conferences over Zoom, I think, than I am in person, in particular, because we always have to start them after hours.
And Judge Williams, I think you're on mute there.
The most common phrase in courtrooms in the United States today is, "You're on mute." It will happen in depositions. It'll happen in your trials. And part of the message that I hope we get out today is, it's okay. It's going to happen to you. It's going to happen to all of us. I'm like Judge Keenan. I'm a lot more likely to schedule and to agree to do a settlement conference because I'm not necessarily trapped at the courthouse during that. I can do that from pretty much anywhere. I will say that the level of preparation of the lawyers that I've seen in the settlement conferences, tying back to what Scott and Coreen were saying about about having more detailed settlement memorandums, the level of preparation of the attorneys I've observed is greater. One of the challenges that I think that we faced, and it's not universal, it's just, and it's not necessarily a product of the format, but more a product of the fact that an adjuster sitting in Phoenix doesn't have to travel and doesn't have that downtime to prepare. I have seen what appears to be less prepared adjusters and individuals where we have to spend more time explaining the case to them because they're just ending their workday and they haven't had that travel time to prepare and review their own lawyer's memorandum.
Thank you for that. Is there a tip that you would give the listeners with regard to mediation as far as doing Zoom or video conference mediations as opposed to traditional?
Well, I would start out by saying, I've actually had a lot of success at mediating cases. I've been lucky in that a lot of the cases that I've done Zoom mediations with, we've been able to resolve. So I don't mean to suggest that the challenges are insurmountable or that it can't be efficiently done over Zoom. But I will give you one cautionary tale. I got very excited. I like the technology aspect. It's fun for me. In person, I think, I'm more comfortable with, but the technology has become somewhat of a hobby. So in getting ready for mediation, I thought, it'd be really cool is to do a video mediation brief. And I can, put my stuff up on the screen and I can talk about it and I can, circle things and I can make my arguments and then I'll send that to the mediator. And so I did that. And the mediator said, "Yeah, cool. Can you send me something in writing?" So if you're going to do something like that, just know your audience, maybe check in advance and ask, do you prefer something in writing? Would you like to see a video mediation brief? So that you're not actually doing the same work twice like I did.
All right. If there are no more thoughts on mediation, we'll go ahead and transition on to civil jury trials 2021 going forward. And we can start with voir dire, and I'll start with Coreen and Scott on this issue. But first question I'll throw out is, what is the worst thing that you've seen happen and how did you deal with it?
Jason, before we go there, and I apologize for interrupting, do you think we might be able to talk just about the future of civil jury trials in King County going
Absolutely.
2021? Because I think that's a topic that the members really need to be kind of brought into the loop on this constantly changing, shifting sand. And both Judge Keenan and I, we actually came prepared to talk about Maidenbauer, what the future of Maidenbauer is, and what's happening as it relates to when we plan on starting in-person civil jury trials again. So it would be okay if we jumped into that?
Absolutely. I skipped a line in my outline there. So please, Judge Williams, go for it.
Judge Keenan, you want to start or you want me to leap in?
Oh, go ahead, Judge Williams, please.
Okay. As you know, the most current emergency order 28, which was issued back in January, says that that we have essentially a moratorium on in-person civil jury trials through today. We started in-person criminal jury trials back in mid-February, and part of what you have to understand is that unlike a civil jury trial that can be conducted remotely, when we're not doing in-person criminal trials, the entire criminal jury system stops. There's no alternative. And so the backlog that we currently have here in King County is 7,000 major felonies waiting for trial. We are worlds ahead of other courts around the nation. There are some courts, I have a good friend in San Diego who has not been in the courthouse for over a year. They're just at a standstill. And so because of the innovation of WDTL and its members, Wasatch and its members, the court, we've been able to kind of crunch things through using virtual technologies, both for civil and criminal. But the reality is that with that backlog in place, that means that those criminal trials are going to have a priority over your jury trials, whether it's in person or whether it's virtual. And because we don't have the option to do a virtual trial in a criminal case. We can do virtual voir dire, and we do in every criminal case, but we can't do the actual trial that way. The other challenge that we're going to face, it's a brick and mortar challenge. The process of getting cases out, as you all know, involves brokerage, which is a little bit different than what we used to do years and years ago. But what that means is that every Thursday, the presidings get together and they look at the Tetris of available judge, available courtroom, and jurors, whether or not they have available jurors, and then counsel availability. And then in turn, that can drive off of witness availability. So they're looking at that every Thursday to assign cases out. If you are fortunate enough to get a civil jury date in the week that that your trial has been set to go, you are very fortunate, because again, we have a huge backlog of criminal trials. But here's the problem. Downtown, it can take 2, maybe 3 courtrooms to do an in-person jury trial because of social distancing. Here at the MRJC, it can take 2 courtrooms. So you have a courtroom limitation that's instantly imposed on, and just in terms of our brick and mortar, our ability to get trials out. Maidenbauer has allowed us to relieve a lot of that tension. And I know that Judge Keenan is currently at Maidenbauer doing virtual bench trials or remote bench trials. But we lose Maidenbauer for the month of April. Maidenbauer has other commitments during that month. So during the month of April, there will be no civil jury trials. There will be no trials at all during the month of April. We've been informed that we plan on resuming, and we should have Maidenbauer back and operational on April 26th, and that we should have Maidenbauer available to us through July 1st. And I know it's a short window, but that's partially that's funding. It's when the CARES funding runs out. So that's 6 courtrooms out there. And we've kind of double checked, and we've made sure that those courtrooms can be used not only for virtual jury trials, for in-person jury trials, but also for fully virtual jury trials. And again, remember the Tetris. Do you have a judge? Do you have a brick and mortar courtroom, a space that we can use for purposes of open courts? And then the third one is, do we have jurors? And again, the criminal department, the criminal trials, they're going to take precedence over the civil cases. So it's, well, even when we begin doing civil jury trials that are in person or have that opportunity, there may be a limitation on jurors. The most current information that Judge Keenan and I have received from our presidings is that the emergency order 28, which ceases in-person jury operations for civil cases through today, that will be extended through at least April 26th. And I didn't see that it's been posted yet, but we've been informed that we can expect that to occur. And then after that, it's going to be on a, if we can get you an in-person jury trial and you really want one, and we're going to talk more about that issue upstream. But if the stars align, you might get an in-person trial, but you're probably, at least for 2021, if you really want to get your civil trial out, you should be thinking very hard about learning the skill sets of doing virtual, not certainly virtual voir dire, but also virtual jury trials. Judge Keenan, did I miss anything?
Great. Thank you, Judge Williams.
I'd just like to follow on, I've noticed a lot of, I guess, what I would call pushback against civil Zoom jury trials by the defense bar. And I had an opportunity to try a civil Zoom, and I kind of thought it would be fun and interesting. And I just thought it would be an interesting thing to do. And it was a case where I kind of wanted to get it into trial. I didn't want to wait around. It had been continued a couple of times, and I kind of wanted to get it off the dime. And I did the trial before Judge Williams. And it was at a time when I think the defense bar was kind of uniformly thought that this was a bad idea. And it led to higher verdicts. And I'm not sure how people knew that because there really hadn't been any. But I will tell you that based upon my experience, and that was a good one. Maybe if it hadn't been a good one, I would have said they're terrible. I never want to do another one. But I did not miss walking down 3rd Avenue in the rain with 4 banker's boxes on a luggage carrier and trying to go over a curb and not dump them, and meeting some of the fine people that hang around 3rd Avenue near the courthouse, and all of that stuff about going through security, which makes, that's my least favorite part. And it was down in Kent, so it would have been easier in terms of that. I wouldn't have had to walk down 3rd Avenue, but I was still have the drive down I-5 and the West Valley Freeway. It just was a lot more civilized, to tell you the truth, to come to my office and boot up the computer. And I think, quite frankly, the jurors can see you better. I mean, you're looking at me now in this seminar, and I'm probably 3 feet or so away from your screen, or 2 feet away. And you can see me better, and you can, I don't know if that's good, to tell you the truth, but it just is a different kind of medium. And I don't think it necessarily favors either the defense or the plaintiff. I don't know, again, I hear anecdotal stories that people say that the verdicts are higher and it's bad for defendants. That wasn't my experience. And I don't know really whether we've got a data set that's big enough to make, that kind of a sweeping statement yet. But I will say that from my experience, I think that there's a future for this in the right kind of case. And especially, and we're going to get to this, but especially for voir dire, but I'll let somebody else have the floor now.
Any other thoughts on kind of the new normal, or whether this is going to be a thing going forward? And then before I go to voir dire.
Well, it's definitely going to be a thing going forward. I mean, it's just a question of it's going to evolve and evolve and evolve and evolve. And so you can make the choice to say, I don't like it, therefore I'm not going to learn it. Or you can accept what our current reality is, which is this is happening, whether you like it or you don't like it, or you're neutral on it. And it's something that you need to learn. And I think, my experience was similar to Scott's in that I actually thought, wow, I have a chance to try a case on Zoom. That sounds cool. And so I think part of it's a matter of attitude. But part of it also is a matter of just your being willing to learn the new format. And I think you'll find if you are willing to learn it, there are advantages the defense bar has that the plaintiff's bar does not. Like, for example, it's going to be a lot more difficult for the plaintiff to convey that emotional hook over a screen than it is in person. And that's an advantage for you. And so you just need to look at it from the mindset of, okay, like it or not, this is my reality. So how am I going to maximize that to my best advantage? Because I tell you what, I show up to pre-trial conferences and I have this lower third and I'm able to screen share with no problem at all. And the judge says, so, are the parties willing to do a Zoom trial? And I said, yeah, let's do one. And opposing counsel says, no, we don't want to do that. So I think if you're more prepared and you treat it as, I have the advantage here, you might find a different response from your opposing counsel.
Thank you, Coreen. That makes sense. I will turn back to voir dire and I'll start with Scott. I've got 3 questions here written down, so maybe I'll just give them to you all at once and you can address them as you see fit. But one is, what is the worst thing you've seen happen in Zoom voir dire and how'd you deal with it? Then what is the biggest advantage of voir dire via Zoom? And finally, what's one tip you could give to the viewers today?
Well, I actually, I think it would be helpful before the practitioners discuss this is, I know that both Judge Keenan and both Judge Williams have given seminars on this, and I attended them. But when I still didn't really get, well, how are we going to have 40 people? I mean, their pictures are going to be the size of postage stamps. So maybe it would be helpful to have our 2 judicial participants kind of explain that and how it will appear on the screen and how they do things by panels. And then maybe Coreen and I can jump in after they lay that foundation kind of thing.
Sure.
And it varies. I can tell you that my practice has been, my panels aren't any bigger than about 18 or 19 jurors, because I think that's about the most that you want on a screen. If you have a bigger monitor, more might work for you. I'm typically working off of a laptop or maybe a 17-inch monitor. And so I don't want the screen to be too crowded. And I'll hide the non-video participants to make the screen less crowded. And I'll arrange the tiles myself and have everybody else follow the order that I have set on my screen. I'll rename all the jurors by juror numbers so that you're looking at a smaller set of people. And I think, one advantage is that you can see people's expressions up close. And I've heard attorneys during voir dire ask a question of the panel, 18 or 19 people, and then they'll stop and say, oh, juror 8, I saw your eyebrow raise when I asked that question. Is there anything you want to share with me? And so when folks tell me, well, we miss out on all the body language of voir dire in person, and my response is always, if we're in my courtroom, and I'm sitting in my courtroom right now, and there's 4 rows of benches and juror number 50 is in the back corner, how much body language are you getting with 50 people during the 20 minutes you have with each panel? And I'll say, I think voir dire, remote voir dire may be with us for a very long time. I'm in favor of that because otherwise we're bringing down 150 or more people just downtown alone. Let's put the Maline Regional Justice Center aside. 150 or more people down here each Monday, Tuesday, and Wednesday morning. 150 people that have to find their way to this courthouse and sit in that room all day and then be dispersed in groups of 50 to the different courtrooms around the courthouse. I think it's far more efficient. And I'll say one more thing, and then I'll kick it over to Judge Williams, which is that the court has convened these work groups to study what we should continue, practices that we implemented during the pandemic and what we'd like to see continue. So we are actively considering what really worked well and what we'd like to see going forward.
Judge Keenan actually led the production of the 4 videos you'll find out on our website, one of which is which Judge Keenan teaches, which is about what to expect and how to do video voir dire. It's only about, it's about 12, 13 minutes. And you know, it's fast and it's really helpful. And so I really encourage anybody that's getting ready to do any form of virtual hearing, go watch the videos. In terms of the advantages, look, here's the deal. We get more diverse jurors. It is through the process of virtual voir dire. It is a more inclusive process. We get a much higher response rate to our summonses. Why? Because they don't have to come down, like Judge Keenan said, you know, find their way down to the courthouse, go through security, all the things that Scott and Coreen have talked about. So we get a much more diverse pool, but there are some differences. And like what Coreen and Scott were saying, I mean, the reality is this: if you're the lawyer that you think the juror, that voir dire is the first opening argument, that this is a speech that you're giving to your panel, you need to learn a new skill set. You know, the purpose of voir dire, I spent 30 years in the well, and I learned that, yeah, it's easy to have that speech, but the reality is I got better verdicts if I learned how to extract information from my jurors. This forum is better for that on 2 fronts. One, like Scott said, you're 2.5 feet away from somebody. You can develop a relationship with your jurors because you're having a conversation with them. You're not giving them a lecture. And the second thing, and I just concluded a rape of a child case. And you know, you can imagine voir dire in that case was sensitive. And the jurors, instead of sitting in this alien, frightening, distracting place that is a courtroom, yeah, it's where we're comfortable, but they're not. They're sitting at home, and they felt safe and they felt comfortable. And so when they were asked about their life experiences, because they're safe and they're comfortable, I was stunned at some of the things that our panel shared with us. And they would not have shared those things if they had come down to the courthouse, filled out a paper questionnaire, as opposed to the confidential online questionnaire, which again, another advantage, gives you a lot of information about your potential jurors. But they wouldn't have shared it there, and they most certainly would never have shared it, even if do you want to discuss it outside the presence of the other jurors. Why? They felt safe. And having that sense of safety on the part of the jurors, which allows them to focus and concentrate and relate to you. If you can make that transition, this works. If you can't, you're going to struggle. And it's in my world, it's kind of that simple. One of the questions that Jason asked, what's your worst experience in video voir dire? It was actually my very first one. It was the asbestos case. We're doing voir dire. Juror number 3 in the panel is sitting in what looks like a big cushy chair, like a big leather chair. And she had also been a juror that had said she was just too busy, and she was in her community, she was too important to have to come down and do jury selection. And so we said, no, you're going to attend this way. It's only 90 minutes. You can do this. So she's sitting in this big leather chair, and she's muted, which is appropriate, but she's listening. She's got her headphones on. She's paying attention. She's clearly on a handheld device. And that's fine. And then she gets up and she starts walking around. And she walks up to a counter and gives the person behind it a credit card. And then she walks out. It's clear she was at the nail salon. And she's walking around, and the lawyers are keep doing it. And I interrupted. I said, you know, juror number 3, you got to stop doing that. You need to be paying attention. Oh, okay. So she gets in her car. I'm thinking, okay, fine. She's in her car. She'll pay attention. She'll just sit there in the parking lot and we'll get this done. Oh no, she starts to drive. And again, the lawyers have continued. I'm watching this. I'm going, no, juror number 3, driving is a divided attention task. I need your complete attention. Pull over. Oh, okay, Judge, I will as soon as I can. She keeps driving. This happens twice more. And finally, about the time apparently she got wherever she was going, I just said, no, enough. You will appear in my courtroom for in-person voir dire at 3 o'clock this afternoon. Oh, I can't, Judge, I'm too busy. I said, I don't care. You will appear. And, so being able to watch and see what's going on, the problems are solvable. But Jason asked, what's the worst thing I've seen happen in what year? That was it.
That's a great story. Wow.
And the question was, what's the best tip I can give? Don't make a speech in what year. It's a conversation. It's not a speech.
Appreciate that.
On the worst question, this is both a good thing and a bad thing. What Judge Williams said about you get a lot more information when you do. It's not like the little one-page, jurors information form that we're used to getting. This was a Excel spreadsheet that it went on for so many columns that I had to get a Noelle Szymanski, who helped me try this case in Judge Williams' courtroom. I put her in charge of manipulating the data on that because, I will make a confession here. I've never filled out a complete juror grid in 40 years of doing trials. There's always somebody that I forget something to write down about. So I had no confidence in being able to keep up with that. And actually, if you're not good at manipulating data on an Excel spreadsheet, I do encourage you to get assistance with somebody in your firm who's technically savvy to help you with that process. But you get an enormous amount of information on that, much more than you ever got on that little one-page form that we're all familiar with. And in my experience, it was a great way to start what Judge Williams alluded to, start conversations. You could look at something on that sheet and say, this person I was involved, she was a fundraiser for some arts organization. So I just said, what kind of arts organization? What do you do? And it was a natural way to get that information. And sure, you could kind of do that when you had the old form. You could ask them about their hobbies, and if you struck pay dirt there, you could continue a conversation. But it was much more efficient. Once you learned how to manipulate the Excel spreadsheet, it was much more efficient, and there was a ton of information in it.
Thanks, Scott. I'm going to segue into trial and talking about the trial itself, and really the same questions. What's the biggest advantage? What's the worst thing you've seen happen, and how did you deal with it? And one tip you can give the listeners, and I've got some other questions, but maybe we'll start with those three.
Well, I think probably most people know the worst thing that I've seen, which was the Zoom bombing in the middle of my closing. And that actually wasn't as big of a deal as it sounds like it was. I mean, not to say that it wasn't important, because obviously it was, but we had Judge O'Donnell, who thankfully has a phenomenal sense of humor. And, as people are storming our call, playing banjos and insulting the judge, and he just kind of, laughed it off, which did a couple things. One was it put the jurors at ease, and the other was it underscored the fact that he was in complete control of the situation. And so we had to shut down the call and start up a new call. And it while it was in the middle of my closing, which, really isn't ideal, it wasn't that big of a deal any more than if you're in the middle of your closing and someone slams into the courtroom, slams the door open and walks in the back, and everybody turns and looks, or someone's phone goes off, or, any number of disturbances that you might have. So to me, it was equivalent to something like that, although it was a little bit longer of a delay before we could get it up and running. And that is a situation that I don't expect that anybody else is going to run into, because we've come a long way since then. So I don't think that there is, any issue with that at this point in time.
Anyone else have a worst thing that you've seen happen and how you dealt with it story for trial itself?
Go ahead, Scott.
I just remember one episode from the case, the Judge Williams case, where there was a juror. And again, this shows you how much communication, you remember this, Judge Williams. There was a juror who did not like my opponent or didn't like the plaintiff. I could never tell which it was. But because he was in this safe environment of his own home, even though he knew he was being broadcast to at least 30 other people. Every time the plaintiff's lawyer or the plaintiff testified, he would literally stand up and go like this, and you could hear his mouth, and he was not saying words that I would repeat in front of this genteel audience, but it was plainly visible to me and to Judge Williams and to everybody else. And we finally, Judge Williams called a timeout. We took this individual kind of aside, and he said, "No, I can be fair," like they usually do. And of course, I wanted him badly at that point. And Judge Williams said, "Well, I think we're going to find another case for you," and excused him. So that was the worst thing that happened to me, because he would have been a great juror for me.
I mean, I feel like I'm missing out. I almost want to propose that the court adopt a local rule requiring a banjo player at every remote hearing or trial. I think what I did have an occurrence during oral argument on a motion recently where the client was attending by Zoom, and he was wearing a coat and tie, and that's what I could see, kind of his torso. But I could see the entire room behind him. And at some point he was on a chair with wheels, and he wheeled back, and then he was just in his boxer shorts, right? So it was business on top and party down below. So that was unfortunate. That's something that I cannot unsee. What I would say about trial is something, I'll come back to something I said earlier, which is consider how your evidence translates on the screen, and practice that with a colleague. Send a Zoom practice invite to a colleague. Share some of your exhibits, especially ones that may have a lot of text or have a lot of intense graphics, and ask them, how does that look to you? Can you see that okay? And think about being creative with your illustratives, and think about summary exhibits. Where I've seen exhibits I think not translate well is long financial records and trying to scroll through all of those. So I would just think about how that stuff displays, and think about preparing some summaries and illustratives that you might not prepare for an in-person trial.
Following up on what Scott was saying in terms of the watching, and the fact that you're about 3 feet away from someone. The reality is what happened in that trial, Scott was aware of it. I was aware of it. I don't actually think that the plaintiff's counsel caught onto it, either because of the screen view that they were using, or because they were sort of kind of focused solely on their presentation, because you always have your own screen up there as well. And so they didn't catch it. I did. And that was what led to us having this isn't right. You need to stop doing this. And remember the story I told you about the juror in the nail salon. Again, the lawyers, I was the one that caught it. I think I can speak for all of your judges. We really would welcome your assistance if you see something happening in a non-intrusive, blow up the trial kind of way. If you can bring it to our attention, that's really helpful, because that's another set of eyes watching the jury, and you can see them really well. Throughout the trial, I'm sitting there scanning, I'm listening to the witness, and periodically I'm also looking at the witness. As Judge Peckman said, it's the first time I can actually look straight at the witness. But the reality is I'm monitoring the jurors. I'm going in and I'm zooming in on them using the pin feature, and I'm looking at what their eyes are doing. And I encourage you, if you see a juror or someone in the virtual courtroom doing something that's inappropriate, in a non-blow up the trial kind of way, bring it to the judge's attention. And the reality is we'll deal with it the same way we would deal with something that was going on. If, say you had a juror that had fallen asleep. Not that anyone would ever fall asleep in any of your jury trials, but the reality is it does happen in live trials. But or someone who's behaving appropriately, feel free to make sure that you communicate to that judge and be another set of eyes for us.
Thank you, Judge. One question I'd like to ask is, how does one raise or deal with mistrial motions or sidebars during a Zoom trial? Judge Williams?
Sure, and I saw Judge Keenan. And actually Judge Keenan just posted and did an article in the King County Bar Association News on this, and he talked specifically about this. Here's the deal. If we're in a trial and you need a sidebar about something, used to be, I had the only courtroom at the MRJC, you could have a sidebar without booting the jury out of the room and still be on the record. Well, with our new equipment update, that's gone now. But here's the thing. If we're in person, in order for me to remove the jury, we have to stop the proceeding. I have to admonish them, don't talk about the case. Then I have to summon the bailiff into the room. They have to rise. They have to go back into the jury room. They get settled into the jury room. Some of them are going to use the restroom. They're going to get settled in. That is a 15, 20-minute process minimum. To remove the jury in a virtual trial, it's 10 seconds. I can admonish them in about 5. I push the button, bam, they're in the virtual jury room. And then to bring them back, it's 10 seconds. Because again, they haven't gone anywhere because I've told them not to. Bam, push the button, they're back in. So sidebars are infinitely easier. And that in turn means that as a judge, I'm a lot more likely to grant a sidebar and to hear argument on a subtle evidentiary point than I am if I'm going to have to take 20 minutes and stop the trial. Judge Peckman was asked the question during an ABOTA seminar, something to the effect of, are these trials longer, shorter, about the same? And of course, like everything else, we don't have a lot of data. Her observation, and I agree with this, they're about the same, if not a little bit shorter. There are parts that take longer. Jury selection takes longer. Witnesses, because of being able to go in and out, tend to not take as long because we can kick the jury out, we can bring them back, and we tend to start and stop on time. And so we gain a lot of time there. So it's probably, at least in my view, and Judge Keenan may have a different view, but my experience has been it's about the same, if not shorter, because again, some things take longer, but there's a bunch of stuff that just takes less time. Motions for mistrial, have they happened? Yeah. I had one in the last civil jury trial that I did. Same thing, jury's out of the room, motion heard, ruled on, brought the jury back in, continued the trial.
Thanks, Judge. I'll transition to civil arbitrations and bench trials. What's the biggest advantage of a Zoom arbitration or a bench trial versus in person?
Well, I can say in terms of arbitration, my favorite part is not having to drive all over yonder to go to arbitrations all the time. That's my favorite part. That's the biggest advantage for me because, I'm not complaining about driving. It's just that time that I spent in the car, that I used to spend in the car, now all that time I can spend preparing either that arbitration or a different case. I have so much more time to work on each individual case. And I find that in arbitration, I can present things online. I typically use PowerPoint, but I'll do a PowerPoint for the plaintiff's cross-examination and for closing. And that isn't something that I would necessarily do at an in-person arbitration. It would just be all verbal. And when I'm putting that exhibit, that medical record or that deposition transcript right in front of my arbitrator and underlining it as I go, that's a very effective way to put everything in front of the arbitrator at one time. I feel like for me, it's a persuasive way to advocate in front of a sophisticated finder of fact. I really like the online format specifically for arbitrations. I haven't done a bench trial, but I would imagine it would be the same type of thing.
Can I ask you, Coreen, did you actually put the medical record up on the screen share and then you underline it or highlight it? Is that what you do?
I do.
Okay.
Mm-hmm.
Can you teach me that?
I absolutely. I love talking about technology, and I will teach you that at 3 o'clock.
And I'll just say on the topic of bench trials, I'm in favor of bench trials continuing to be remote when and if hopefully the pandemic abates and everybody's vaccinated and whatever the new normal is comes about. There isn't, in my view, a strong business case to have many in-person bench trials. If I'm the finder of fact, you can convince me just as much in person as you can on screen. There may be reasons, particularly maybe there's a lot of documentary evidence or something that doesn't translate well to a screen, but I'm in favor of continuing to have bench trials remotely, and I think that they work well. And it's great for me. I've got a couple of monitors going. I'm taking all of my notes, which I have to do a lot more of as a fact finder. So I think they work well.
And for the first time, I can actually look the witness straight in the eye, straight on. So I have to say, Judge Peckman, absolutely right on that. I get asked that question, what's the future of civil bench trials and civil jury trials a lot. And I know that there are some that think that I'm an advocate. Candidly, I'm not a particularly big fan of technology, but ultimately there are forces, cultural forces, economic forces. They're like the ocean. They require no force to sustain. And the reason why this and having the repertoire, the skill set to be able to do these kinds of trials will be it's going to be an important thing for practitioners to have from this point on. It's not because the courts like it for a particular reason. It's not because plaintiffs like it or dislike it, or the defense bar likes it, or your insurance carrier likes it or doesn't like it. At the end of the day, what's going to drive the train on this is economics and culture. In King County, it's the culture of inclusion, because we get more diverse jury pools and we get more responses. It is easier for individuals to be able to participate. Economics, well, Coreen's talked about that. But the reality is, once we are at a place where the lawyers are being ordered to go back into the courtroom, I have absolutely no doubt that at that point, the economics of the situation will assert itself. The safety issues will assert themselves. But ultimately, from the perspective of your clients, you doing a virtual trial from your office is less expensive for them than it is for you to do it in the courthouse. And long-term, it's going to drive the train.
And I guess just one thing I would add to that, based upon the debrief that I did with my jurors afterwards, I would say about maybe about 9 jurors stayed behind. And of that 9, I think 3 or 4 had prior jury experience. And to a person, they said, we love this. It was so much better. They'd been on trials. I'm not sure it was the downtown courthouse or the Kent courthouse, but they had been in juries, and they said, when there needed to be a private conversation between the judge and the lawyers, we didn't have to get up and go out of the room. We didn't have to sit and be herded, from the main jury room at the courthouse up to an individual and, sort of lined up in the hall like kindergartners. They just really liked the process much better. And I think that's also going to be a driver. You're going to get people who are a lot more willing to serve on jurors. That goes to the inclusion issue than you would be if you make people continue to go to, brick and mortar courthouses all over King County. So
we did get a question, Jason, that relates to, and I think the phrase "lost in translation" was used, and it referenced, quote, ridiculously high jury awards that we've seen since COVID. And if we have just a moment, might we talk about trying to parse through the difference between the effect of COVID and as it relates to isolation on jury awards and the effect of this media? Is that something, Scott, Coreen, Judge Keenan, Jason, that you guys would be willing to just take 3 minutes and talk about?
Well, I can jump in. I did contact Jury Verdicts Northwest in advance in hopes that they could give me some data from 2020 on verdicts. And they didn't have it parsed out in terms of which trials were in person, which were hybrid, and which were fully remote. So they weren't able to give me the information that I specifically wanted. My sense in general is that jury verdicts have been going up for the last several years. And now we've got all these confounding factors with a pandemic, we've got economic crisis, we've got so much going on now that I really would, I mean, and I have to jump in and say, I love being in trial in person. It's my favorite part of my job. I can't wait to do it again. I have had fun doing online trial too. Part of it's just my attitude. I'm going to have fun doing just about anything. But I honestly didn't feel like I had a disadvantage being on Zoom. My verdict was, it was a lot of money, but when you look at the facts of the case that I litigated and the amount that plaintiffs were asking for, it wasn't a verdict that it would have shocked me in person. I mean, it wasn't what I wanted or what I was expecting going into trial, but it's not something I would have looked at and thought, oh my gosh, what happened here? It's just, it's just one of those things. And I can't blame it on a remote format or Zoom or distraction or anything specific. I really think it's leaping to conclusions to say that Zoom leads to high verdicts for plaintiffs. I don't think we can make that connection quite yet.
Scott, Judge Keenan, Jason?
Nothing further.
I'd like to offer this observation of the trials that I both observed, and I do some monitoring of our verdicts here and actually nationally, because I wind up getting contacted by judges. I think that the presumption that you're getting higher verdicts is incorrect. Judge Feltman actually speaks very strongly about this. In the cases that I personally handled, in the cases that I've learned of, specifically, Illinois just did their first one. The verdict came in less than half of the high-low. And what I'm seeing is actually, despite COVID, we may be seeing, I can't say that they're lower, but I can absolutely say that they're not higher. I am seeing more variability that I think that I've traced back to, and again, you guys know me, because I've been, teaching for so long, and so I can't help myself but sit there and take notes about how the lawyers are asking questions and how they're relating to the jury. I do have to say, I firmly believe that the nature of the verdict is more closely tied to the skill set of the lawyer. And I think that, and to the extent that we're going to attribute that to the form, it's because you got to remember this. When you're in a Zoom format, you're 3 feet away from your jurors. Aggression doesn't play well. You don't have the courtroom to absorb the aggression. And the ability to connect and communicate, and your ability to ask good questions that that advance your case theory, to have a case theory that's understandable, that resonates with the jury. These are core skill sets. And what I'm seeing is those core skill sets directly correlate to the nature of the verdict, more so in this format, because I think you're just more center stage, ironically. Jason, that's all I got.
All right, thanks, Judge Williams. I'll give Judge Keenan, Scott, and Coreen any last thoughts. All right. Well, thank you all very, very much for attending today. And with that, we will move on to our next speaker. Thank you, Judge Keenan, Judge Williams, Coreen, and Scott. And we will get to hear from Coreen again in a little bit after our mid-afternoon break. All right. Our next speaker is Betsy Smith. She's going to be speaking on the civil arbitration update today. And Betsy's been an insurance defense attorney in both Florida and Washington for 32 years. She's currently the managing trial attorney representing Nationwide across Washington State. So without further ado, I'll turn it over to Betsy.
Hey, thanks, Jason. Hello, everybody. I just want to throw in one little note about our prior presentation. I think that the expert costs are going down in virtual trials as well, because you don't have to have your expert sitting out in the hallway for a day and a half, and you can control how much they spend spinning their wheels. So keep that in mind as well. So civil arbitration, I'm going to try and start my screen from the beginning. Somebody tell me, can you see it?
Not yet.
Oh, I didn't share, duh. I have too many screens, just like other people. Hang on.
Betsy, I was going to say, we got about a 5-minute late start, so feel free to take your full
That's
time.
cool, thanks. So now can you see it?
Yes.
Civil arbitration, you can see my, great, okay. So it's so good to see everybody. I appreciate the opportunity to talk about civil arbitration and the 2018 amendments. I was kind of surprised that we're still having questions on the WDTL about a listserv about, is it $100,000 per claim, per action, per party? And so when Jason asked me to do a little of this, it gave me a chance to do some work and to do a little research that I don't generally do, and do a little survey that I'll go through at the end. So mandatory arbitration, we all know, is the statutory system that's designed to take relatively small and simple cases off of the court's docket and resolve them quickly and inexpensively. Small and simple is a relative term. We just heard about Zoom trials and where things are going and the backlog on the King County Court's dockets. I think that's probably indicative of the backlog all over the state. And we're going to be dealing with people wanting alternative ways to try cases. And I know that there's some talk about increasing the limit on MAR, well, I'm sorry, civil arbitration. And I think people will push for that so that we're no longer talking about $25,000 or $50,000 cases or even $100,000 claims. We might be talking about $250,000 claims. And in my opinion, if we don't have a change in the discovery rules, those $250,000 cases are going to become, the $25,000 cases of the past. So let's just get started here. First of all, I forgot to tell you all this. I'm an employee of Nationwide Mutual Insurance Company, but I'm here on my own today. So this is the obligatory disclaimer that I have to put up. These are my opinions. These are not the company's opinions. And the company will disavow me if you throw my opinions in their face in some sort of bad faith case or a deck action down the road. So just giving you that information. So let's just dive right into the amendment. Back in 2018, they amended RCW 7.06 in a number of ways. They preserve the purpose, which is judicial economy, by providing a simplified and economical way to resolve disputes involving claims of $100,000 or less. I think we're well past is this a $50,000 claim or is this a $100,000 claim? All of that transition time is passed. So now we're just talking about $100,000 or less. The change to the name was to remove the word mandatory and change it to civil arbitration. We still get things from even King County that call it mandatory arbitration. We still call it mandatory arbitration. And my team in my office get on my case about the fact that I insist on calling it civil arbitration. And my shorthand for civil arbitration is CARB. I love carbs, so it just makes sense. They increased the limit to $100,000 in 7.06.020. That's exclusive of interest and costs, and we'll talk about whether that's per case or per claim a little bit further down, but they increased the limit to $100,000. They added this new section mandating that the hearing occur within 21 to 75 days from the assignment of the arbitrator. So they codified what had generally been court rules. And they added 7.060.04 or O dealing with discovery. you know, this is really a tough one for me, and it's really frustrating because you get a complaint, and within the complaint, the attorney says, I'm putting this into civil arbitration or mandatory arbitration. Don't bother sending us, you know, regular discovery. Until the case is actually in civil arbitration, you have a right to serve basic discovery that's within the rules of your local jurisdiction. But the problem comes when you try to compel that discovery, and this civil arbitration appointment or assignment is looming over the head of the parties. So if there's ever a time to front load your cases, it's now. And nobody's, as far as I can tell from my research, nobody's tested whether a motion to compel in a case where the plaintiff's attorney has stated in their complaint that they're going to put this into civil arbitration is granted or denied based on that allegation that they're going to put it into civil arbitration. It'll be interesting to see if that ever goes anywhere. For the most part, realistically, we all either have some sort of agreement with the plaintiff's attorney, or we just give in and send out the arbitration interrogatories, which are no longer valid. Right now, since 2018, technically discovery has been limited to requests for admissions, depositions of the party, and you have the ability to request a CR 35, but it's not guaranteed. Again, my research hasn't yielded any reported decisions about an arbitrator's rejection of the CR 35 request. I'm sure it's coming. It just hasn't made its way up through the courts yet. I don't think that RFAs do us much good in an arbitration. What we need is the medical records. What we need is answers to interrogatories that give us the stuff we need to evaluate the damages and prepare for a hearing. And we're not getting that any longer through the discovery under this amendment. The next amendment was the addition of the requirement that the de novo request has to be signed by the party. And this is an interesting one that, you know, somebody might want to chime in a little later when we're talking about questions and answers. Under current court orders, criminally, criminal defendants don't have to sign things. I wonder whether or not civil defendants have to sign things like this de novo request. I'm not going to test it. I don't want to run the risk of being the one who tests that. But it's a question that I've had over the last 6 or 8 months since the COVID orders have taken away the need to have a wet signature and a signature by a party in criminal matters. But right now it says that, you know, the statute requires that we have a signature by the party in a de novo. And the last change to the nope, I'm sorry. Yeah, the last change is that not all counties have civil arbitration. See, this happens to everybody. We get a little ahead of ourselves. So I want to go back though for a minute and talk about how the civil rules correspond with the statutory changes. Of course, they changed the name in the civil rules. They changed the rules to comport with these statutory changes. You know, the qualifications of the arbitrator have changed. They've got to take a course, and that's set forth in the Civil Superior Court Civil Arbitration Rules. That's a mouthful, isn't it? And under 4.2, the discovery rule, they specifically took out of that rule this phrase: the arbitrator will allow discovery only when reasonably necessary. The conference requirement of CR 26I shall not apply to motions to the arbitrator to allow additional discovery under this rule. They took that out. And so you've got to think that if the court took that out of the rules, they meant for it to be out, and they meant that the arbitrator doesn't have discretion to award allow other discovery. And I think that arguably it requires a 26I conference now, since they took it out of the rule. Used to be in the rules that the notice of hearing was 63 days. Now it's 75 days as a maximum. And they reiterated the requirement for a signature. I think the most interesting change to the rules when they comported it with the statute was this discovery omission on allowing discovery and the CR26I conferences. So the big question on everybody's mind was, is a civil claim synonymous with a civil action? We've had, I'd say once or twice a quarter, we get a WDTL listserv question that says, I've got 2 plaintiffs, 2 accidents. Can the plaintiff get $100,000 from each car accident, or is it just $100,000 total in the action, 2 different dates of accidents? So let's talk about how we decide whether this is a $100,000 per claim or $100,000 per action. First of all, let's talk about the limits, whether they're per claim or per action. When the legislature uses 2 different terms in the same statute, it's presumed that the legislature intends each term to have a different meaning. I am not a statutory construction guru. I avoid that like the plague, but sometimes you've got to look at it. And in this case, the statute says that an action is subject to civil arbitration. I still can't get it right. When all the claims are $100,000 or less. And if you look at the Twitchell decision, which is an old, well, it's relatively old. I'm old, but this is not as old as me. It's from 2005. The Christensen case, I mean, they talked about civil actions and the parties' claims. The action is what's subject to mandatory arbitration, not individual claims. So in order for an action to be subject to civil arbitration now, you've got to have all parties waiving claims in excess of the statutory limitation, and that's straight out of Christensen. In other words, if you've got a plaintiff and several claimants, a plaintiff and their 4 children, let's say, which is a case that I had in civil arbitration, and you have a $50,000 policy limit, and each of the claimants claims $50,000, they can all go to civil arbitration because nobody's claim is greater than the civil arbitration limit. But if one of those claimants asserted that their claim was worth $1 million, that would defeat the eligibility of the entire case to civil arbitration. How does plaintiffs fix that? They segregate the $1 million case from the others. That's what they need to do. But essentially under Christensen, if one party in a multi-party claim has a claim that's excess of the civil arbitration limit, then it's not subject to civil arbitration. And that case was also exemplified, or that decision was recently dealt with in 2013 in Twitchell, where two people had filed suit against a kennel owner for allowing their Rottweilers to kill their small dog. And each of the plaintiffs claimed their own individual claim for, at that time, $50,000. And the defense attorney took the position that because the claim total was $100,000 and the MAR limits at the time were $50,000, that this case wasn't subject to civil arbitration or mandatory arbitration at the time. In Twitchell, the court made it very clear. It's not the aggregate of the claims, it's each individual claim. So if party A has a $50,000 claim and party B has a $50,000 claim, it doesn't matter that the total would be $100,000 back when the limit was $50,000. So those 2 cases are something to take a look at in terms of statutory construction and analysis of this question when people come asking you, is this a case that's worth putting into civil arbitration, or can we object to civil arbitration? So one of the really cool things that I want to talk about is Zoom arbitrations. I'm not ready to do the civil survey yet, but that's my next slide. Under RCW 7.06.043, the courts have ruled, or the legislature ruled, that the hearing has to take place in appropriate facilities provided or authorized by the court. Arguably, the Washington Supreme Court's orders, the most recent of 2/19/21, provide a safe haven for us to insist that these be by Zoom. The Supreme Court's order says, quote, hearings we should continue using remote proceedings for public health and safety whenever appropriate. There have been a couple of instances that I've heard about where the arbitrator doesn't want to do it by Zoom, or another attorney doesn't want to do it by Zoom. I think that you can use this language from the Washington Supreme Court's order to influence the participants to do this by Zoom. The Washington's order also authorizes all proceedings to be conducted by remote means. And so if you can't observe strict social distancing and public health measures, again, you should be citing to this Washington Supreme Court order to try and convince other counsel, whether it's co-defendant or plaintiff, to do this by Zoom. Anecdotally, I recalled seeing a WDTL listserv subject or email about one instance where after 2 days of depositions involving 4 attorneys, witnesses and the court reporter, 50% of the participants tested positive for COVID-19. Do we know that they contracted COVID-19 at that deposition? No, but it certainly is coincidental that these people were all together in a room doing depositions for 2 days, supposedly doing everything they can to protect each other, and still somebody got sick. It's just an anecdote. I certainly don't encourage my folks to go out to in-person things if they can avoid it. The Supreme Court also said there's a presumption of remote depositions and a presumption of remote service other than initial service or third-party witnesses. And this part of the order supports a position that arbitration hearings should be remote. And finally, the order from the Supreme Court encourages parties to stipulate to reasonable modifications of civil matter aspects, discovery, pretrial hearings, and alternative dispute. It's logical that civil arbitration hearings should be remote. I'd be interested in input from anybody through the WDTL listserv, or if we have time at the end of my half an hour, to talk about their own instances where they've had arbitrators who didn't want to do a Zoom arbitration, or plaintiffs' attorneys who didn't want to do a Zoom arbitration. So I had this great idea about doing a survey, and wait a minute. And so I sent out a survey to WDTL on a little form, and we had 23 people responding, and I'm really pleased with that. I appreciate it very much. And basically, I was looking for information on arbitrations since February 2020. And here's what we found. We got, since February 2020 until roughly a month ago, of these 23 people, they had 184 civil arbitration hearings. Of those 184 civil arbitration hearings, 112 were by Zoom. That's a pretty significant number of arbitrations by Zoom. Then I asked questions about the award levels. And you see here that the bulk of the awards were between $0 and $40,000. So 112 of the 184 were below $40,000. So we're not getting the bulk of them at $100,000. We had 26 that were at up to $50,000, and you see the numbers go down as we go higher. We had 3 that were excess of the jurisdictional limits. So again, just as Judge Williams said, I think our collective perception is that arbitration awards are higher, and this is a totally unscientific survey, But it would seem that the arbitration awards are still within that lower number, the 25 to 50. And I would encourage all of us to do our homework and figure out a way to quantify the results of these arbitration awards in a scientific way. Not my survey, it wasn't scientific. Because the time's going to come when the legislature considers whether to increase the limit and whether the legislature decides to change the discovery rules. And if we don't have documentation for that, we can't make a change happen. In a prior life, I was a negotiator for a teachers union, and I spent times arguing with my constituents that I needed evidence, just like we need evidence in courtrooms. I needed evidence that changes that they wanted in the collective bargaining agreement called for and justified what I was going to put in front of the school district. It's the same here. We have, as a group, have to work together to figure out how to convince the legislature that the civil arbitration rules, if they're going to increase the limits, there's got to be a change in the discovery. So then I also had times from everybody to give me some comments from their survey, and basically the comments, again, not scientific at all, were that the arbitration awards were, quote, clearly trending higher. It doesn't matter if the arbitrator is a plaintiff's attorney or a defense attorney. That one case, they awarded $70,000 in general damages on a $4,800 special damages case. Another case, a career-long in-house defense attorney awarded $35,000 in generals and $10,000 in medicals, where there was only $300 property damage to both cards. One of our colleagues told me that they feel pressured to issue awards somewhere in the middle, so to prevent an appeal. This person didn't see the landscape changing anytime soon. And they expressed an opinion that they thought that the arbitrator was just like daring the defense to appeal by giving such a high award. I dare say that we don't want to appeal just because we think somebody was daring us to do so. I see another comment was, I see deliberate efforts to move matters into arbitration to avoid participating in discovery. There are fewer cases getting to hearing, but that's more the particular insurer involved than anything else. One person said to me, for some reason, liability defenses, which I viewed as strong, were not well received by arbitrators during Zoom arbitrations. And you know, the same argument that I have was a comment by somebody else, quote, defendants are allowed almost no helpful discovery. Rules provided for a CR35 exam, yet I've yet to see an arbitrator award one. Those kinds of things we need to be identifying and quantifying so that we have the evidence that we can use if we want to see a change in the statute. And then the last comment that I had that I received was based on discussions with colleagues and my own experience as an arbitrator. I think Zoom arbitrations will continue beyond the pandemic. Telephonic testimony was already common, and teleconferencing is a better option. I don't think that there is much of a difference between an arbitration over Zoom and a trial over Zoom, other than the jury part of it, of course. But you've got to have the same set of skills. You've got to have the same comfortability with the camera and with the technology, or have somebody to help you with the technology that you can rely on. Jason, I haven't looked to see if there's any questions or not. I will share the survey results so you can see the comments and the quantity of responses with everybody down the road. But with that, I have nothing further. I hope that answers the question about, is it $100,000 per case or $100,000 per claim?
Thank you, Betsy. I appreciate that. And don't see any questions at the moment. So we will go ahead and go into our afternoon break at this point. We will reconvene at 3 o'clock for Coreen Wilson's presentation on technology and presentation tips for remote and hybrid remote litigation.
Hey,
And
Jason.
I'm going to turn it over to Maggie, I think, here.
Thank you.
Yes.
Don't tell people to leave just yet.
That's right. We have our prize drawing, so do stay connected if you can.
Yep.
And again, you can take this with you, I believe, on multiple devices. So,
right.
Go.
So when we are live, we have this afternoon break as our prize drawing. And so we tried to think of clever ways that we could incorporate our course sponsors, who of course are used to seeing you, talking to you, giving you swag, and of course collecting your business cards for prize drawings. So our solution was for our course sponsors to put together videos and draw your names ahead of time. So actually this time around, you didn't even have to put your card in their bowls. You were just automatically entered. So please stay with us for the next 10 minutes as we go through the course sponsors, announcements, and prize drawings. And I would just like to say that if you haven't already figured this out, our course sponsors are a great partner to WDTL. They help keep our doors open and me in my seat. So anyhow, we're gonna start now. We're gonna screen share and move on from here. Sorry, everybody, I just realized my presentation view is being blocked by my little video. There we go. Okay.
Hi, I'm Andy Walter from Northwest Medical. Thank you to Maggie and Kathleen for working hard to make this virtual conference a success. I look forward to personally connecting with you all again at the next DTL function. March Madness is starting up. It's daylight longer, and my allergies are back in the spring right around the corner. We'll all be getting back to outside activities, and barbecuing with family and friends is my #1 pastime. Being the neighborhood's #1 grill master, dedication, tricks of the trade. My little ones at home never need to focus 100% on my grill mastery. You know that my trade secret, a wireless grill thermometer. Not just any thermometer, 4 separate sensors: chicken, steak, vegetables, and fish all at once. You are now free to socialize with friends, refill your beverages, make separate mac and cheese dinner for your kids. The winner will instantly become the #1 grill master in the neighborhood. I look forward to seeing social folks celebrating the chief status as the neighborhood's #1 grill master. Again, thank you for the opportunity to participate in this virtual conference. Please don't hesitate to contact us at Northwest Medical Experts and review all your case medical expert options. Congratulations to the winner.
Yay, Garrett won the beat for thermometer. Andy will be in touch with you, Garrett, to get that to you. Congratulations.
It's alive. I'm JJ, professor of record history for solve problems. DCN Labs solve the problem of expensive medical records. How? High-tech medical records. How? High-tech medical records.
And this is from our core sponsor, Veritas. Forensic accounting, valuation, and economic research professionals. Yay, David. I'm sure Matt will be working with you to get that to you. $100 Visa gift card. And this is MKA, a multidisciplinary construction consulting firm. Thank you, MKA, for your sponsorship. And congratulations, Kara.
Join us for an upcoming WDTL webinar, Advanced Topics Explained in Accident Reconstruction, on Wednesday, March 31st at noon. Congratulations to the ESI raffle winner, Lori O'Toole from Preg. ESI, how can we help you?
Congratulations, Lori. And this is from Advanced Medical Group, and it looks like their drawing is for Betsy Davis. Congratulations, Betsy. You'll be getting a Bevmo gift card. Oh, there's two. Tiffany, you'll be getting one too. Woohoo! Congratulations. Oh, sorry. I'm trying to figure out how to start the video. There we go. Well, this is our core sponsor, Physician Direct Services, and I'm not quite sure why the video is not starting. Let me try again. Okay. I see Grace there, but I don't know how to get to the winner. We're going to get back to that one. And this is from JS Held. And JS Held is a global consulting firm. They have a number of experts. They're one of our core sponsors. And let's see what JS Held has for us. Oh, Keith, you are the winner. And Micah will be calling to arrange an exchange. So that would be Micah at JS Held. Oh, it's a wine basket. Even better. Way to go, Keith. Good job. I apologize. I believe at this time I am buffering. Twiddling our thumbs. This is just our time to congratulate Keith even more. Okay, I think we're gonna have to pause our, we don't want that. I think we're gonna have to pause this and let's see if we can get it going again. It's loading, but it's not doing what it's, oh, according to Diane Meyer, I need to quit PowerPoint and restart. Okay, well, we're gonna get back to this. Hold on, folks. I'm gonna stop screen sharing and we're gonna, okay. Oh. Hi, WDTL family. This is okay. Okay, I'm gonna see if this works. Sorry guys, this is super awkward. We are going to do, let's see. Hi, WDTL family. This is Grace from Physician Drug Services. Just a quick hello and hopeful that this trust update is doing well for 2021. So we here at CVS did a drawing for a $100 gift card for Amazon, and our winner goes to Chris Gibson from Forsberg and Umlauf. Quick update in regards to CVS is that we're scheduling nationally now. So if you have a claimant that lives out of state and needs help finding an expert in the state in which your claimant lives, really help you. So we've been navigating with Zoom and then also assisting with trials, depots, etc. We still are scheduling CR35s and INPs and record reviews, and we're adding to our expert list daily. We have over 500 plus experts, and we really fine tune in regards to your expert witness needs, and we provide estimates and etc. So please check us out on our website, physiciandirectservices.net, and hopeful that you have a great rest of the day. Oh, thanks, Grace.
Hi, I'm Diane Meyer, the founder of Legal Presentations. As a visual strategist trial consultant, I've had the privilege of helping attorneys win cases with strategic visuals for over 20 years. On average, adults spend about 11 hours a day staring at some type of screen. Now, jurors not only expect, but require information-rich visuals to stay engaged, understand your case, and ultimately be persuaded to your side. A boring document is simply a boring document and is not an information-rich visual. A creative call-out tells a story and can easily be recalled. Overview visuals can be animated to build one piece at a time before revealing the big picture. My work as a visual strategist involves analyzing, interpreting, and finding visual solutions to simplify complex case information. We often work directly with experts to strengthen their testimony and credibility.
Okay, I'm so sorry. Diane is awesome, and I'm just messing up her presentation, and I don't know how. So sorry, Diane. But let's go back. Let's see if we can go back. I'm trying to get the sound. Ugh.
Case information. We often work directly with experts to strengthen their testimony and credibility. We love partnering with our clients to brainstorm winning visual strategies for mediation and trial. As a proud sponsor of WDTL, we have a video conference light, and the winner goes to Reppart of Forsberg Umlauf. Congratulations, Kim.
Yay, congratulations, Kim, and thank you, Diane. You're awesome. And this is from McCann, who helped with medical records and IMEs. Irene, congratulations. $100 Nordstrom gift certificate. Whoop, whoop.
Hello, everyone. I'm Anthony DiLiberto, and I work with the experts at Robson Forensic. I wish we all had a chance to connect in person. It is a pleasure to show our support for WDTL members and raffle off a pair of Apple AirPod Pro headphones today. Quickly, for those of you who don't know, I work directly with the 95 experts at Robson Forensic out of our Seattle, Washington office. Our firm is specifically structured differently as we have no public shareholders or board of director influence. Now, we are a multidisciplinary firm offering engineering, technical, scientific, and standards of care experts for complex insurance and litigation. If you have an expert need, please reach out to us. We'd love to work with you. Now, without further delay, I will raffle off our Apple AirPod Pros. I've done this already on the site, and today our winner is Jason Baca of Reed McClure. Jason, I'll reach out directly and get you those Apple AirPod Pros. Thanks for taking the time to watch, everyone. Take care.
Wow, Jason, woohoo! I don't know if you've ever actually gotten a prize before, so that's awesome. This is Jensen Hughes. They do engineering consulting. And here's Burnson and Porter, forensic accounting. Doug McDaniel, many of you know him. Thank you, Burnson and Porter. Woohoo! Congratulations. Wow, way to go, guys. Thank you, Arca and Kristen. Okay, well, I appreciate you guys bearing with us through that. That clearly was not exactly how we planned for it to go. And I do realize the sound was lower than it should have been. But as we say that this is our first virtual insurance law update and our first virtual core sponsor raffle drawing. So we will get that worked out. But anyhow, we're so grateful for our core sponsors, and thank you all for being here. And I'm going to turn it over to Jason.
Thanks, Maggie. And welcome back for our last two speakers, our last session here for this year's seminar. And our first presenter is Coreen Wilson. She spoke previously as part of the panel when I introduced her at that time. So I'm not going to go over her qualifications again, but pretty much everybody in the business knows who Coreen Wilson is. She's going to talk today about remote and hybrid remote litigation, technology and presentation. Take it away, Coreen.
All right. Well, hello and welcome to remote litigation, where you don't have to like technology, but you do need to learn how to use it. Now, for those of you who are saying, no, I don't, you can't make me. This presentation is for you. And let me tell you why, because I'm going to show you a behind the scenes look at the kind of technology that your opponent may be using. And if you're the kind of person who says, well, I'm on the fence about the technology, I'd like to look a little better online, but I'm not sure I really want to get down into the weeds, this presentation is for you, because I'm going to show you cheap and easy ways, some ways that are even free, to level up your online presentation. And for those of you who are thinking, bring it all on, I want to know all the technology, I've got a little bit at the end for you specifically to show you some of the options that are available should you choose to get down in the weeds and into this new technology. So with that, I'm going to start out with three things. There we go. Start out with three things that will blow your mind. The first is that Zoom fatigue really isn't our major problem here, because it's not that we're tired of looking at screens. Shares of Netflix have gone up in value. In fact, we spend most of our days looking at screens, and I can guarantee you that at the end of a long day of Zoom calls, you're probably going to go home and look at the big screen of your TV while also looking at the small screen of your phone. It's not that we don't want to look at screens, so we don't want to be bored. The second is that we'll pay to look good online, but not in person. And for those of you wondering, that's a picture of ZZ Top, sharp dressed man. Most of you probably don't even get the reference, but think of it this way, okay? How much time and money do you spend on your personal appearance when you're going into court or going into an important proceeding? What do you do to make sure that you're presenting as a polished professional? Do you put that same amount of effort into looking good online? Finally, none of this matters if you can't present your evidence. Even if your evidence is admitted into the record, whether it be at arbitration or at trial, if you're trying to use something at a deposition and it ends up getting attached to the final copy, if you can't actually interact with that exhibit, highlight the proportions that you're talking about and really make those stand out in the mind of the trier of fact, you're doing yourself a great disservice. Mastering the screen share is your first priority. So with that, I am going to take a second to change cameras. There we go. And start out with some easy ways that you can right now level up your online presentations without having a whole lot of technical knowledge and without spending a whole lot of money. So let's start out with cameras and angles. Now I'm going to show you one of the worst pictures I've ever taken, which is actually not true. It's a horrible picture of me, but probably not the worst. This is from my laptop webcam when I was trying to set up for the Zoom trial I did last year. And I had planned on using my laptop because I didn't know any better. And this is how it looked. I quickly learned that looking good online isn't as easy as one might hope. It actually takes a little planning and forethought. And one of the best ways to improve your online appearance is to switch from using a laptop webcam, which are notoriously the worst cameras out there, to using an external webcam. So let me show you the difference that it makes when you use an external webcam. This is from my laptop webcam. It's a bad angle, not great quality. That's from an external webcam. That's how it looks when you just change your camera and your angle. Now, the lighting obviously is horrible, but the change in angle makes a significant difference in looking good online. We'll fine tune the lighting later. The problem with the laptop camera is that it's reminiscent of Frankenstein. This is actually a screenshot that was taken from the 1930s version of the movie. And the director specifically shot the angle from below looking up because it made Frankenstein look scary and menacing and monster-like. And my guess is that's probably not what you're going for in your online proceedings. So you don't want your camera looking down from below, angled up your nose. That's not the best look for you. So how do you get to the freestanding webcam? Well, let me show you. This is what I've got. It's not what I'm using right now, but this is what I've got. This is a camera that you can easily find on Amazon right now. I just looked it up. It is $79.99, and it looks like this. See? Nothing to be afraid of, just a little webcam. All you have to do is plug it into your USB port. That is it. It is ready to use when you plug it into your USB port. I recommend using one of those flexible stands for reasons I'll get into a little bit later, but all you need to know for now is you can change your camera angle really easy if you have one of these flexible gooseneck stands. So get yourself a camera, put it on a stand, and you're already well on your way to looking good online. Next thing you need to look at is lighting. And I was talking to an attorney, a few days ago, who said he'd gotten himself a microphone, which is one of the first things that people do. If they want to look better online, they get themselves a microphone and a ring light. Well, he gotten himself a microphone and he said, well, I'm going to go buy myself a ring light. And I told him, if you really want a ring light, get one, but that's not the best light for you. And he says to me, well, but Kim Kardashian has one. And by all means, if you look like Kim Kardashian, a ring light is all you need. You can probably still use your laptop webcam. Get your ring light, you're good to go. But for the rest of us, we need something a little bit better. Let me show you the difference that different lighting makes. Let's go back to, this is me with the overhead lighting. And I'm overexposed. It's not particularly flattering. That's desk lights. So I just use regular table lamps, and the color is a little bit off, but it's better than the overhead lighting. This is ring lights, better color, but still not that great. And this is what happens when I upgrade to a 3-point studio lighting setup. That's what I'm using today, is the 3-point studio lighting setup. And a lot of you are thinking, okay, that's ridiculous. I'm not going to buy 3 lights. I don't care how much they cost or how big they are. That's too much for me. That's fine. I'm not going to push anybody into looking good online if you don't want to. But if you do want to, here are a couple of lights to take a look at. And this is what I recommend, is these LED panel lights. Even if you just get one, just think about this. Just get one and use your natural light from your window. Hopefully you have a window in your office or whatever your online setup is. And use the combination of LED panel light and your natural light, and you're already going to look much better online. I have a description of a 3-point lighting setup in my materials. So there's a short video that I've linked to that gives you some great information on how to set that up, budget-friendly ways to set that up, if you're interested. If not, just get yourself that light and the one light, and you'll already level up. If you want the 3-point, you notice this is only 2 of the 3. Let me show you the third. That's the third light that I have. And this is, you can see, this is what happens when you don't use a gooseneck stand for your webcam. This is an external webcam, and I have it mounted on top of my monitor, which is sitting up very high today, and really is not a great angle for me to be using. So this is, that's what the overhead light looks like. Some of you probably don't have space for that, and that's fine, because you can achieve the same look by doing a color contrast through wardrobe. And what you'll notice is that today I'm wearing blue. In those videos, I was wearing black. And the reason I was wearing black is because it looks terrible. And I wanted to show you how bad it looks. So let's look and see what happens when I change from black to white to a neutral color. Now, black is not going to give you any definition. It's blobby. Same thing when I go to all white, and you can see how my camera had to auto adjust to the bright light. So I switched and decided, let's try neutrals instead that pop against the background. Much better. What you need is a contrast between you and your background. Now, some of you may have a white wall behind you, and you may not have a ton of dark hair. And in that instance, maybe a black top works great for you because you have that contrast. The backlight here, this hair light, creates a contrast between me and my backdrop, but you can do the same thing with clothing if you don't want to go to the expense of the lighting setup. So that's one thing to be mindful of, is what you're wearing. So now let's talk about microphones. Microphones are the favorite toy of people who are trying to look and sound better online. And what most people end up getting is either a Blue Yeti or a Rode microphone, and they're USB mics and have a sound card built in, and that's terrific. If you want to go that route, you're going to spend a couple $100s. The sound cards are, like I said, already built in, so you don't have to worry about that. But here's a couple of things that I want you to think about before you spend that money. First is that if you're that worried about sound quality, you need to be wearing headphones. I'm wearing headphones, and the reason is because I don't want the feedback through the microphone. So wear headphones, don't use speakers from any source. That's going to improve your sound quality right away. And if you're spending a few $100s on a microphone, you're definitely going to want to make sure you use headphones. The second thing is the microphone is going to help, but you really need to be mindful of the acoustics of your space. So if you've got a gigantic conference room that just has a big long glass or wood table in the middle and doesn't have a lot else going on, you're going to have a lot of reverberation. And you want to think about, is that really the best space to be doing your online presentation for? Because the microphone can only compensate so much. This is the microphone that I have. And what you'll notice is that it's a 3.5 millimeter jack. So it's, instead of the USB, I've got a little audio plug-in. The reason that I have that is because of the type of setup I'm using. So if you, before you go spend a few $100s on your USB microphone, think about, okay, where do I want to go from here? If all you want to do is just add a couple things to your setup and then stop, and you don't necessarily need room to grow because you're not in love with the technology, USB mic is fine. If you do think that you want to, say, set up some kind of production studio in your office or some online litigation studio in your office, or at least have the flexibility to do that, this type of a microphone is going to be a little bit better. I didn't spend a ton of money on it. I didn't think it was necessary in order to improve my sound quality. So let me show you so these are the USB mics. This is the Rode right here. And this is the Blue Yeti. The Blue Yeti is probably the most popular one right now. That one is, I don't know if you can see, it's $129.99. They have a ton, a whole wardrobe of microphones that you can look through. So let's look at the setup. Let me show you the kind of setup that I'm running right now. Don't hyperventilate. This is a setup that I can do entirely by myself. See, there's no one else here. I've got my 2 LED panel lights. I've got 2 monitors because it is so much easier to use 2 monitors. I've got a camera here, the camera that you're looking at, and then I've got my PowerPoint over here on this laptop. I'm also, you've probably seen using a stylus to both write on the screen of my laptop and click through my presentation on my laptop. I can do all of this on my own without having tech support. But what I will tell you is that you may notice at different points during the presentation, I look or sound a little bit distracted. I'm not looking at the camera. That's because the point today is to show you a bunch of different technology. It's far more technology than I would attempt to incorporate into a trial presentation on my own, but I want to show you the range of what's available. So let me give you, let's switch. One of the common questions I get is, what about this thing behind you? Is this a green screen? This is not a green screen. This is a real live bookcase, because I don't know how to use green screens, but never fear, I know somebody who does. And so I interviewed him, and I'm going to give you his words of wisdom on how to use a green screen if that's something that you want to do. It's something that you'd have to reserve for out of court because most courts don't allow them, but here's what he has to say on green screens. Thanks for joining us. And for everyone who doesn't know him, this is Matthew Dobler. He is a noted trial attorney in Pennsylvania and a tech genius extraordinaire. And he has agreed to share with me some ideas and tips on green screens. So to start out, can you give us an idea of what a green screen is?
Sure. A green screen is simply a background. So here's a green screen, right? It's a background, and my green screen is a curtain. So I think you can kind of see me. There's probably enough light that you can see. It's just a backdrop. And what you do is you take a computer program and you carefully tell the computer program to erase all the parts of green that it sees and replace it with something else. So I usually use black, but you can use other things. So you can, for example, here's my computer. I can just replace it with my computer. And that's all I'll show you for now. But you can easily, anything that you can put on your computer, then you can put in the backdrop. So that's the short answer.
All right. So give us an idea of what the options are with green screens in terms of how would you use one at, say, a deposition or mediation or some other type of proceeding?
How could you use one, or how would I use one?
Let's start with how you would use one.
Yeah, how do I use one? The only thing that I use one for right now is for what you see, is that I replace my background. I always use a plain black background, and I get that with the green screen. So that's really the only thing that I do. You could pretty easily put a document up on the background and just sort of show yourself with hovering in front of a document, and you could do, as they'd say, weatherman style, you could do something like that. So again, like it would look similar to this. You could put a document up here, and rather than having a PowerPoint, you could have a document up there. You could, of course, you could have a PowerPoint up here too, and you could sit here and you could be changing your slides as you go. So a couple different ways to do it, but again, I've not figured out a way that I can be paying attention to the deposition and paying attention to what's going on in the background well enough yet.
And so is that why you typically just use a black backdrop instead of your computer screen?
Yeah, the other issue is, I don't want to get too technically deep here, but I think the way to say it is just readability. That sometimes when documents go up on these sort of electronic presentations, they become very hard to read. So that doesn't mean that it's impossible. You can certainly, there's some techniques that you can use to avoid that. So making your text very large, for example, or there's some scaling issues you can get into if you want to talk about a more technical approach. But they make it more difficult to do in the moment. And again, the thing that I think is the beauty of online litigation and of online depositions in particular is that ability to really be present in the moment. And I find, and listen, nobody loves the technology more than me. Nobody. But I find that if I'm a slave to the technology, then I can't be present in the moment in the deposition the way I need to be. Here's the other thing that I think is important for people to know about green screen. And it's interesting because you talk about this, and I've heard Judge Matthews.
Judge Williams. Matt Williams.
I've heard Judge Williams talk. Matt Williams, right? Thank you. I've heard him talking about prohibition against backgrounds. And I just want to clarify a couple things here, okay? So maybe I'll arm you with this knowledge, and you can do what you want with this.
Okay.
The thing about bandwidth and fancy backgrounds has to do with the virtual background, not the green screen background. So they're different, right? What everybody else knows about a fancy background is a Zoom virtual background, right? That's different than what I'm talking about with a green screen keyed in the ATEM Mini. If you do what we're talking about here with a keyed green screen background where something like the ATEM Mini is doing that work, then Zoom doesn't care what's behind you. It doesn't know if it's green or black or it's veil, or it doesn't care. To Zoom, it's just video. It's the same, just video. So there should be no objection from a technical perspective to using a keyed green screen background during court. The objection is that I've always understood is that since it eats up bandwidth, and that is valid. That is valid. That concern that virtual backgrounds through Zoom, especially when you're in Zoom rooms that have a lot of people in them. We were in a charity event over the weekend where there were hundreds of people in there. And every time they played any video, they asked everybody to turn off their video altogether in order to try to preserve bandwidth and try to keep things moving, which was something I had never seen before. But again, that concern about bandwidth versus backgrounds is real. It, however, should be eliminated if you are keying the background at your point of service the way I'm talking about here. Does that all make sense?
That makes sense to me.
Yeah.
Yeah, I think that makes sense. Yeah, because if you feed it through the ATEM, Zoom's only getting one image.
Correct. That's exactly right. Zoom has no idea Zoom just sees it as webcam, right? Zoom just sees external webcam. Yeah. And then once you do that, and that's really the beauty there again, we get back to the beauty of the ATEM. I mean, to me, green screen is really just a natural evolution of the ATEM process. So sooner or later, I wholly expect to see you. You showed up one day with better lights. You showed up one day with a better microphone. I fully expect that one day you're going to show up with a green screen and you're going to be asking me questions about it, because it is the thing that makes it so that you can do this, right? Yeah. It is the thing that makes it so that you can do this. It is the thing that makes it so that you can do all the tricks, but that's ATEM. It's ATEM, and it's ATEM being able to say, I know the ATEM and only ATEM can look at this image and say, get rid of all the green. The thing that's left is matte. And once it knows where matte is, you can say, put matte on top of the computer, or put matte behind a key, or like, once you tell the computer what's what, it can composite layers for you.
Yeah. Yeah. Very cool. I only know how to do part of that, but I am learning.
But it's all on the path. I mean, one thing leads to the next, leads to the next, leads to the next.
All right. So I got a couple of questions during that video. One was, how hard is it to switch cameras? On Zoom, if you look at the bottom left-hand corner, there's the mute button and the button that says stop video. That stop video button has a little gray arrow next to it. And if you click on that gray arrow, you will see all of the available cameras. And I can just switch from one camera to the next, to the next, to the next, and do that with a mouse click. It's very, very easy. However, when I do something like this, I'm doing it with this device right here, which is the ATEM that Matt was referring to. And that's a production switcher, which is also easy. I'm just pushing a button. However, there is a learning curve, but I'm going to get to the ATEM later because it's a little bit more advanced and probably not something that a lot of you want to use. If people have questions about the ATEM, like jump in and I'm happy to spend more time talking about it. But my guess is that most people probably aren't going to want to take it to that level, at least not right now. So let's go into a few parting tips and words of advice on setup before I move on to screen share. And those are test your technology again and again and again. I said twice, but do it 3 or 4 or 5 times. Prep your lighting every single time because lighting does change. And so I actually had to change mine a little bit during the day today as the external lighting changed. Hardwire everything, 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 everything. Don't use battery backup, don't use Wi-Fi, and don't use Bluetooth. And some of you are thinking, oh, but I have a Bluetooth headset and it's worked great, and I am happy for you, but please have a backup headset that is wired, okay? Have backup cords. I had my power cord, my power strip fail on the first day of trial. Have an extra camera. I had my camera freeze during arbitration a couple weeks ago, and because I was able to switch cameras midstream, no issue. I mean, it literally took me 5 seconds. The arbitrator may not even remember that it happened. And scan everything. It's much easier if you have things scanned and ready to present. So that being said, let's move on to presentation pointers. And I have once again recruited the help of another expert on the topic. Now, I have some experience that I gained over the last year in doing this, but I thought who better to talk to than Stephen Kilbreth, who some of you may recognize from King 5 News. He also appears in person. He's an auctioneer, and so he does live auctions, and he has a history in radio broadcasting. So I asked him specifically, how do you appear dynamic on screen? And this is what he had to say. All right. Well, thank you very much, Stephen. I appreciate you helping us out with this. Can you give us some ideas or tips on how to be interesting and dynamic on screen as opposed to in person?
So certainly it does create a different dynamic. I mean, for me, I think the main difference is, you still can, use your hands. I mean, I was on TV this morning, my studio's over here, and I still was using my hands. I still, it's okay to do all of those things because that's real. I think being real and genuine and to your true, not trying to be something you're not, I think is probably better too. I think it's better to, maybe you can look at the camera, because see, my camera is right here, although you're right here. So I think looking at people in the eye is probably better, although it's hard because I can see you over here. But I think that's probably key. But it's also genuine to look around and look at papers and things like that. I know one thing that people have said in meetings is that when you're down and say you have your notes or stuff or you're written and you're going like this the whole time, I mean, that's not very engaging. For me, it's being engaging and interacting with people and just being your genuine self.
What do you think about using notes and a teleprompter, those sorts of things, doing that and still at the same time trying to be genuine and have your personality come through? How do you balance that?
So we do, I mean, I do, typically I'm an auctioneer. So I do about 70 events a year in a regular year. We've done about 30 to 35 virtual events, which all have had a teleprompter. I've been on TV for a long time, so we have a teleprompter there, although most of the stuff I do is all ad lib and not on a teleprompter. But I think that the key to, if you get a teleprompter app and you can have your camera and the teleprompter app and everything right next to each other, I think the key is to put bullet points on the teleprompter to remind you of things to say. If you write your full, your lines or your script or whatever you would call it, it's going to sound and look like you're reading, and we don't want that. So we do with our MCs and co-hosts and things like that, we put just bullet points just as a reminder of things to say. It'll say, point 1, and then it's easier to scroll too, because you're going to have to scroll it yourself, obviously, when you're doing your thing. But and you can do it with the keyboard, or there's foot pedals, or there's the mouse or whatever. There's a lot of different ways to do that. But I think just keeping it bullet points so you can talk around it. I think the main thing about being engaging is conversational, for sure.
Okay. What if something comes up like you freeze or your screen freezes? You have some sort of tech glitch or something come up that you didn't anticipate. How do you deal with that sort of thing?
Well, that is something that happens for sure. I was on TV the other day, and we, they said, "Oh, and there's Stephen, and he's frozen," but they could still hear me. So the camera had frozen, but they could still hear me. And of course, we've all been in meetings and things like that. I think it's the best way to do it is just kind of roll with it and have fun with it. The other day I lost my train of thought at a virtual event, and I was engaging with people in the chat room, and I was like, "Oh, Coreen said this," and then I just stopped because I couldn't think of anything to say, and I'm like, "Oh wait, she's not talking back to me because she can't," or something like that. And it's just you gotta be able to be self-deprecating and kind of make fun of those situations, and that's part of it. I think The good news is a year into this, people are kind of used to that now. Although they're used to it, but they also really want a polished production, if you will, as well. They want you to be experienced doing it. They want you to look the part, and I think that there's a lot of different things, but make sure your background. I think one of the advice things people do is not to have the green screens or those kind of backgrounds behind you. Big chairs like this, like you're in a perfect situation, because the big chairs like this make you appear, wider than maybe you want to be. So on TV, I have a little chair that I sit on. It's a wood chair. It's not comfortable, so I take it out when I'm not doing that. And there's just a lot of little nuance things like that you can do as well.
In transitioning your auction, your auctions from in-person to online, what was the biggest transition you had to make?
We do a lot more scripting. We're prepared for the shows, and there's, like I said before, there's no net. You can't stop talking. You have to keep moving. Nobody likes the dead air. You have to keep it entertaining and engaging, and that's the main thing.
And I appreciate you spending the time this morning. It's really helpful. I mean, like I said, it's a huge transition for us. All right, and those are some good words to live by in terms of being prepared and being scripted without being scripted, having your bullet points ready so that you can talk in a conversational way, but not in a way that looks like you're reading. Also, the tips about the background, I think, are really important. I don't use a green screen. Maybe someday I will. It's not something that I intend on working on now. But the tip about the chair is particularly important. But I think the most important thing that he said that I've learned in my own practice is tech glitches are going to happen. And when they happen, the best thing to do is, number one, just to have a sense of humor about it. But number two, you need to acknowledge it, because if you don't acknowledge it, everybody's going to wonder what's going on. Remember at the beginning of the presentation, when I switched cameras, I told you guys what I was doing, because I didn't want you to think that I had dropped off the call or was having some sort of technological difficulty. Talk your audience through it, but don't spend more than a few minutes. If you've got an issue, don't spend more than a minute or so troubleshooting. You need to have a backup plan. You need to be familiar enough with your technology to have a backup plan, whether it's switching cameras or what have you. You need to know how to solve the problem. So let's move on to evidence, how you share evidence on screen. And I'm going to go beyond the basic screen share that we all know, I hope by now, and show you a helpful tip, which is here's how to teach your host how to screen share. This is an issue that comes up anytime I don't host a meeting, almost every time I don't host a meeting, which is my host has not allowed screen share privileges and I need to screen share and they don't know how to do it. And the problem is, if you don't have screen share privileges, you don't have that button at the bottom of your screen, which means you can't see what they're seeing and you can't walk them through it. So what I've done is I've given you 3-step instructions, and I've put these in your materials so that when this happens to you, and if it hasn't happened to you already, I'd be shocked, but it will happen to you if it hasn't already, you can walk your host through how to screen share. Just keep these instructions handy. I actually saved them as a separate document for my materials so that you can keep those on hand. Now, beyond this basic technique, this is the basic screen share. This is at the top, it says basic. And you can share, you just click share, you pick whatever screen you want, not your desktop, but whatever screen, if you're sharing your motion with your client or whatever you're doing, you share that and that'll pop up in your screen share. But there's also an advanced tab. So click on advanced and there are a number of options that are available to you. And I'm going to talk about 2 of them. There is, just FYI, you can use a PowerPoint as your virtual background. So if you are a person who is super into green screens and you want to do this, say during a mediation or an arbitration, if you want to incorporate it into your presentation that way, play around with that and see what that does for you. This is how I've been playing on my videos, is this way. But what I'm going to talk about right now is sharing a portion of your screen And then I'm going to tell you how to share content from a second camera, which is very easy and is a great way to have a backup plan. All right, so this is not me screen sharing right now. This is a screenshot of when I tested screen sharing. So say I've got a picture like this. This is a pretty small picture. And I don't necessarily want my, arbitrator or jury to see all this garbage around here. I just want them to look at this part. When you share a portion of your screen, you can move this box so that it only fits around what you want to share. And so I will share my screen now with this picture and make sure I have it up. The one pitfall you need to know is it has to be pulled up because it will share a portion of whatever screen is behind Zoom. So see, there you go. Now that just shows you, that just shows you the portion of the screen that I want you to see. And then I can go up to this button called annotate, and I can write on the screen if I'd like to with a pen, or I can use text and I can type in whatever I want. And that will show up on my document. So really great way to interact with and highlight the portion of your evidence that you want the jury to see, or your finder of fact to see. Let me show you the annotate button. I don't know if that shows up honestly on your screen when I do the screen share, but that's where the annotate is, right at the top. And then now we're on to graphics. So, okay. So that's how you do the share a portion of your screen. Now, if you go back to that portion, that advanced tab, and click instead on share content from a second camera, that's what I'm going to do now. And I'll tell you right up front, I have under my video, I have 6 cameras. So when I click share content from a second camera, I don't think there's a possibility of setting a default second camera. So it's probably going to share, yep, it's going to share the wrong camera. There's an option at the top left-hand corner to switch cameras. And there we go. There is my bad roof. And now I have the option to use a document camera to show any hard copy exhibits that I didn't scan in advance. And I can, I can write and point and do all the things that I want to do. But let me tell you this, before you run out and buy yourself a document camera, if you don't have one, or if you have one, great. Play around with this and knock yourself out. It's going to be fun. If you don't have a document camera, don't run out and buy one. Here's what I want you to do instead. It's not required that you have a document camera per se to share content from a second camera. You can use any second camera you want. So for example, if you go out and buy yourself one of these webcams and get that gooseneck stand like I told you to, you can point this at your desk and you can put whatever papers you want to underneath it, and this can be your document camera. And let me tell you, there are 2 advantages of doing this as your document camera. One advantage is the frame rate is much better and the resolution is much better. It's just a better camera. And so it's gonna look better overall. The second thing though is now you have a backup camera. If your main camera goes out, now you have a backup that you can use as your webcam if you have some sort of technological glitch. And it's terrific if you have a bigger office where you've got, 12, 20 or more attorneys, just buy a couple and attach them to those stands. And then whoever's presenting that day can use it as their document camera or their backup camera. You don't need 2 cameras for every attorney. Just have a couple extra ones in the office and you're there. So now that you know how to interact with exhibits, I want to talk a little bit about the main difference, I think, between in-person proceedings versus online proceedings. Here's what we're used to. As trial lawyers, we're used to taking our audience and putting them in an actual wooden box and taking their screens out of their hands and making them watch us. And now we can't do that anymore, and we don't like that. And so we have to be interesting. And I don't know about you, but I didn't go to law school for that. Joking aside, though, I think the best analogy that can be made is to advertising, because when an ad pops up on your screen, you can't click that button fast enough to close that ad. If a commercial comes on TV, it's time to head to the fridge. We are actively trying to ignore advertisements. So my thought was, if we're trying to deal with this distraction and we're trying to capture attention in spite of distraction, who better to talk to than somebody who's in marketing and advertising? Thanks for helping me out, Nick.
Of course.
So can you give us some advice on how to capture attention in a distracted world?
Yeah, I mean, this is something I deal with on a daily basis. So I'm the director of marketing at Elysian Brewing Company here in Seattle. It's the largest craft brewery in the state of Washington. It's one of the top 12 largest craft breweries in the country. And on top of that, we're part of the Anheuser-Busch network. So my days typically are spent on the phone, on a Zoom call, presenting new products, new brand initiatives, new campaigns to the leadership that oversee what's called the Brewers Collective, which is a collective of 21 craft breweries owned by Anheuser-Busch across the country. These 21 craft breweries are constantly presenting their ideas to this group of people to basically get buy-in of the system. The work that I do and that my team does is kind of twofold. There's like a 1-2 punch, right? So we make beer, which you ingest and taste and fall in love with. So the beer has to taste good, but it's hard to convey that over the phone. The other side of it is visual, how our products look and the ideas behind those products and the packaging and the stories behind it. So what are some easy tips and tricks to go around doing that? One of the things that I've done in my career at Elysian is I've been really focused with my team on how our stuff looks. When our stuff is presented, especially over Zoom, when we're sharing our screen, typically it's some version of a PowerPoint deck, how do those slides look? How do they engage with the consumer? And instead of looking at an academic direction, which is tons of information, tons of bullet points, words, I, as a marketing person, look at advertising. What do ads look like that catch my attention? And my job as the presenter is to essentially add color commentary to the visuals that you're engaging with. If I can make the visual compelling enough and interesting enough and dynamic enough, like an advertisement, then no matter what is trying to pull on your attention, whether it's an additional screen that's in front of you or a text message coming over your phone or your kids yelling at you or whatever it is, this visual is going to grab you and you're going to want to pay attention to it. The second one that I try to do, and this is probably, I preach this to my team all the time, is pitch to your audience. Who's your audience? Know who my audience is. If I want them to believe in what I'm doing, I have to speak to them in their language, right? So there's one person on, this team of execs that I pitch to who is very, very analytical. So everything that I'm talking to him about, I can go in with like story and feeling and great visuals and all that kind of stuff, but I have to have a quantitative hook to get him in. The quantitative can't be the entirety of your presentation, but it has to be the bait on the end of the hook that you're fishing in the river with, right? Like, because I know that person's going to care about it. Now I know that this person over here is very consumer focused, and she wants to know what the consumers are seeing and feeling when they go into the grocery store to buy their product. The third one, when in doubt, leave it out. When in doubt, leave it out. Take all of the information that you want to sort of throw up on these slides, and you want it to be kind of this tidal wave of, oh, I got to get every fact in there because if I miss this one, then my whole thing will fall apart. That's not true. The visual should be the crux of what you're trying to convey, and let you as the presenter lead the audience down the path. Great ways to do that are with telling stories, with telling great anecdotes about what you're talking about, if the stories can be funny in some sort of way, if they can be relatable in some sort of way. You know, maybe, yeah, sure, you can talk like higher level marketing theory with this person, but you also want to talk about how it feels. So that is really big. You know, less information up front, dynamic visual, lead him or her or they along kind of the path with what you want to direct. Make sure that your information is resonant towards who you're speaking to. And then visuals matter. I mean, look, let's face it. We are all on devices all the time now. And everything is driven towards a visual mindset. Headlines capture attention more than the body of the article because headlines are quick, they're easily digestible. And so key your visuals that way and look for inspiration around you. You know, what do you like in your life, right? I'm a Nike freak. I love Nike ads. So what is Nike doing that's enticing me? Maybe you love Starbucks coffee. What do they do that brings you in? You know, you drive down the road, you notice a billboard. Why'd you notice it? Was it the font? Was it the colors? Stuff like that. You know, it got your attention. So what can you learn from that to maybe help gather attention in your life? The idea of infographics, you know, there's another book I got next to me that's an infographics book, right? That's all about how can you convey with images, because people can digest images quicker than they can digest words, right? But, you know, like Anthony Bourdain used to say, luck is not a business strategy. You've got to, you know, you got to really make these moves to make differences. And, you know, I think trying really hard to capture that attention is makes a big difference.
And graphics have now become essential in terms of communicating the facts that we want our audience to remember and helping them to understand it as well. So with that, I'm going to show you some ways that you can create some interesting graphics and do them in a way that's actually easy and free. So what I want to show you first is, this is an infographic. For those of you who don't know what an infographic is, we've all seen them before. Maybe you didn't know that's what it was called. And we've probably seen this specific infographic about now the average attention of a human is shorter than that of a goldfish. This is actually not true. It's been shared and shared and shared, and it looks, you know, it's very easily understood. It's very persuasively presented. It's memorable, but it's not actually true. I mean, all I can say is anecdotally, I can't stand having goldfish on my jury. They never pay attention, but there hasn't actually been a scientific study. But the infographic commands attention and it makes you believe it even though it's not true. Here's an infographic that I created. And this is the very first one I've ever done. And I will admit, it's not perfectly symmetrical and the color palette probably leaves a lot to be desired, but I did this for free in about 20 minutes. And think of the possibilities. That's what this is designed to do, is just get you to think of the possibilities. What if you took the top 5 or 6 facts in your case and you put them in an infographic and you present this in your opening and you use it during the cross-examination of the plaintiff, and you use it again during the cross-examination of the plaintiff's expert, and you use it again during your expert's direct examination, and you use it again during your closing. This isn't limited to online trials. This is something that you could use in a live trial, something you could use in an arbitration. This is something you could use in mediation. This can go a lot of places, and it was free and easy to create. And I'm going to show you how in just a minute. Here's something else, it's a timeline format, but same type of a thing. Really cool graphic, free, took me about 20 minutes. These are hypothetical. I mean, I never get cases with facts this great, but this is the top 5 facts in my hypothetical case. And I'm going to put this up there again and again and again. And I guarantee you, whoever my finder of fact is, whether it's a judge, whether it's an arbitrator, whether it's my jury, or whether it's a mediator who's trying to, you know, go between rooms, this is something that's going to command attention and be memorable. All right. So this is what can be done with professional graphics. Now, I did not do this, and I did not even know this was possible. And that's why I'm sharing it with you, so that you know it's possible. if you want to have a professional create graphics for you. This is the opening slide for my closing argument for my Zoom trial. And I mean, I just about jumped up and down when I saw this because it was just so cool. I couldn't believe it. So even 1 or 2 graphics like this in your case is going to make a huge difference. So even if you don't have a lot of budget, just a handful of these will make a big impact. Now, say you don't like any of this. You say, I'm not going to design graphics. I'm not going to hire somebody to design graphics. That is not my thing. Okay, use a trial board. This is a screenshot of my expert on Zoom using a trial board. And it showed up beautifully, absolutely beautifully. So if you understand that, you know, we need to rely more heavily on graphics now, but you don't want to use any of this tech garbage, mount this to a foam core board, set it behind you or set it behind your expert and use it. You don't need to use a computer program if you don't want to. But if you like this kind of thing, I have some advanced tricks I can show you. One, and I'm just going to go through this really fast, just so the point of this is not to teach you how to do all of these advanced things. I don't have that kind of time, but just to show you what's out there. This is the A10 Mini. This is what Matt Dobler was referring to. This is what I'm using today. And this is a very similar setup to what I'm using today. It functions as a webcam. So this thing works as a webcam. And you can plug into it as there's 4 plugins. They're HDMI sources, but there's 4 plugs, and you can do 4 cameras. You can do what I have is a laptop and 2 cameras. You can do whatever you want, and you can set it up so that you have different microphones if you want them, different camera angles. I have my second camera angle back here. The whole point was to show you my setup. But if I was in trial, I would set it up so I had one so I could sit and one so I could stand. Or if I was trying it with co-counsel, one for me and one for my co-counsel. There's a lot of ways you can set it up. You can do cool things with it. You can do the picture-in-picture thing that I've been doing. You can do the that banner at the bottom, which is called a lower third. There's actually a lot more you can do with it than I even know how to, but it's something that I can grow into, which is one of the reasons that I got it. Okay, but let's say you don't want to do that. Let's say you just maybe want a cool banner like this and do picture-in-picture every once in a while, but you're not going to spend a bunch of money or spend a lot of time learning it. I've got something for you. It's called OBS. It is a free online software, and it allows you to do both picture-in-picture and that lower third graphic that's on the screen right now, which I will take off. You can download plugins. Just you go to the website, download the software. It is not super user-friendly. So what I've done is in your materials, I have a link to a YouTube video by a guy called, his name is David Maldo. He uses it for very creative purposes, like putting kittens in the bottom of his screen, but he'll show you the basics and walk you through it in a way where you'll get it the first time. He doesn't talk over your head. It makes it very, very easy to use. The thing that I started out with in the beginning, when I did that overlay, the graphic overlay on my screen and showed you the 3 things that will blow your mind, which you know, may or may not have actually blown your mind. I used Prezi. It's Prezi.com, 100% free. You can use it. You have to use it as your webcam, which is why I had to switch cameras after I used it. But you can stay in Prezi the whole time if you want. It's just that your screen's going to be reversed. So then if I tried to do this, everything would be backwards. So just know that when you screen share. These are the pre-made video designs. You don't have to create any of these things yourself. They have pre-made templates. All you do is fill in the text. So it's as easy as that. And these are the infographics. And I mean, there are many more than what I'm showing you on the screen, but this is how I did the infographic. You can change all the colors, the icons, the text, everything. They make it really easy. Even easier than that is Canva, which is also 100% free. And that's how I've done some of these animated PowerPoint slides, like, you know, the lighting one where it shows the light bulb and the text flies in. It looks a little bit cooler than what PowerPoint has. And so I like to do those in Canva. takes a few minutes a slide. They have all sorts of templates that you can use. It's very, very user-friendly. The timeline I used was from Microsoft, and there's links to all this stuff in your materials, but there's a link to the website to download these templates from Microsoft so that you can use them with PowerPoint. All you have to do is change the date or the icon or the color, or whatever you want, and personalize it. Super easy to use. Finally, here's a treat for those of you who have a document camera. My document camera is made by Ipevo, I think I'm saying that right. And they have a software that's called Visualizer, and it's free. And so if you already have a document camera, just look on the document camera, find out what the manufacturer is, go to their website, and I bet you they've got a free software that allows you to do stuff like picture-in-picture or other cool tricks that you can do on Zoom. And you've already got the document camera, you might as well learn how to use that kind of stuff. Now, I probably totally overwhelmed everybody, and you're probably wondering, now what? Where do I go from here? And how do I keep on top of all this stuff? And so what I'm going to tell you is the first thing that you need to do is go back to Zoom and learn all of the advanced screen share features. That will make your life so much easier. Once you're done with that, think about upgrading your camera and your lighting. And then, if you want to look at microphones or look at, Canva or some of these other things, add those on then. But the important